Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we have a new trial out of Florida. Florida versus Lawrence Dority. Excuse me. Florida versus Lawrence Dority. So before we get started, this actually started yesterday, day one, and we are into day two. So I'm hoping we can fast forward through the breaks of day one and catch them towards the end of day two. And don't worry, Washington versus Ali, we're still covering that. We're going to dual stream. That's in Verdict Watch. That starts at noon, East Coast time. So we will cover that. But in the meantime, we want to pick up on a new trial. So Psychosaurus Rex first in the chat saying, go green. Fur Baby's mom, good morning to you. Alice Howell, hello to you. Green-Eyed Cat, thank you for joining us. Red Snap and Selena K. Aussie Gardner and Widespread Panic and Brat are in the house. Thank you guys for joining us. Scent Bunny, no verdict yesterday. I'm assuming I fell asleep waiting. That is true. Mama C, good to see you. And Kelsey, thank you for joining us. Alice Howell, always good to see you. Com TN Girl, is that Com Tennessee? Is that TN short for Tennessee? Betsy Nerdette Connor, good morning to you. Thank you for joining us. Will Johnson and Tash. Awesome, you guys. Thank you so much for joining us. Yes, check out our description. If you guys have any kind of questions, go ahead and check out our description. I'm going to play some news before we get started, as always. And here's our cast of characters, our players, if you will. So Lawrence Dority on the upper right there, he is the defendant. He's 34 years old. Adreian Payne is the victim. He's 31. I forgot to add victim. So he is the victim. He played for Michigan State University, MSU Spartans. So let me read our description here. Adreian Payne was a former NBA player and standout Michigan State University basketball star, known for his athleticism and close friendship with young cancer patient Lacey Holsworth. He played in the NBA for teams including the Atlanta Hawks and Orlando Magic, and later he played internationally. So this happened in Orlando, right? So you can imagine he probably has a lot of friends still in the area. I don't know where he's originally from, if he's from Michigan or Ohio or Illinois, somewhere up there. I don't know that. I'll have to do some more research on that. But he did play for Orlando, and this took place in Orlando. So on the morning of May 9th, 2022, he was shot, and he was unfortunately deleted outside the Orlando home of Lawrence Dority. Now, according to police reports and witness reports, Payne had been called by a woman, believed to be Dority's girlfriend or close associate, to help mediate a domestic dispute. The two women were friends, and Payne came with his girlfriend to try and calm the situation. Dority told detectives he arrived at the complex with his father and young son and found Payne waiting for him outside. He claimed Payne threatened to smoke him, which led Dority to go inside, retrieve a gun, and return. Dority said he fired when he saw Payne reach toward his waistband, believing he was in danger. Payne, unfortunately, was struck by that gunfire. He was rushed to the hospital, and he was later pronounced dead from his injuries. Dority was arrested at the scene. Originally, he was charged with first degree, but then, if you read our description, he entered a plea. So at the scene, he was originally charged with first degree. He reportedly claimed self-defense, saying he feared for his life, and Payne did not have a weapon. But then Dority entered a plea of not guilty, and he invoked Florida's stand your ground law. So he was denied that in pretrial motions, with Judge Tynan ruling the case will proceed under second-degree charges. Now, if Lawrence is convicted, if Dority is convicted, he will face life in prison, and the DP does not come into play for second degree. I believe he's still in jail. Yeah, he's currently being held without bond. So he is in jail, and he's being held without bond. So that's our background. CJ says, how are you? And Willow Johnson, user 718 #9. Good to see you. Thank you for joining us. So let's get to some news, and then we can dive into the trial.
This morning, a man accused of murdering a former Orlando Magic player goes on trial. That shooting happened 3 years ago in East Orlando and left Adreian Payne dead.
This morning, West 2's Bob Hazen live at the Orange County Courthouse. Bob, the shooter is claiming self-defense.
Yeah, and he tried to get a judge to agree that he was standing his ground, but that was denied. So today, Lawrence Dority will be going on trial at the Orange County Courthouse. Now, Dority is facing a second-degree murder charge for that shooting from May 2022. It killed Adreian Payne, who briefly played for the Orlando Magic back in 2017. He was a well-known star as well at Michigan State. The shooting happened at a townhouse complex off Curry Ford Road. Investigators say Dority lived there. The arrest report says Payne and his girlfriend went to that complex, possibly at the request of Dority's girlfriend, to serve as mediators and prevent any kind of domestic violence between the two. But Dority told detectives that he felt threatened. He had just gotten home with his young son and father, and he didn't know why Payne was there confronting him. He also claimed that Payne said he was going to, quote, smoke him, so Dority went into his own home and got a gun. He said when he saw Payne reach toward his waistband, he thought that Payne was going to pull out a gun, so he shot and killed him. Again, Dority claimed self-defense and immunity from prosecution. The judge, though, rejected that argument. Now Dority will have to make his case in front of a jury, with that trial starting up this morning. It's expected to last 4 days. Covering Orange County, live in Orlando, Bob Hazen, West 2 News.
All right, so fun fact, I met Bob when I was down at Sarah Boone. He's a really nice guy. And it's nice when you see these people that you meet at another trial, you know, continuing on and doing other coverage. So, Jen, yeah, if you live in Orlando, now they're into day 2, so it'd be either today or tomorrow, because they may be in a verdict watch. Who knows? They're already into day 2, and I think the defense anyway. Yeah, it would have to be. This is a quick trial. It's whatever's happening there. It's a quick trial. All right, so let's get into the trial here. All right, so keep in mind, this is from yesterday. Now, the audio is a little wonky, especially at the beginning. There's a lot of background hum, probably from the air conditioners. Sometimes the lights happen. You know, sometimes when lines get close to AC, they create hum, or it could be the AC. When audio cords get close to electric cords, sometimes they cause hum. It could be the background AC. So just be aware that there is going to be some hum. I did my best to try to minimize it. So hopefully you guys will be okay with the background. It could get annoying at times, especially at the very beginning. The prosecutor is away from the mic for about 5 minutes or so, maybe less. So it's really hard to hear him. But just bear with it. The audio does get better, at least from a volume standpoint. And then there's also, again, there's going to be some background hum. So just bear with it. And if you can deal with it, awesome. And I understand if you can. If you need to leave, that's fine as well. So, all right, here we go. New trial.
Good morning, ladies and gentlemen. Welcome back. I trust that you all complied with the instructions I gave you yesterday. You did not do any research, looking up of any names, maps, or doing any investigation of your own reference to this case. Is that correct? All right. When we stopped yesterday, we had done the jury selection, and I had given you the preliminary instructions. So we're now going to start with the opening statements of the attorneys and then start moving into the witnesses' testimony. So at this time, the attorneys for the parties will have the opportunity to make their opening statements in which they may explain to you the issues in the case and give you a summary of the facts that they expect that the evidence will show. State wish to give its opening statement at this time?
Yes, Your Honor.
You may do so.
Thank you, Your Honor. Please report. On May 9th of 2022, this defendant shot and killed Adreian Payne. And you're going to hear the evidence in this case, and it's going to show that this defendant was not acting in self-defense. He was not standing his ground. He arrived back to his house at about 1:30 a.m., and he saw the victim's vehicle, which he recognized, parked a few houses down from his residence, parked on the street. He approached the vehicle. They had a brief word, and then the defendant goes back inside his house. The victim doesn't follow. He never leaves the area of his vehicle, which is parked on the street. But the defendant goes to his house. He locates his firearm. He arms himself with that firearm, and he comes back out. Now, mind you, you're going to hear from the evidence in this case that the victim was not armed. He did not have a firearm. He didn't have any weapons. You're going to see there was a photograph of a kitchen knife on the passenger floorboard, but there was nothing that he used or threatened in this circumstance. He was not armed. He was parked at least 10 yards away from the yard of the defendant. The defendant arms himself in his home, comes back outside his home, finds the victim still by his car. He takes that firearm out. He points it, he takes deadly aim, and he shoots and kills the victim in this case. That's the fact that you're going to hear in this case. So, you're going to hear through the witnesses and evidence in this case that the defendant was driven home that night about 1:30 a.m. by his father. He had been in an argument with his girlfriend, Tatiana Mesa, and they were at a family party at the defendant's father's house. You're going to hear that Tatiana Mesa, the defendant's girlfriend, called her best friend, Tara Walker, who is the victim's girlfriend, and asked if she could come over to the residence. Tara Walker speaks with her boyfriend, the victim in this case, and he decides to come to the residence or the area of the residence as well as backup. They all get there. I guess the defendant arrives before Tara Walker, but she arrives shortly after, and the victim is already in his vehicle, parked on the street when he arrives. So the defendant had previously known the vehicle, as you're going to hear in the evidence, and he goes up and exchanges words. He's upset. You're going to hear from Tara Walker that the defendant appeared to be intoxicated at the time. Again, he didn't drive himself to his home. His father had driven him to his house that night. There's words exchanged, but that's not the point that the shooting happens. He takes the time, he goes inside, and he arms himself with the firearm. Now, you're going to hear from the medical examiner in this case, Dr. Marie Hansen, and she's going to tell you that the cause of death was the gunshot wound that went through the arm and the torso in this case, and that the manner of death was determined to be homicide. You're going to hear from several witnesses in the case, the primary one being Tara Walker, who was present and witnessed the shooting. And she's going to let you know, as I said, that the defendant appeared to be intoxicated, that he was upset, that he was belligerent. And I expect that you're also going to see some surveillance footage in this case. Now, the surveillance doesn't capture the incident itself, but there's a camera that's near a neighbor's camera that you can hear the shooting itself on the surveillance footage, and you can see the aftermath. And on that footage, you're going to be able to hear Tara Walker pleading with this defendant. Don't take your gun out. Don't take your gun out. We were called here. Don't take your gun out. You're going to see the defendant doesn't listen. He takes his gun out, he takes aim, and all in this moment he shoots the victim and kills him. Now, after that, you're going to see Tara Walker run to the area where the surveillance camera is located, and you're going to see the defendant's son, Adreian Dority, is running with her, and then ultimately the defendant comes out and calls his son into the house. Now, you're going to hear from Tara Walker, and she's going to tell you the victim didn't have a weapon, that he didn't threaten a weapon. The evidence in this case will be clear. This is not a case of self-defense. This is not a case of someone standing their ground. As was discussed in jury selection, in a self-defense or stand your ground situation, the facts matter. And the facts in this case are not someone defending themselves. They're someone being the aggressor, taking aggressive action, arming themselves, and committing a murder. And once you've heard the evidence in this case, we'll ask that you convict. Thank you.
Mr. Thompson, does the defense wish to give an opening?
Yes, Your Honor. May it please the court?
You may.
Good morning again, ladies and gentlemen. How you doing today? Again, we just get right into this. This is not a complicated case. This is a very simple case. Okay? This is a case about self-defense. And not just self-defense of oneself, but we're talking about self-defense of one's family. Okay? Please pay close attention to the facts in this case. Every fact is very important. May 9th, 2022, Lawrence Dority was celebrating Mother's Day with his family at his father's house, not very far from where this incident occurred. Okay? When he decided to leave, his father drives him home. Okay? Mr. Larry Dority is the driver, Lawrence Dority is a passenger, and his 10-year-old son is a passenger in the back seat compartment of his truck. Unknown to him, unexpected, as he arrives home, he observes a black Chevy, blacked out tinted window Chevy Malibu parked outside his car. The lights, headlights on, car running. Okay? Out of concern, he starts to walk over to the car, and he starts to realize this car looks familiar to him. He believes it's the car of his long-term friend, lady friend, Tara Walker. This is the car she has been very months. It must be 6 months at a time. Mr. Dority didn't know that was her car. He didn't know there was a boy in the car. He walks up, and then the tinted window rolls down. One can't see inside his car. It's 1:30 in the morning. Dark out. Window rolls down. Mr. Dority asks, "Why are you here?" You want to know what happens next? Evidence will show that a 6'8", at least 6'8", according to the medical examiner, he's 80 inches tall. Just like 6'8", now she's tall. Steps out of the car. Wingspan of 7 foot. With a threatening posture. Steps out. I was smoking. What you want to do? What you want to do? Mr. Dority immediately retreats into his home. Gets his firearm. Evidence will show that he's a concealed weapon permit holder. Evidence will show he didn't go look for trouble. Trouble came with him. Right? His son is outside. He can't even make it into the house stage. He walks back out. But before that, he's still asking, "Why are you here?" You need to leave. Guess what happened next, ladies and gentlemen? As Mr. Dority, after being threatened, walks into his home. He comes back out, and instead of Mr. Payne, the first one is Mr. Payne. His name is Adreian Payne. Mr. Dority didn't know that. He only knew that somebody named Adreian. He didn't know him personally. He didn't know him at all. Right? As he comes back out, not only did Mr. Payne not leave, but he pulls the car a little closer to this. So he had the opportunity to leave. And the evidence would show that his girlfriend, Tara Walker, actually told him to leave. She had arrived at the tail end of the verbal altercation. Evidence would show she wasn't even present when Mr. Dority approached to ask him to see who he were. You heard testimony that she's going to say she's on the phone. She would admit to you that she told him not to come to the house. He did it anyway. The evidence would show he didn't even know where Mr. Dority lived. He circled around the neighborhood to find, he found Mr. Dority's car. He was familiar with it and say to them for whatever reason. Right? Mr. Dority comes back out and asks him to leave again. Not just that, why are you here? Simultaneously, as Mr. Payne is reaching, Mr. Dority fires one shot, not to kill, but to repel the threat. The evidence would show that bullet was pierced through the bicep into his chest cavity. Only then he got back in the car. He was still standing outside the car. Okay? What did Mr. Dority do next? He didn't flee. He immediately got his son, told him to get in the house, called law enforcement, reported to them what happened. Okay? He cooperated with the investigation. This is a case about self-defense. This is a case about defense of others. This case is very simple. The evidence would show that neither Mr. Lawrence Dority or Mr. Dority's fiance at the time invited Mr. Payne over. No one invited him over. The evidence would show that Mr. Payne's girlfriend advised him not to go, not to come. The evidence would show that the crime scene wasn't really secure. It was contaminated before law enforcement arrived. The state conceded in its opening to submit that there was a weapon in the car. The evidence would show that that weapon, that knife, was not tested for DNA. Fingerprints was not even taken in evidence. The evidence would show that Ms. Mary Walker had access to that vehicle before law enforcement arrived. You would hear evidence that no firearm was located. But there is a reasonable explanation for that. Okay? Evidence would show that. The evidence revealed the inconsistency in the state's evidence in this case. It's abundance of it. The evidence revealed lack of evidence in this case. This is a clear case of self-defense. After you've heard and seen all the evidence, we ask that you find Mr. Dority not guilty. It's the right thing to do under these circumstances. This is not a case of a gunman on the loose, shooting bystanders and innocent people. This is a man that was on his way home, minding his business. Okay? This is not complicated. This is a case about a man who was forced to defend himself, his child, and his father against a much larger, aggressive man who showed up armed and threatening him at his home in the dead of the night, 1:30 in the morning. He didn't come singing a Christmas carol. He didn't come with any sense of kindness or respect. He came with intent to intimidate and threaten. And that's what he did. Evidence would show that Mr. Dority did what any reasonable person would do in that situation. Ask, Mr. Payne, why are you here? Mr. Dority asked Mr. Payne to leave. Did he leave? No. But more importantly, why was he there? How did you even know how to get to the house? Mr. Dority was threatened by him. He immediately went in his home and protected himself and his family. Mr. Payne postured himself in a threatening manner while outside of Mr. Dority's home at 1:30 in the morning. This is a case about self-defense. This is the case that the people of the state of Florida should recognize. This is not acceptable. He's innocent. This action of justice. You heard everything we prayed humbly and asked that you find out. That is what justice is.
State, call your first witness.
Your Honor, at this time, we would move to offer into evidence what's been marked for identification as States E, the stipulation of the parties, and ask that be published.
Any objection from this defense?
No, Your Honor.
All right, what's been marked as States Exhibit E for identification will be received into evidence as States 1 without objection.
And Your Honor, if you could publish the...
All right, ladies and gentlemen, what is in evidence now as States Exhibit 1 is a stipulation of the victim's identification. It indicates that the Assistant State Attorney, Michael Joseph Smith, and the defendant, Lawrence Alexander Dority, as well as his lawyer, Harold Dion Thompson, stipulate that the identity of the deceased in this case is Adreian D'Angelo Payne, and it is signed by all three parties. Okay? So that is a stipulated fact that you all can consider. All right, State.
Thank you, Your Honor. At this time, the State calls Garrett Morris.
You solemnly swear or affirm testimony shall give, shall be the truth, and whole truth, and nothing but the truth, so help you God.
All right, go ahead and have a seat for me once you get situated. And state your full name for me and spell your first and last name for the court reporter.
Garrett Morris, Garrett Morris.
State you make, right?
Thank you, Your Honor. Good morning.
Hi, good morning.
If you could just introduce yourself to the jury.
Yes, my name is Corporal Garrett Morris. I'm with Orange County Sheriff's Office.
And how long have you been with the Orange County Sheriff's Office?
For 5 years, and total time in law enforcement, almost 13.
Where did you work in law enforcement before the Orange County Sheriff's Office?
Volusia County Sheriff's Office.
And what is your current job duty?
Currently, I'm a patrol supervisor in our Sector 3, west side of the county.
And what shift are you on?
Midnight shift.
Okay. Did you work last night?
I did.
Okay, so have you just come straight through from that?
Yes, I did.
I want to take you back to May 9th of 2022. Were you working at that time?
Yes, I was.
What was your position then?
At that time, I was a patrol deputy in Sector 2, which is the east side of the county. And I was on midnights as well then.
And did you have occasion on that day around 1:30 a.m. to respond to 2529 Beaver Shores Drive in Orlando?
Yes, I did.
And when you responded to the scene, were you able to locate a victim on scene?
Yes, I did.
Where was he located?
So the victim, when I located him, he was in the driver's seat of I believe, a silver vehicle, and he was with his left foot outside of the vehicle and his right foot inside the vehicle.
Okay. Did he appear to be injured?
Yes, he had a gunshot wound to his chest, and he was unresponsive.
Was anyone else near the victim when you arrived?
Yes, the defendant's father was near the victim, and so was the victim's girlfriend.
And what happened from there once you arrived, located the victim, and realized he had a gunshot wound? What did you do?
At that point, I put on my gloves and I got him out of the vehicle. The defendant's father assisted a little bit, and then I started CPR.
And you started CPR once he was out of the vehicle on the ground?
Yes, I pulled him out of the vehicle into a flat, hard surface, and that's when I began CPR.
Now, as part of anytime you're going to perform CPR and walking into an unusual situation, is it part of your protocol to check for weapons?
Generally speaking, yes. Whenever, if I were to respond to a call where maybe there was somebody who was maybe just overdosed or something like a natural causes, I may not always check for weapons, but whenever in this case it was obvious that he had been shot, I check for weapons on whoever I'm in contact with, and in that case it was the victim.
And did you locate any weapons on or about the victim's person?
No, I did not.
Now, at some point, did fire rescue arrive and take over, I guess, the CPR and life-saving measures from law enforcement?
Yes.
And what happened from there as far as your involvement?
After that, I just assisted in maintaining the crime scene. I put up crime scene tape and held that area around the car until our homicide and forensic units could get there.
Now, during this encounter that you've just described, were you equipped with body-worn camera?
Yes, I was.
And was that activated?
Yes, it was.
Have you had a chance to review that body-worn camera prior to today?
I have.
First, I want to show you what's been marked for identification as states composite D. It's 3 photos, or still photos from your body-worn camera. Let the record reflect I'm showing opposing counsel with the mark for identification as states D. Permission to approach?
You may.
Let the record reflect I'm showing the witness what's been marked for identification as states D. If you could just look through these and let me know if you recognize them.
Yes, I do recognize them.
Are these still images from your body-worn camera?
Yes, they are.
Are they a fair and accurate depiction of what was captured by your body-worn camera?
Yes, sir.
At this time, the state offers into evidence what's been previously marked for identification as states composite.
Any objections?
No objection, Your Honor.
It's been marked as States Exhibit D for identification. Without objection, will proceed into evidence as States 2.
Commissioner Public once more.
You may.
States Exhibit 2. All right, what are we looking at here?
That's the victim on the ground with a gunshot wound to his chest. I don't know at which point that was during the CPR, but that was those gloves are me checking his fanny pack for any weapons.
I know you have a screen in front of you. Are you able to look sort of behind and see the screen behind you? Is that the gunshot wound that you observed?
Yes.
And then this here, is this a fanny pack that he's wearing?
Yes, it was.
And you went inside of that fanny pack?
I did.
And did you locate any weapons or anything of that nature?
No, I did not.
And then I know it's a little bit blurry, but what are we looking at here in this still image?
That's the victim as I first found and observed him in his car.
Would this be like his leg here?
Yes.
This is inside the driver's compartment.
Yes, that's him sitting in the driver's seat, and I believe his left leg was out of the vehicle, and he was slumped backwards, unresponsive.
finally, this still image, dark on the screen. It's in evidence. I don't know if you can actually see it here, but again, just to orient, this here area is the driver's seat.
I can see the steering wheel and the victim's shirt.
And there's another individual, this picture here, you can see it, they're actually holding the photograph. Is that the person that you understood to be the victim's girlfriend?
The female that was there was the victim's girlfriend.
You guys also had an opportunity to review a clip of your body-worn camera from responding to this incident?
Yes, I have.
Let the record reflect I'm showing the opposing counsel has been marked for identification as states C. Permission to approach?
You may.
Let the record reflect I'm showing the witness has been marked for identification as state C. Please take a look at that. Do you recommend it?
Yes, I do.
Is that a disc of your body-worn camera that we reviewed together back in June?
Yes.
Is it fair and accurate?
Yes.
At this time, the state offers the evidence will contribute to mark for identification as state C.
Any objections?
No objection, Your Honor.
What's been marked as State's Exhibit C for identification will be received into evidence as States 3 without objection.
Your Honor, permission to publish once marked?
You may.
Now publishing State's Exhibit 3.
Oh, Jesus. Where's the ambulance officer?
All right, back up.
Yes, sir.
Back up.
Oh, Lord, have mercy.
County 125.
Oh, Lord, have mercy. Oh, Lord.
Black male, GSW to the chest, unresponsive, no pulse. I'm going to try to get him out of the car and start CPR.
Yes, ma'am.
Here, come on.
No, man.
Here, grab his legs. Let me get him out. You got him? Yep. Come on, pull him.
He's not breathing no more. He was talking to us.
Okay. All right, I got his head. Just pull him. Pull him away from the car. All right, there we go. Give me light.
I got you. You guys gonna be able to save him?
So we're gonna try and do, remember. Right now, I just need to stand over on the side of the box, alright?
No, I'm sorry, it's quiet.
Yeah. Yeah, it's open.
What do you need?
Wow. Got nothing. There's no guns.
Oh my God! Oh my God! Oh my God! Oh my God! Oh my God!
That's empty coming in.
And that concludes State's Exhibit 3. Corporal, did all the events we've just discussed, including your response, occur in Orange County, Florida?
Yes, it did.
I don't have any further questions.
Ross?
Good morning, sir. How are you doing today?
Good morning, sir. Good, thank you.
I'll just try to piggyback briefly off what you just testified to.
Mhm.
Isn't it true you did not search the vehicle for weapons?
Yes, sir, it is. I did not search the vehicle.
And you just saw the video yourself, obviously. Isn't it true the right side passenger door was open?
I believe the girlfriend was standing at the right side passenger door, yes.
So it's fair to say, well, you didn't open the right side passenger door, right?
I didn't go to the right side passenger.
So that's, as far as you believe it was Mr. Payne's girlfriend who opened that door?
Objection calls for speculation.
Sustained.
You have no idea who opened that passenger side door and opened that door?
I do not know who opened that door.
All you know is by the time you arrived, that passenger side door was open, correct?
Correct.
Okay. And Mr. Payne was seated in the driver's side, correct?
Correct.
And there was no other person inside that vehicle at that time, correct?
Correct.
And you didn't search that vehicle, correct?
Correct.
You didn't search Tara Walker's, the victim's girlfriend's car either, did you?
No, sir, I did not.
I have no further questions.
Any redirect?
No, Your Honor.
May the witness be excused?
Yes, Your Honor.
All right, thank you, sir. You can step down. Thank you, sir. All right, State, next witness.
Yes, Your Honor. At this time, the State calls Hannah Miner.
What's the last name?
Miner.
You solemnly swear, affirm, testimony shall give, shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, go ahead and have that seat for me. And then state your full name and spell your first and last name for the court reporter, please.
Hannah Miner, HANNAHMINER.
All right, state you may inquire.
Thank you, Your Honor. Good morning.
Good morning.
If you could just introduce yourself to the jury.
My name is Hannah Miner. I'm a crime scene investigator with the Orange County Sheriff's Office.
And how long have you been a crime scene investigator with the Orange County Sheriff's Office?
Since January of 2022.
And if you could just give the jury a little bit of your background as far as training experience that enables you to hold that position.
I have a bachelor's degree in forensic science from the University of Central Florida. I also have a master's in pharmacy with a concentration in forensic science from the University of Florida, and I'm currently working on a doctorate in forensic science from Oklahoma State University. In addition to that, I am a certified crime scene analyst with the International Association for Identification.
What is the role, if you could just explain to the jury, what is the role of a crime scene investigator?
We are notified to respond out to crime scenes. We document those crime scenes with photos, notes, sometimes measurements. We'll document evidence, collect evidence, process that evidence, package that evidence, forward the evidence to its final location, whether that's a laboratory or our evidence unit, and then we will write reports on our involvement for those cases.
And do you work in conjunction with law enforcement, like detectives and things like that?
Yes, we do.
So I want to take you back to May 9th of 2022. Were you working in your capacity as a crime scene investigator at that time?
I was the on-call crime scene investigator, yes.
So it might seem self-explanatory, but if you could just sort of describe, what does it mean to be the on-call crime scene investigator?
Our office is staffed until midnight, so any calls that come in after midnight, it goes to the on-call crime scene investigator, where they will take calls from home.
And were you directed as part of your job as the on-call CSI to respond to a location at 2529 Egret Shores Drive in Orlando?
Yes, I was.
And was part of your job to document that scene?
Yes, it was.
What time, if you recall, was it that you responded to that scene?
I arrived on scene at approximately 5 o'clock that morning.
Was it still dark outside, or had it begun to be light yet?
It was still dark outside.
Were you able to take some photos outside that scene before, I guess, the sun ultimately came up?
Yes.
And Your Honor, I've previously shown opposing counsel what's the mark for identification as states composite H. That's going to be photos. Permission to approach?
Yep.
Let the record reflect I'm showing the witness what's been marked for identification as states H composite of 6 photos. Could you take a look at that?
Yes.
And are these photos that you yourself took as part of your duties on the night?
Yes.
Are they clear and accurate?
Yes.
At this time, the state offers the evidence of the previously marked for identification as states H.
Any objections?
No objection.
It's been marked as States Exhibit H for identification. Will be received into evidence as States 4 without objection.
And Your Honor, permission to publish once marked.
Okay.
Now publishing with narrative of State Exhibit 4. What are we looking at in this photo?
That's the front door of the residence.
When you say the residence, is that what you understood to be the defendant's residence?
That is correct.
And then this photo?
It's essentially the same photo, just zoomed out a little bit to show more of the surrounding area.
And are you documenting a white truck in this photo?
Yes.
Here's the stop sign. Can you see, I know you have the screen in front of you, but here's I'm circling with the laser pointer. This is documenting the location of the intersection of the area where this happened.
Yes. Yes.
And where is this in location to the defendant's residence? We just saw the photos.
If you were standing facing the residence, this is to the left.
I know it's dark. Obviously, you took some photos of the daylight as well, right?
That is correct.
It's dark in this photo, but what are we looking at here?
That is the victim's car.
And this is another dark photo of the victim's car.
That is correct.
Now, after the sun did come up that morning, did you document the scene with some daylight photos, sort of capturing different items' location to each other?
Yes, I did.
Let the record reflect, I've previously shown opposing counsel what's been marked for identification as state's composite I-14 photographs. Permission to approach the witness?
You may.
Let the record reflect, I'm showing the witness what's been marked for identification as state's composite I-14 photographs. If we just flip through these and let me have it. And these all photographs that you took during the daylight on May 9th of 2022?
Yes.
Are they fair and accurate?
Yes.
At this time, the state offers the evidence of the previously marked for identification of state's composite I.
Any objections?
No objection, Your Honor.
It's been marked as State's Exhibit I for identification. Received into evidence as State's 5 without objection.
Permission to publish once more?
You may.
So what are we looking at in this photo?
That is the white vehicle that was parked in front of the residence.
When you say the residence, you mean the residence you understood as the defendant's residence?
That is correct.
And as we're looking forward in this photograph, what's depicted? Is this a stop sign that you've seen the earlier photo at night of?
Yes.
And then this vehicle, is that the victim's vehicle?
Yes.
So it would be off screen in this photo, but like if we were to go over into this area, would that be essentially where the defendant's door would be located?
Yes.
So this would be sort of a perspective if you're standing in the defendant's door.
Objection as to leading.
Sustained.
What would this be a perspective of where you're standing?
Could you clarify the question?
Right, so where were you standing when you took this photo?
On the right side or the driver's side of the vehicle.
And did this capture the distance between the defendant's
Objection, Your Honor. Leading, best evidence rule. May we approach?
No? Overruled.
Does this capture the distance between the defendant's residence and the victim's vehicle?
It documents it, yes.
What are we looking at here?
That's the passenger side of the victim's vehicle. Correct.
Was the door open when you arrived, or did you open the door?
Can I refer to my report?
Sure.
The front passenger door was open.
And now we're looking at, is this the back passenger door?
The rear passenger, yes.
Now, did you open this door for this photograph?
Yes.
What are we looking at here?
The front quarter panel of the victim's vehicle.
And then this is a different view of sort of directly into the driver's side of the vehicle.
Yes.
Now, this residence back here, this is not the residence that you mentioned to be. Correct.
That is correct.
And then is this just another photograph with both the front doors open?
That is correct.
What were you documenting with this photo?
That's the driver's seat. There are some red stains on the piece of paper that's on the floorboard.
When you say the red stain, is that if you look at the screen behind you, is that what I'm circling with my laser pointer?
That is correct.
And what are we looking depicted here?
That's the cup holder area of the victim's vehicle. There's additional red staining near the shifter.
This area here that I'm indicating with the laser pointer.
That is correct.
Which is a closer view of that.
That is correct.
And then what are we looking at here?
That's the passenger side of the victim's vehicle.
And then what's depicted in this photo?
That was a knife that was on the floorboard, kind of near the end of the seat.
And what seat was that?
The passenger seat, the front passenger seat.
And what are we looking at here?
Another overall of the scene of the front of the residence and the two vehicles in the daylight.
So the front of the residence, you could look at this screen here. If you could just take the laser pointer, could you point out where your understanding of where the defendant's residence was? And then if you could point out with the laser pointer the location of the victim. Now, in this photograph, is this here on the bottom left of that victim's vehicle?
Yes, it is.
And so then if you could take a laser pointer and as best you can point out the location of the victim's residence.
This is the white car that was in front of the residence.
Would it be the other side, far side of the white car?
That is correct.
And then again, this shows the white car from the previous photo.
That is correct.
And then on the right side of the photo is that the door to the residence.
Yes.
Did you actually enter the defendant's residence and document the interior of that location as well?
I did.
And let the record reflect, I've previously shown opposing counsel what's been marked for identification as states composite J. Permission to approach the witness?
You may.
Let the record reflect, I'm showing the witness what's been marked for identification as states composite J. So you could just flip through those and let me know if you're done. Photographs that you took entering or inside of which defendant's residence?
Yes.
Are they very accurate?
Yes.
At this time, the state offered in the evidence was the previously marked for identification as states composite J.
Any objections? No objection, Your Honor. It's been marked as State's Exhibit J for identification without objection will be received into evidence as State 6.
Commissioner Public once more.
You may.
What are we looking at in this photo?
That's the entryway to the residence.
And then in this photo, have you stepped inside the residence?
Yes.
In this photo, or are you just a little bit, I guess, further inside the residence?
Yes.
What are we looking at here?
Another photo photographing the entryway, so the way I had just come through the residence from the sliding glass door from the previous photo.
So this would be you come in, and then you turn around, and I guess the photo looking back that way, is that correct?
That is correct.
What are we looking at here?
It's another overall photo, just panning from that same location back toward where I just walked through the residence.
Now, in your documentation of the residence, was a firearm located?
Yes.
What are we looking at here?
It's a photo of the kitchen area where the firearm was located inside of that drawer that's open in the photo.
Okay, you could just take the laser pointer and point through the drawer that you're referring to. And then is this photograph just looking at the drawer inside showing the firearm?
That is correct.
And then what is depicted here?
That is the firearm once I rendered it safe and placed it in a firearm box.
What does it mean to render a firearm safe?
In the original photo, the slide was forward, so there's no way for me to know if the firearm was loaded or not. So in order to render it safe, I take the magazine out, which is the item on the right, and then lock the slide back to make sure that the chamber is empty so that it's safe to handle.
Is it fair to say previous to this photo, the magazine was inside the firearm?
That is correct.
Now, that firearm that we just saw the photographs of, was it ultimately collected and placed into evidence?
Yes, it was.
For the record reflect, I'm showing opposing counsel what's been marked for identification as State B. B. Permission to approach the witness.
Go ahead.
Let the record reflect, I'm showing the witness what's been marked for identification as State B. If you could just take a look at this and let me know if you recognize that as a firearm that you collected from it.
Yes, it is.
And that was placed in evidence by you.
Yes, it was.
At this time, the state offers in evidence what's been previously marked for identification as State B.
Any objections?
No objection, Your Honor.
It's been marked as states for identification without objection. Will be received into evidence as State 7.
Your Honor, permission to have the witness get off the stand and publish for the jury.
You may.
Then I can step off the stand and have you. Later in the course of your duties as a CSI in this case, were you tasked with collecting from the medical examiner a projectile or bullet recovered from the victim in this case?
Yes.
Let the record reflect I'm showing opposing counsel what's been marked for identification as States A. Thank you. Permission to approach.
You may.
Let me know if you can tell who's marking it or if you need to open it. I'm showing the witness what's been marked for identification as States A. Do you recognize this?
Yes.
And how do you recognize it?
The label has the case number, the location collected, a description that says sealed container labeled bullet from right abdomen. It has my name and EID on it and my initials and date that I sealed the item on the tape.
And is that the bullet or projectile that was recovered from the autopsy?
Yes.
And at this time, the state offers into evidence what's been previously marked for identification and States A.
Any objections?
No objection, Your Honor.
What's been previously marked as States Exhibit A for identification without objection will be received into evidence as States 8.
Beyond what we've discussed, did you document any further scenes in this case?
No.
Did you have any further involvement?
Just my response to the medical examiner's office.
And did all the events, all your investigation occur at the residence located in Orange County?
The initial call-out response, yes, was only at the residence.
I don't have any further questions. Thank you.
All right, Cross.
Yes, Your Honor. Good morning. How you doing, Investigator Minor?
Yes.
How you doing today? Just briefly, I want to ask you some follow-up questions. How long you said you've been a crime scene investigator?
Since January of 2022.
January of 2022.
Correct.
And this incident occurred in May 2022, correct?
Correct.
So about 4 months. At the time of this incident, you had been a crime scene investigator for 4 months, correct?
Correct.
Okay. Is it fair to say this was close to like your first actual one in the field solo?
No, it was not.
Okay. Were you supervised by anyone?
Yes, I was.
Okay. When you, obviously, crime scene investigate, do you guys wear body camera footage? You don't do stuff like that, do you?
We do not.
Okay. And you arrived at this scene about 4 hours after the incident actually happened, correct?
I don't know what time the initial incident was reported.
Is that not something you would put in your report or something you think relevant for crime scene documentation?
I document the time I was notified that my response was required, the time that I arrived on scene, and the time that I cleared the scene.
Okay, what time were you notified?
Approximately 4 o'clock in the morning.
4 in the morning. And what time did you arrive? 5 in the morning?
Correct.
And as a part of your documentation, can you tell me again what your functions are? You say you document, but just walk me back through it briefly.
We respond to the scenes. We document them with notes, photography, any other processing methods that are deemed necessary for this specific case. We collect the evidence once it's been documented. We'll process that evidence. We will send the evidence to their final destinations, whether that's a lab or our evidence unit, and then we will write reports on essentially what is our involvement with each case.
Perfect, perfect. So I noticed you said you collect evidence, correct?
That is correct.
Isn't it true it was also a knife in the car that was not taken into evidence by you?
Yes.
When you arrive on the scene, is that a part of your duties to dust for prints or try to obtain DNA? Is that part of your job?
It can be.
When you say it can be, meaning that's something that you usually would do?
It's a case-by-case circumstance.
So in a case where someone is alleged to have been murdered or shot, you notice this blood spatter in the car. Is that not a case where you would dust for prints or dust for DNA if a weapon is located in the car?
It depends on the case circumstances.
Would you consider a knife a weapon?
It can be.
Okay. So I noticed you took a lot of pictures of Mr. Payne's vehicle. Let me go back a little bit. Are you aware of the vehicle, the owners or the persons that are said to be the owners or operators of the vehicles that you took picture of?
No.
So the black vehicle, the Chevy Malibu, you don't know who owned that car or drove that car?
It was my understanding that it was being operated by Mr. Payne.
Okay. Were you aware that Mr. Payne's girlfriend had a vehicle that was on the scene as well?
No.
Isn't it true you didn't take a picture of that vehicle?
I don't know what vehicle it is, so I don't know if it's in my photos.
Not even aware of it at all, correct?
Correct.
So it's fair to say you didn't take a photo of it?
I don't know what the car is. It could be in the background of one of my photos, so I don't know.
Okay. Did you take a photo of a white Audi truck SUV?
Not to my recollection.
You took a photo of a white truck, correct?
Yes.
You took a photo of a white Mercedes-Benz, correct?
Yes.
You took photos of a black Chevy Malibu, correct?
Yes.
So if you were to learn that Tara Walker, Mr. Payne's girlfriend, drove a white Audi vehicle and it was on the scene of this incident, you would agree that you did not document that vehicle?
Not to the same extent that I did the others.
Did you document a white Audi in your report at all?
In my report, no.
Had you knew of a white Audi vehicle being on the scene, would you have done that?
Depends on the case circumstances.
Okay, I want to make sure I ask you this clear because I'm not trying to trip you up. As far as your records and your reports, did you document a white Audi vehicle on the scene?
In my report, no.
Okay, thank you. So it's fair to say you don't know what was inside of that vehicle.
If I did not document it, I would not know what is inside of it.
Just to be clear, part of your duties are to collect evidence, correct?
That is correct.
No further questions, Your Honor. Thank you.
Any redirect?
No, Your Honor.
May the witness be excused?
Yes, Your Honor.
All right, ma'am, you can step down. All right, let's take about a 5 or 10 minute recess, and then we'll pick up with the remainder of the witnesses for the morning, okay? All right, so, ladies and gentlemen, if you can step back in the jury room, if you need to use your restrooms or whatnot, we'll give court staff a break, and then we'll come back in about 5 or 10 minutes and resume, okay?
All right.
All right, we're in recess for about 5, 10 minutes.
All right, well, we can zoom because this is from yesterday. So let's go through. I know the audio is terrible, you guys. I'm so sorry. You know, I mean, I'm doing the best I can, and I know you guys understand, but I just want to let anybody watching, if they're having issues with the audio, it's on their side, and I have filters that I can kind of go back and forth with. But when somebody's talking into the mic like that, and then somebody's talking over here, it's nearly impossible to to run it, because I'm literally running faders. It's like a box. It's like a tennis match or a boxing match. It's like nearly impossible. So anyway, state opened up May 9th, 2022. Dority sees Payne. The defendant goes back into his house. Payne doesn't leave his car. Dority goes and gets his gun. You'll see there's going to be a kitchen knife on the floorboard. Payne is at least 10 yards away, and Mr. Payne is the victim. Mr. Dority is the defendant. If you guys have any questions, definitely go and read our description, and we'll come over here as well. All right, so 1:30 a.m. Mr. Dority is driven home by his father. You'll find out that they got in an argument. That Mr. Dority got in an argument with his girlfriend, and she calls Mr. Payne's girlfriend. So Tara Walker arrives after Mr. Payne. Dority appears to be intoxicated. Words are exchanged. He goes inside to arm himself with a firearm. Tara Walker, who is the girlfriend, witnesses the shooting. She'll say that Dority was belligerent and angry. Tara was pleading with Dority, "Don't take your gun out. We were called here." So Dority calls his son into the house. So apparently his son, I'm not sure how old his son was. I missed that. But his son calls him into the house. And Tara will say that Mr. Payne did not have a weapon. Quick opening, right? Then defense comes in. He says, this is self-defense of a family. So they were celebrating Mother's Day at the father's house. Father drives him home. He gets home. He sees a black Chevy, which, as we know, was not black. It was silver, but maybe at nighttime it looks black. A tinted window rolls down. He says a 6'8" person steps out. 6'8" man steps out with a wingspan of 7 feet. Yeah, I mean, there's no question that Adreian Payne he's a big guy. He played professional basketball. He played for Minnesota and he played for Orlando, I think, and Atlanta. I think he played for. Do I have it in my description here? Do I have it in my description who he played with? He played for Atlanta and Orlando. I don't have in there that he played for Minnesota. I'm pretty sure he played for the Timberwolves as well. So he played for Orlando, Atlanta at least, and I'm pretty sure he played for Minnesota. So he's a big guy, right? 6'8". It's about average, right? You know, you got 7-footer, 7'2", you got 6'6", 6'7". So he's probably a forward. You know, forwards are usually 6'9", 6'10". So he was on the smaller side. But I wish I could show some video of him without getting in trouble. I'll try and find some video of him that's not like NBA, so we'll get copyright struck. So I'll try and find some video of him so we can see what kind of player he was. All right, so going on. Okay, so he's 6'8", wingspan is 7 feet, and he says, "I'm going to smoke you. What you going to do?" Did he actually say that? It's going to be like a he said. Lawrence is going to say that, but we can't hear Adrian's side of the story because he's no longer with us. So did he actually say that? I don't know. Dority has a concealed weapon permit. Mr. Payne doesn't leave, but pulls the car closer. So Tara arrives at the tail end of the incident, so she probably didn't hear that. So it's going to be Lawrence is going to be the only one that can say he said he was going to smoke me. Dority shoots once, hits Payne in the bicep. So I guess it hits him here and then goes through. Must go through his. We'll have to wait for the ME. He says that Mr. Payne reached for his waistband. So Dority, Dority grabs his son, goes back inside, calls 911. He doesn't try to flee, doesn't try to run away. He says this is a case of defense of others. Dority or his fiance invited Payne over. The girlfriend advised Payne not to go. He said the crime scene was contaminated. No firearm was recovered. That's interesting because I thought they just showed one. All right. He said you're going to see there's a lack of evidence in this case. This is not a case of a gunman on the loose. Dority asked Payne to leave, and did he leave? No. How did Payne even know how to get to the house? That's a great question. How did he even know how to get to the house? Well, maybe the girlfriend told him. Like, why would he go over? I mean, there's no reason for Adreian to just go over there randomly at 1:30 in the morning. Like, there had to be a reason. Mr. Payne presented himself in a threatening manner. Both parties stipulate to Mr. Payne's identification. Then we get to witness number one, which is Corporal Garrett Morris. He talks about a silver vehicle. When he got there, he was a first responder. He said Mr. Payne's left foot was outside the vehicle, his right foot was inside. So that's interesting. So he was either getting out of the car or he was getting into the car. Because there's no way your right foot, you're not shot and then you throw your right foot into the car, right? You're either getting out and you get shot and then you fall, or you're getting into the car and you get shot and you fall, right? Interesting. Gunshot to the chest. He started CPR. No weapons were found on Mr. Payne or his fanny pack. Then cross. You didn't search the vehicle for weapons. He said the passenger side door was open. He says the girlfriend was standing over there. Then Hannah Miner shows up. She's the CSI, crime scene investigator. She documents crime scenes with photos, notes, collects, processes, packages, evidence. There was a kitchen knife on the passenger seat, and there was blood spatter on the dash. Then they show a bunch of pictures of the house as well. She arrived at the scene at 5 a.m. She admits a knife could be a weapon, sure. She didn't report a white Audi at the scene. Yeah, what's that white Audi doing there? And then she doesn't know what is inside the vehicle of that white Audi. All right. Reenactments of the scene in court mic antics are the best. Chris, only 8 a.m. and it's already hot. Yes, I hope you guys are hydrating, not just coffee. Yeah, coffee, doesn't coffee dehydrate you, I thought? And Psychosaurus Rex, just wait. I was going to actually do a demonstration over there. I was going to demonstrate getting out of the car or getting into the car. You get shot. So think about it, right? All right, here, let's check it out. All right, so you're getting out of the car. All right, so this is my car. If I'm getting into my car and I get shot, I'm going to fall. I guess I'm going to fall like that. Or if I'm getting out of my car, I put my foot down, right? My foot's still here, and then I get shot. So either way, right? I mean, either way, you have to have your foot has to be in the car, right? There's no way that you're shot and then you put your foot in the car, unless you're shot and you're trying to stumble into the car. Suppose you could get shot outside the car and then try and stumble in. I suppose that's one way to do it, right? You could do it that way. Right, I suppose he could have gotten shot. He could have come. So is it plausible? Is it plausible that he's coming towards this guy, he gets shot, and then he stumbles back and he puts his foot in and then falls? I mean, I suppose that's That's plausible, but is it reasonable? I don't know. What do you guys think? You think he gets shot and then, like, what do you guys think? Do you think he's in the car, going into the car, coming out of the car? What do you guys think? Let me know your thoughts on that while I zoom here.
Matter you wanted to address? All right, we're back on the record. We're going to go ahead and bring the jury back in. Defense counsel, you had a matter you wanted to address?
Yes, Your Honor. At this time, the defense would like to invoke the rule pursuant to Florida Rule Criminal Procedure 90.616, sequestration.
All right, the rule of sequestration has been invoked. At this point, I've noted that none of those witnesses have been in the courtroom. You've discussed that with them, Mr. Smith.
I have, Your Honor, and I just emailed my victim witness coordinator because in a previous conversation at the bench, we were informed that this was being live streamed. So I've informed him to let any future witnesses know not to watch the live stream as well.
Got it. Thank you. All right, then have a seat. And state, you can call your next witness.
Yes, Your Honor. At this time, the state calls Marco Quintanar.
Can you tell me the story of friend fisting and shot gay, shot with truth, nothing but the truth, so help you God?
That's right. All right, have a seat for me. And then, sir, go ahead and state your full name and spell your first and your last name for me.
Marco Antonio Quintanar Gonzalez. Quintanar is Quintanar. Marco, Marco.
State your name, inquiry.
Thank you, Your Honor. Good morning.
Good morning.
If you could just introduce yourself to the jury.
I'm Marco. I live in the corner of where the incident happened. I'm just a neighbor.
And you live in the city of Orlando?
Correct.
Okay. Now I want to take you back to May 9th of 2022. Did you have surveillance cameras at your home?
Correct. I had one at the garage.
Okay. What type of surveillance system did you use?
It's a Nest camera by Google.
Nest by Google?
Yep.
And if you could just give the jurors a sort of specific location of where that camera is located.
So basically in the entrance of the garage, just in the middle of the garage, it's pointing to the driveway towards the street.
Now, does that camera have both video and audio capacity?
Correct.
And did it capture the audio of an incident that occurred in the early morning hours of May 9th of 2022?
Yeah, that's correct.
And were you able to provide that footage to law enforcement?
Yes, I did.
How is it that you were able to access that footage?
So basically through my phone in an app, I just selected the time and hit download and provided that to the law enforcement.
Now, for that app, do you have like a secure login that you're able to go in and locate footage from your camera?
Yeah, I mean, you have to log in with your email and password to do that.
And you were able to access the footage and then provide that footage to law enforcement?
Yeah, that's correct.
Before you provided the footage to law enforcement, did you, other than selecting specific time frame, did you edit the footage or change it in any way?
No, not at all. I just selected it and downloaded it.
Who all has access to that footage? Does anybody else have that app?
My wife.
And again, you or your wife didn't tamper with or edit the footage you provided to law enforcement in any way?
No, not at all.
Let the record reflect I've previously shown opposing counsel what's been marked for identification as states F. Permission to approach the witness?
You may.
Let the record show that I'm showing the witness what's been marked for identification as states F. Do you recommend it?
Yeah, it's the video footage recorded in CD.
And we reviewed this footage together back in June?
Correct.
Is that fair and accurate?
Yes.
At this time, the state offers into evidence what's been previously marked for identification as states F.
Any objections?
No objection, Your Honor.
What's been marked as previously as State's Exhibit F for identification were received into evidence without objection as States 9.
State will reserve publication. Now, you yourself weren't a witness to any incident, right? You just located the footage?
Yeah, no. At that time, we were up because I have a son that at that time was 4 months old. He wake up to be fed. So basically, we were about to get back to sleep, and we hear the gunshots. And I wasn't really sure, so I have to open the app and hear that. So, yeah. And then the next morning, an officer knocked at my door. He asked if the camera captured the moment. So I said yes. And he requested that video.
So hearing the shot is what caused you to go and look at your camera to see if it captured anything. Is that fair to say?
Yeah, correct.
All right. I don't have any further questions. Thank you.
Rose?
Yes, briefly, Your Honor. Good morning, sir. How are you doing today?
Good morning.
You stated, so isn't it true you didn't actually see the verbal altercation that transpired outside?
Yeah, that's correct.
Could you hear the altercation?
No, I mean, I just hear the gunshots, and then when I opened the app, I could hear the altercation through the video.
So you were able to hear the altercation when you looked at your video, correct?
Correct.
So you agree it was an actual verbal altercation prior to a shooting, correct?
Correct.
All right. And the videos that you provided to law enforcement, how many videos were there?
Just one.
Just one. Was it one long video, or was it, like, do you recall?
No, probably it was about a minute long.
10 minutes long?
1 minute.
1 minute long?
Yeah.
Okay. And isn't it true the video that you provided to law enforcement doesn't actually capture Mr. Lawrence Dority and Mr. Payne in any frame of the video?
No, it doesn't. It doesn't show that.
So essentially, it just shows a headlight illuminating in the area, an argument occurring, and then a gunshot. Correct?
Yeah, it's basically the audio what the police was interested in.
Thank you. No further questions.
You redirect?
No, Your Honor.
The witness step down?
Yes, Your Honor.
All right, thank you, sir. All right, next witness.
Yes, Your Honor. At this time, the state calls Tara Walker.
You solemnly swear affirm person shall give, shall be the truth, the whole truth, nothing but the truth, so help you God.
Have a seat for me. You State your full name for me and spell your first and last name for the court reporter.
Tara Helena Walker, T-A-R-A, last name is Walker, W-A-L-K-E-R.
I just need you to speak up a little bit.
Okay.
Thanks. You may inquire.
Thank you, Judge. If you could just introduce yourself to the jury.
Hi, I'm Tara Walker. I'm Adrian's girlfriend.
And what city do you currently live?
Orlando.
Now, are you currently employed?
Yes. I work at Baptiste Dentistry.
Now, I want to take you back. Do you know a person named Lawrence Dority?
Yes.
How do you know that person?
He was my best friend's boyfriend.
And who is your best friend, or who was your best friend that you're referring to?
Tatiana Mesa.
Now, over the years, first of all, how long have you known Lawrence Dority?
At that time, 15 years. About.
At that time, I assume, are you talking about the time of the incident back in?
Correct. Yes.
2022.
Yeah, because now it would probably be around like 18 years.
So, going back to 2022, how long had you known Lawrence Dority?
15 years.
And over the years, would you say that you maybe encountered Mr. Dority 100 times more?
Yes, more.
Would you recognize him if you were to see him today?
Yes.
Is he in the courtroom?
Yes.
Can you point him out and describe something he's wearing for the record?
He's right there and he's wearing gray.
Let the record reflect the witnesses identified the defendant.
So noted.
Now, going back to May of 2022, did you know a person named Adreian Payne?
Yes.
How did you know Mr. Payne?
I was in a relationship with him.
How long had you been in a relationship with him?
5 years.
And did you have any children in common?
Yes.
How many?
1.
So I want to take you back to the early morning hours, sort of after midnight on May 9th of 2022. Did you ever go to the defendant's neighborhood in the early morning hours of May 9th, 2022? Yes. When you arrived in that area, where did you go specifically?
In the middle of the street.
What vehicle were you in?
My car. I was in an Audi Q5.
And was the area you went to, was that Egret Shores Drive area?
Yes.
And is that in Orange County?
Yes.
Now, why is it that you decided to go to that area?
Tatiana had texted me and asked me to meet her at her house in 15 minutes.
Okay. And so did you agree to do that?
Yes.
And was your understanding that she had been in an argument?
Objection as to leading.
Your Honor, can we approach? So you said you had received a call from your friend Tatiana Mesa?
A text message, yes.
And your understanding was that she had had some sort of argument with the defendant?
Correct.
And so you agreed to meet her at the residence?
Correct.
So at some point after speaking with Tatiana, did you have any kind of contact with Adreian Payne?
I did, yes.
Can you describe that contact?
He was on his way back to my house. It's Mother's Day night. He had left and he was coming back. And I told him that I was going to go to Tatiana's house to see what was going on, that she had asked me to come to her house and that she had called the police.
Objection, Your Honor, hearsay. Your approach.
Hold on. I have. All right, ladies and gentlemen, there has been an objection to the last comment that was made by the witness as it relates to the police being called. I have sustained that objection. It is not relevant to these proceedings, and you are to disregard any reference to that comment, and you are not to consider it in any way, shape, or form in reaching a verdict in this case. Understood? All right. If I could have you all step out into the hallway or into the jury room just for a brief minute so that I can have another issue dissolved or resolved with the parties, okay?
All right.
So Tatiana called law enforcement and they're keeping that out. Keeping that out. Isn't that relevant? That's the whole reason why he was called over.
All right, go have a seat. All right, Mr. Smith, you have a few minutes. Ma'am, if you want to step down, you and Mr. Smith are going to have a conversation. That's fine. If she wants to stay there, that's fine too.
That was in the text message to me. She said that she called the person. Okay. Okay.
All right, then we can go ahead and bring the jurors back in.
Text from.
They have a seat. You may resume.
Thank you, Your Honor. So after receiving the text from Tatiana Mesa, you had communication with Adreian Payne, is that right?
Correct, yes.
And did you inform him of what you were doing?
Yes.
I guess, did he decide to come to that area as well?
Correct. He said he was coming off the highway and that he would meet me there.
So what happens when you first arrive at the area of the defendant's residence?
Larry, his father, is parked in the middle of the street near the stop sign, and Adrian's car is about 7 houses down, and Lawrence and him are outside of the car having a conversation.
Okay. And so you witnessed them having a conversation. What did you do from there?
I stopped in the middle of the street. Larry was standing outside of his vehicle. I rolled down my window. I lowered my phone down because I was on the phone with Adreian. And he told me to get back, that he was going to get his gun. And I was like, you know, what?
So let me stop you. Who told you to get back he was going to get his gun?
Larry.
Larry said he was going to get
Larry did, yes, correct.
Okay.
And I was like, what are you talking about, Larry? That's Adreian, that's Harmoni's dad, that's my boyfriend. And then he said, oh, that's a big fella, I'd never seen him before. And I was like, yeah.
And this is Larry, again, this is your understanding of Lawrence, the defendant's dad?
Correct.
Okay. So then what happened from there?
So I put the phone back to my ear. I was looking straight. I see that Adreian has his arm on top of the car. And he has one arm over the door. He's in between the crease of the door. Lawrence is standing on the side of here, the side of him. And I heard him say something like, get on, Lawrence, I'm not worried about you. Lawrence backed up. Adreian closed the door. Lawrence walked to the house, and Adreian walked over to me.
Okay. So at this point, the defendant has gone back inside the house?
Yeah, so we were about 7 houses down from his house, so he walked through the back, like on the grass, maybe around his backyard.
Okay. And then you have a conversation with Adreian?
Correct. He walks over to me. He walks in the middle. Larry is still there. He's getting into his car. They kind of just like nod heads. He gets in his car. He reverses and he pulls to the front of the driveway. Adreian's talking to me. I asked him, are you okay, babe? He said, yeah. Are you okay? And I said, yeah. Go back to your car and just pull up, and I'm going to park right here, which was like guest parking on the side of the house.
And did he go back to his car?
He did, yes.
Now, in that interaction that you had with him, did you observe him to be armed with any firearm?
No.
Did you observe him to be armed with any other weapons, like a knife or anything like that?
No.
And so, does Adreian actually go back to his vehicle?
Correct. He walks back to his car. I park my car where I say I'm going to park it. He pulls up to the spot where we were originally at, where Larry and myself was located.
So he pulled the car up to that spot.
Correct.
Now, that spot, where was that in location to the defendant's residence?
So we were in front of someone's house and across the street, and then there's it's a townhome. So there's one house and then their house.
Okay.
So stop sign, their house, and then his house. I don't.
And so, at some point, did the defendant come back outside of his residence?
Correct.
Are you able to estimate about how long that was? Obviously, I know you didn't have a stopwatch on you.
I know it wasn't less than 30 seconds. I mean, it had to have been like a minute and a half, maybe. It was somewhere.
At some point, did the defendant come back outside of his house?
He did.
Okay. When did you first notice that he had come back outside of his house?
So I parked my car. I walked over to Adreian. He opened his car door. He stuck his left leg out. I thought he was getting out the car. He had his hand on the steering wheel, and I said, "Babe, don't get out the car. I'm going to go see what's going on with Tatiana." Okay. And I turned around. I probably took about 5 steps, and then I seen Lawrence coming from in between the cars. Like there was another car and then a Mercedes, which is his car, and he had his arm under his shirt, and he came to the edge of it. I stopped. I asked him not to draw his weapon. What was he doing? His dad was asking, what was he doing, son?
Hearsay. Sustained.
Without getting into what anybody else was saying, what did you observe?
He came down to the end with a gun under his shirt. He took the gun out of his shirt. I asked him not to raise his weapon. I started to yell his name, Lawrence. And then from there, he asked us he asked, "Why are you here?" He asked a couple times, maybe like 2 to 3 times, and I tried to explain to him, Tatiana asked me to be here.
Okay, and so at some point after he's walked out, he's now taken his firearm out.
Yeah.
And where was he when he had the firearm out? How far was he from Adrian's vehicle?
Not far. He was at the end of their street. I mean, at the end of the grass, the neighbors, so I don't know how to explain it unless I show you.
Walked down. Let me have a photo here. Your Honor, this is in evidence of State Composite 5. Are you able to see my laser pointer on the screen? Yeah. Okay. So I'm going to have you take the laser pointer if you could.
Okay.
And you hit this button here.
Okay.
And then just point at the screen where Adrian's vehicle is located.
Right here.
Okay. Now, with the laser pointer, if you could just sort of circle an area where the defendant was when he fired the shot. So he had walked a few places down from his residence. Is that fair to say?
Judge, that's the leading, Your Honor.
Sustained.
Move to strike.
Well, no answer has been given. You can rephrase.
So if you could just, with that laser pointer, can you circle where the defendant's residence was? Okay. And then if you could just sort of walk down with the laser pointer showing the jury where the defendant had walked to at the time he fired the shot. And is he on the grass area?
Correct. Yes.
Okay. Now, you had some interaction, you said, with the defendant as he came back out?
Correct.
Were you able to observe his demeanor?
Yes.
What was his demeanor like? Was he even keeled? Was he upset?
It seemed like he was intoxicated.
Overruled.
He appeared to be intoxicated to you?
Correct, yes.
Now, after the defendant shot Mr. Payne, what happened from there?
I turned around to run towards Adreian or, get to him. His dad grabbed me and spun me around and told me that I needed to run.
It's not offered for the truth of the matter asserted, it's direct.
We're not going to have the arguments in front of the jury either, so let's come on up.
Okay, so after the shooting, you were saying what happened next? You can continue.
I turned around to get to Adreian. Lawrence's father grabbed me, spun me around, and told me I needed to run, to grab Havian and run.
Did you do that?
I did. I walked over. I tried to run. My legs felt like bricks. I went to him. I opened the car door. He jumped into my arms. He was already crying. I put him down because I couldn't carry him, and I told him to run. So we started to run. Larry ran over to Adreian.
Okay. Now, let me stop you there. So you run after this, and you run a few houses down. Is that fair?
Yes.
Have you had an opportunity to see some surveillance footage that shows you after sort of running down, also that captures the audio of the shooting?
Yes.
Let the record reflect I'm showing opposing counsel has been marked for identification as State G. Permission to approach? Let the record reflect that I'm showing counsel has been marked for identification as State G. Do you recognize this?
Yes.
And how do you recognize it?
My initials.
And is it a fair and accurate depiction of what was captured in it?
Yes.
At this time, the state offers an evidence that was previously marked for identification as State G.
Any objection?
No objection, Your Honor.
All right. What's been marked as State's Exhibit G for identification without objection will be received into evidence as State's 10.
And Your Honor, if I could just have a moment to set up the player. All right, so I want to go back through that and ask you a few questions about some of the voices and things that we're hearing on the video.
Okay.
So that voice that we hear there, is that your voice?
Correct, yes.
And what are you saying there?
Do not pull your gun out.
Now, I want to stop there. You said something after "do not pull your gun out." What was it that you said?
Lawrence? I didn't. Me?
I hear some yelling there. Who is yelling?
Larry.
Larry would be
His father.
So, are these two individuals? And I'll let you look at the screen behind. Who is this? And then who is this person? You hear a person saying, "Get in the house." Whose voice is that?
Lawrence.
The defendant?
Correct.
Come here! Oh my God, please! Right now! Please,
I'm going to pause here. If you could look at the screen behind you. You see my laser pointer? Who is this person?
Lawrence.
That's the defendant.
Correct.
help me! Please, please! I don't know the address! I don't know! He's shot him! He's gonna die!
That is 610. Statement now published. It's already been entered into evidence. It's none. So the voice that we hear sort of at the beginning of that, and I'm going to turn it back up, but as much as I can, is that your voice again?
Correct, yes.
And is that sort of a different camera that caught sort of the same audio or similar audio to the other surveillance that we just reviewed?
Yes.
Now, obviously, on the video, On the video that we just watched, we saw you sort of run by to that neighbor's residence.
Yes.
After that video ends, what do?
I run down a little further, and I'm banging on doors.
At any point, did you go back to, how long after that would you estimate that law enforcement arrived?
Oh, I don't know. It felt like forever.
At any point, did you go back to the area where Adreian was located, where his vehicle was located?
Yes. I heard Larry.
I don't want you to get into anything that anybody else said. I just want you to tell me what you did.
I ran back.
Okay, so you went back to that vehicle?
I did.
Okay. And then what did you do when you got back to the vehicle?
I went to the driver's side. I put my keys on top of the car, and I looked to see if he was alive.
Okay. Did he appear to you to be alive?
No. So
What did you do from there?
I ran around to the passenger side. I tried to readjust his head because he was leaning over into the middle with his head up, and I needed to fix him so I could try to do compressions because I couldn't get him out the car.
Okay, and then so you go around the passenger, you open the passenger side door.
I do.
And then what happens from there after you try to reposition his head?
I start the compressions. I'm telling Larry.
Sorry to stop you. You're trying to do the compressions in the vehicle?
In the vehicle. We can't get him out.
Okay. Then what happens?
I tell Larry, you have to help me. He's not breathing no more. And he starts screaming. He leans down and he starts doing them with me. So we're both pushing on his chest.
And then, so you're there with Larry. Are y'all there with the vehicle and with Adreian trying to render aid to him
Yes.
until law enforcement arrive?
Yes.
At any point, did you observe a firearm in the vehicle?
No.
Overruled. Calls for a yes or no answer.
No.
Now, let me show you a photo. This is again in evidence as Deposit 5. Do you recognize that?
Yes.
What is this a photo of?
My kitchen knife.
And is this from Adrian's vehicle, the passenger side?
Yes.
Why, if you know, was this knife there?
Objection is speculation, Your Honor, and lack of foundation.
Overruled. The question was why, if you know.
You can answer.
I put it there.
And
I'm sorry, what was the answer?
I put it there.
And why was the knife there?
We had went to dinner before he'd left overseas.
Okay, so you had put the knife there previously?
Correct, yes.
And it's from dinner?
Yes, correct.
And had you left the knife in the vehicle?
Objection is a leading, Your Honor.
Overruled.
Had you left the knife in the vehicle?
Yes, I did.
About how long before this incident was the knife?
Maybe 4 months. He went overseas. I was driving his car. He was only home for, okay.
So about 4 months?
Yes.
And then he had been obviously not around his vehicle.
Objection, counsel testifying, Your Honor.
Sustained.
You had stated that shortly after this, he was away, is that right?
Correct.
And then how long before this incident had he been back?
19 days.
All right. So that knife that we just saw the picture of, at any point during this incident, did you see Adreian with that knife on his person?
No.
Did you ever see him threaten anybody with that knife?
No.
Now, you previously said that you didn't observe a firearm on Adreian or in the vehicle. Is that right?
Correct.
Did you, and I know this is going to seem like I'm not trying to embarrass you or anything, but did you take a firearm and hide it at some point during this incident?
Leading, Your Honor.
Overruled. It's a yes or no answer.
No.
Okay. And you remained, did you remain in the area of the vehicle until law enforcement arrived on scene?
Yes.
And at some point in the early morning of May 9th, did you ultimately speak with law enforcement?
Yes.
And did you remain on scene to do that?
Yes.
All right, I don't have any further questions at this time.
Cross.
Yes, Your Honor, briefly, if I may.
Go ahead.
Good morning. How you doing, Ms. Walker?
Good morning.
Today? I'm just trying to follow up with some things that you're just saying on direct. I'm not trying to trip you up. I know this is a very sensitive situation for you. Isn't it true that when the initial verbal altercation occurred between Mr. Dority and your boyfriend, Adreian Payne, you were not present at the scene physically?
I pulled up. I was driving up.
Isn't it true Mr. Payne was on the scene before you were, correct?
Correct.
Right. And by the time you were pulling up, you had began to hear communication that you believe was the voice of Mr. Dority, correct?
Correct. I believe him
Okay.
and Adrian had a conversation.
Isn't it true you had actually told Adreian Payne not to come to that house, correct?
Correct.
And the type of vehicle you were driving was an Audi Q5, right?
Correct.
After you told Adrian not to come, he told you, no, I'm on my way. I'm already there. I'm on the I-4, getting off the I-4. I'm on my way. I'm almost there, right?
He said he was coming off of the 408
408, I'm sorry.
and that he would meet me there.
Okay. But he didn't, in fact, meet you there. He was already there when you arrived, correct?
Correct.
At some point, when you pulled up, you previously testified that you saw Mr. Dority's father present at the scene as well, right?
Correct.
And when you saw Larry Dority, he told you, watch out, Tara, I'm about to get my gun, correct?
Correct.
This is Mr. Dority's father telling you he's about to get his gun, correct?
Correct.
Not Lawrence, right? And that was based off what he had observed prior to you arriving, correct?
Correct.
You've known Larry Dority for a while, right?
Yes.
Lawrence's dad, right?
Yes.
You're aware he's former military, right?
Yes.
So at some point during this verbal altercation, Mr. Dority walks away into his home, right?
Yes.
But before he did that, he actually asked Adreian Payne, why are you here? Right?
I can't recall, but I've said it.
You were on the scene, right?
Correct.
Are you saying you didn't hear it, or you just don't remember?
He's asked him that he asked that question when he was sitting in the car behind me.
You said we were sitting in
When he was sitting in the car behind me, he asked that question.
Who was sitting in the car behind you?
Adrian.
Behind your car?
No, I was standing in front of his doorway when he got shot. I didn't know if he was talking to me or Adrian.
Isn't it true that instead of Mr. Payne leaving, when Mr. Dority went in the house, Lawrence Dority, he moved his car up closer to the home, correct?
I asked him to.
You asked him to do that?
Yes.
But it's correct. He did, in fact, move his car closer to the home, correct?
Correct.
This is 1:30 in the morning, at least, correct?
Correct.
How tall was Mr. Payne? About five? No, he was 6'10", right? 247 pounds, correct?
I can't say. 240.
Big guy. Is it fair to say he's a big guy? Okay. You're aware of how tall Mr. Dority is? Lawrence, he's about 5'8", right? Right. But you also told Mr. Payne to get back in the car, right? You actually verbalized to him to get back in the car.
I asked him to go to his car and pull his car up.
So, after Mr. Dority, Lawrence Dority, fired one shot in the direction of Mr. Payne, it's your testimony that Larry Dority, Lawrence's father, told you to run, right?
Yes, sir.
We previously saw that video that was just showed. It wasn't just you running, right? It was a little 10-year-old boy running as well, right?
Correct.
So it's fair to say it was Mr. Dority's, Lawrence's son was outside during this incident, right?
He was inside of the vehicle.
He was outside the house, correct?
Correct.
Okay. And let's get this straight. Did Mr. Adreian Payne live there?
Where?
At the location he was supposed to meet you at.
No.
Did he live there? Okay. Did Tatiana Mesa, Mr. Dority's girlfriend, did she invite him over there?
She invited me.
Did she invite Adreian Payne there?
No, she invited me.
Thank you. You stated that it took some time for law enforcement to arrive at the scene, right? It felt like forever?
Correct.
At some point, you walked over to the passenger side of this Chevy Malibu and entered the vehicle, right?
Correct.
And it's your testimony that you entered it to straighten up Mr. Payne's head?
Correct.
You said you started compressions as well?
With Larry, yes.
At some point, isn't it true that you left the scene at some point, but your brother picked you up, right?
I left around 7 a.m. after they told me I could leave.
Before 7 a.m., you had left the scene too, correct?
No.
You never went to Mr. Larry Dority's house?
I was after 7 a.m.
That was after 7 a.m.?
Yes.
Your car was still at the scene?
Correct.
Your brother came and picked you up, right?
At 7 a.m.?
That's how you left the scene. Your brother came to pick you up?
Yeah, he came at 2 o'clock in the morning.
He came at what time?
2 a.m.
He came at 2 o'clock in the morning?
Mm-hmm.
And you didn't leave till 7?
Correct.
So your brother was on the scene for 5 hours with you?
Correct.
What kind of car did your brother drive?
At that time,
Yes, ma'am.
BMW?
Wasn't it true someone else came to the scene as well? Was it your father?
Correct.
Around what time did he arrive?
3, maybe?
Okay. This was after you had entered the vehicle to straighten Mr. Payne's head, correct?
Correct.
And although you had a vehicle, an Audi, right? You left with your brother, right?
Correct.
And this kitchen knife that was in the car, it was in that vehicle for 4 months, you say?
Yes, roughly.
Because you used to drive that vehicle, right?
Correct.
So that would explain how Mr. Dority may have been somewhat familiar with the vehicle at some point.
Correct.
I know this sounds like a very ignorant question, and pardon my ignorance, but it was fair to say you love Mr. Payne, right?
Correct.
You wouldn't want him to have a bad name, would you?
No.
It's true, you would do anything to protect his name, right?
What do you mean by anything?
Is that fair? Would you?
No, not necessarily.
No further questions, Your Honor.
You redirect?
Yes, Your Honor. So at any point from when you first arrived on scene and you saw Adrian's vehicle up until the moment he was shot, did you ever observe Adrian set foot on the defendant's property?
No.
Now, by the time the defendant came back out with the firearm in this case, was Adrian already back in his car?
Correct.
And at the time, in the moments before Adrian was shot, did he have a weapon?
No.
And did you witness him make any threats to the defendant at that time?
No.
And were you in a position that if he would have made such threats, you would have heard them?
Yes.
I don't have any further questions.
All right, step down.
Yes, Your Honor.
All right, thank you, man. All right, ladies and gentlemen, we're just a little bit past noon, so we're going to take our break for lunch. You're free to go about your business for lunch. Just same rules apply. Please don't do any research, looking up of any names, maps, do any investigation on your own. Also, if you happen to see myself or any of the parties or anybody else involved in the case and we don't pay attention to you, that's because they've been instructed not to have any contact with you since you are the members of the jury. And we want to make sure that there's no appearance of any impropriety, okay? I'm going to have you all come back at 1:30. That'll give you a little time to get out of the building, try and find some place to eat, and then get back in to the building. We'll be ready to go sharply at 1:30. So once you all are assembled in the jury room, we'll bring you back in and get started, okay? Enjoy your lunch.
All right.
All right, have a seat. Before we adjourn for lunch, anything from the state?
Nothing from the state.
Defense? Just for planning purposes, roughly how many more witnesses this afternoon?
I plan on calling 2 witnesses this afternoon, the medical examiner and a firearms expert. And then from there, I plan to rest.
Okay.
And then obviously defense case.
All right. And we will be in recess till 1:30. All right, we're going to go back on the record because there were a couple of capiases for arraignments this morning. This doesn't have to do with the trial.
Thank you. Calling case number 2025 CF00202880.
All right, we can zoom through lunch, but in the meantime, so that was Tara Walker. She's the girlfriend of Mr. Payne. She works at a dentist office. She knows Lawrence. So she was calling, I think she was calling Lawrence Larry as well, I think, because it got really weird. So she arrived. So Tatiana texts her and says, meet me at the house in 15 minutes. She said she had an argument with Dority. So she agreed to meet Tatiana there. She told Adreian, Mr. Payne, that she was going there. And he said he would meet her there. So she says Larry's car was parked by a street sign. So now she's starting to say Lawrence, and also, she's saying Larry for Lawrence, but then there's also a Larry father, right? So she's like, what are you doing? That's my boyfriend. Larry says he's a big fella. I've never seen him before. So Payne has one arm on top of the car and one on the door. So he had 1 foot. He literally had 1 foot in the car, and then he gets shot. So Larry gets in the car, drives past Mr. Payne, and they nod, and then Payne goes back to his car. Larry comes back inside, comes out, and like a minute and a half later, then he shoots him. He just shoots him. And then we hear all that yelling and screaming from that Ring video. That was crazy. And then there's a little boy. He's a 10-year-old little boy is there, right? So, all right. I've got to start the Ali feed because we're going to be dual streaming. So just give me a moment. I've got to go start that. I'm going to fast forward and we're going to go to lunch and I'll be back. So, I'll be back soon, guys. Hang on.
All right, we're back on the record. Both parties have returned. Been informed all jurors are present. Do we have anything that I need to address before we bring them back in?
Nothing from the state.
Nothing from the state, Your Honor.
All right, let's go ahead and bring the jurors back in and we'll resume the trial. All right, seat. All right, ladies and gentlemen, welcome back. I trust you had enough time for lunch and that you all complied with the instructions of the court. You didn't do any research, looking up of anything, didn't do any investigation of your own, correct? All right, and did anybody associated with this case have any contact with you during the lunch break? No? All right, then we are ready to resume. State, you may call your next witness.
Yes, Your Honor. At this time, the state calls Dr. Marie Hansen.
You solemnly swear affirm testimony you shall give the truth, the whole truth, and nothing but the truth, so help you God.
All right, can you go ahead and state your full name for me and spell your first and last name for the court reporter, please?
Dr. Marie H. Hansen, M-A-R-I-E, H-A-N-S-E-N.
State, you may inquire.
Thank you, Your Honor. Good afternoon.
Good afternoon.
If you could just introduce yourself to the jurors.
I'm Dr. Hansen. I'm an associate medical examiner at the District 9 and 25 Medical Examiner's Office. And I'm a forensic pathologist, which means I'm a medical doctor. I'm a pathologist. I did 4 years of anatomic and clinical pathology residency. And then I did a forensic subspecialty residency and have passed the national board exams, and thus am board certified in anatomic, clinical, and forensic pathology.
Thank you, Doctor. And if you could just give the jurors a little bit of your educational background to hold your current position.
I have a BS in chemistry from the University of Wisconsin-La Crosse. I have a medical degree from the University of Minnesota. I have an anatomic and clinical pathology residency in St. Paul, Ramsey, and I have a forensic pathology residency in Miami, and I've been a practicing medical examiner since 1990.
Now, your current position in Orange County, how long have you had that position?
Since November of 2002.
And in that position, do you have to undergo periodic continuing education?
Yes.
And are you up to date with all the required continuing education?
Yes.
Now, as part of your work as associate medical examiner, is part of your job to perform autopsies?
Yes.
Can you describe to the jury what an autopsy is?
An autopsy is a gathering of history and then looking at a person, documenting the external surfaces of the body, looking for evidence of injury, evidence of natural disease, and evidence of medical intervention, and then continuing internally to look at the organs, looking for evidence of natural disease, evidence of injury, and taking specimens as appropriate for potential chemical analysis to help determine the cause and manner of death.
Now, in what circumstances is an autopsy conducted?
Under State Statute 407, any unattended death or any potential trauma, accident, suicide, or homicide, or an undetermined death would be reviewed. If somebody has been in an accident and has been in the hospital for a week, week and a half, they may have done enough documentation that we can tell why they died, and they may not need an autopsy. But in cases of homicide, almost everybody gets an autopsy.
And are you able to provide a rough estimate, I know you don't have the exact number, of how many autopsies you've conducted in your career?
Roughly an average of 250 to 300 a year since I've been practicing.
And that's going back to 1990?
Yes.
All right. I think you mentioned autopsies are a tool to determine the cause and manner of death. Can you just explain to the jury the difference between a cause of death and a manner of death?
A cause of death is a physical disease or a physical injury that causes a person to die. Manners of death are natural, due to natural disease, accident, most often car accidents or drug overdoses or drownings. Suicide, again, that can be drugs, that can be hanging, that can be shooting yourself, other inventive means as people invent, and homicide, deaths due to actions of another, as well as undetermined. Based on the information we have, we can't tell.
Now, when you conduct an autopsy, are they assigned specific case numbers?
Yes, they are.
And as part of your job duties, did you conduct an autopsy in case number ME 2022-909 on a person identified as Adreian Payne?
Yes, I did.
When was that autopsy conducted?
That was conducted May 10th, 2022, beginning at 9:15 in the morning.
Now, was that autopsy documented with photographs?
Yes, it was.
Have you had a chance to review your photographs or the photographs from that autopsy prior to today?
Yes, I have.
Let the record reflect I'm showing opposing counsel with the mark for identification as K.
You said K?
Yes, Your Honor. Now, as part of the documentation of an autopsy, is there typically a photo of just the deceased's face that's taken? It's like an identification photo?
Yes. A cleaned up picture of the face straight on for possible use in identification if it's necessary.
You may.
Let the record reflect, I'm showing the witness what's been marked for identification as state A. If you could just take a look at that. And is that the identification photo that was taken in this case?
Yes, it was.
And is that a fair and accurate depiction of the deceased as he appeared at autopsy?
Yes, it is.
At this time, the state offers into evidence what's been previously marked for identification as state A.
Any objection?
No objection.
What's been marked as State's Exhibit K for identification is received into evidence without objection as States 11. You may.
Now publishing State's Exhibit 11. And is this, as we discussed, the identification photograph taken of Adreian Payne in this case?
Yes, it is.
Now, were there other photos taken during the course of the autopsy showing wounds suffered by Mr. Payne?
Yes, there were.
Let the record reflect, I'm showing opposing counsel with the mark for identification as State's Composite L. Permission to approach?
You may.
Let the record reflect, I'm showing with the mark for identification as State's Composite L. Do you recognize those as photos taken during the autopsy you conducted?
Yes, these are a selection of the photographs.
And are they fair and accurate?
Yes.
At this time, the state offers what's been previously marked for identification as State L and evidence.
Any objections?
No objection, Your Honor.
What's been marked as State's Exhibit L for identification without objection from the defense is received into evidence as States 12.
Permission to publish?
You may.
Give you a laser pointer so you can walk us through these a little bit better. What are we looking at in this photo?
This is a photo of a front arm photo of Mr. Payne. You can see the head, the chest, and the upper arm. And in this particular picture, you can see the nipples are right and left, and he has a defect in his arm and a defect in his chest. And he has some abrasions from the resuscitation artifact.
So you circled with your laser pointer in the middle of his chest. So that would not be something from attempted resuscitation?
Yes, this would be consistent with doing CPR.
And can you just point out in this photograph for the juror what you believe to be the wounds sustained in this case?
Somewhat in the shadows, but you have 2 wounds on the arm and 1 on the left chest.
Can you describe what we're looking at here?
This is the entrance wound in the arm, the exit wound in the arm, and the re-entry into the chest.
This is just the same wounds, but now with measure for scale?
Yes, we're measuring it to scale.
This is again a closer view.
Yes, this is a closer view of the wound through the arm.
What are we looking at here?
In this particular case, when we examined him in standard autopsy position with his hands at his side and his palms up, the wounds do not align, but if you lift the arm and turn it slightly, then the wound through the arm continues into the chest and continues down in through the body.
And this is just a photo. Is this the left hand of the victim?
Yes.
Did you observe anything of note on the left hand?
No. We were looking for contusions, lacerations, chipping of the fingernail.
Is this the right hand?
Yes. This is one of the set of 4 for the right hand.
Did you observe anything of note regarding the right hand?
No.
What are we looking at in this photo?
This is a photograph of the projectile that we recovered from the right abdomen.
So during the autopsy, while you're performing the autopsy, is it correct that you actually withdrew this projectile from the body?
Yes, I did. And we're looking at a sort of cleaned up, this is the top. You can see that it has gotten into a star shape instead of, so it's a deformed tip. And you can see it has a little bit of a copper backing. And we have it from different angles so you can see the deformity of the tip, the core, and then the jacket. In the back, you can see that it is a yellow metal colored jacket.
Now, the photos that we just saw of the projectile, did you actually package the projectile up for evidentiary purposes?
Yes, we would package it place it in a small vial and put a label on it from the case, and then I'd seal it and sign the sealing of that.
Would you be able to recognize that from just the packaging, or would you need to open it?
Not from the outside packaging, because then it gets to law enforcement and they put it in multiple manila envelopes and
You may.
Showing the witness was compared to evidence as Exhibit 8. You just take your time and let me know when you've been able to get to a point where you can recognize that.
I can see and recognize what I signed.
So is this in fact the projectile that was removed from Mr. Payne during the autopsy by you?
Yes, it was.
You can remove it. Now, as part of your work conducting autopsies, is it helpful for you to use diagrams? And would that be helpful in describing the autopsy to the jury?
I believe it would.
Let the record reflect I'm showing a photo example of the marker identification as states M. Permission to approach?
You may.
Let the record reflect I'm showing as a witness both the marker identification as states M. Let me know. Are those diagrams done as part of the autopsy in this case?
Yes, they are.
At this time, the state offers into evidence what was previously marked for identification as state M.
That's M as in like Mary?
M is in no.
Okay. Just want to make all right. What's been marked as State's Exhibit M for identification without objection from the defense is received into evidence as States 13. You may.
What are we looking at here?
This is a diagrammatic representation of what you saw in the photographs. And I used a clear circle for the entrance and solid circle for an exit. And so the wound went from the arm, through the arm, misses the humerus, so it just goes through the soft tissue. Then it goes into the chest, so that's a circle, and it goes diagonally, it goes through the lung, through the aorta, through the heart, and the other lung, and through the diaphragm, and we recover the projectile, that's the X. Just on the, between the liver and the side of the abdomen. And in the standardized options that are available for me for the diagram, when you raise the arm, you can see that you can make it in an alignment so that it goes in a straight line through the arm, through the chest, and into the body.
Based on your experience as a medical examiner, with the positioning of the victim's arm, based on the trajectory you were able to determine to be consistent with having your hand on a steering wheel?
It could be anything that puts the arm anterior and a little bit above. So it's in a line with the wound through the chest.
Would that also be potentially consistent with having your arm on like a window of a car or, window of a driver's side door?
Any position that's going to, any potential scenario that's going to get your arm up and a little bit anterior to the chest.
Now, based on your autopsy, were you able to determine a range of fire?
It appears to be a distant gunshot wound that's more than 2 to 3 feet away because there's no soot, there's no powder tattooing, and there's no the gunpowder that's coming out of the end of the gun to cause the explosion, to cause the bullet to go down the gun. Comes out in a cloud with the gun, with the bullet. When it gets out of the gun, if you're close enough, it lands on the environment. And it was not on him.
So you're able to tell based on certain things like soot and other things if it's a close range gunshot. Is that fair to say?
That's correct.
But if it's beyond 2 to 3 feet, is that all just sort of the same category?
Yes. Once you get distant, once you have none of that, then It's at least 2 to 3 feet, and exactly how far may be determined by other investigational factors.
Now, as part of an autopsy, is a toxicology or drug screen run?
Yes.
Did the victim in this case have any drugs or alcohol in his system?
No, he did not.
And as part of your autopsy, do you weigh and measure the deceased?
Yes.
What was the weight of the deceased?
He was 247 pounds.
And how tall was he?
He was 80 inches or 6 feet 8 inches.
Now, in your autopsy in this case, were you able to determine a cause of death?
Yes.
What was the cause of death?
A gunshot wound of the arm and chest.
And were you able to determine a manner of death?
The manner of death is homicide.
Thank you. I don't have any further questions.
Ross.
Yes, Your Honor. Good afternoon. How you doing, Doctor? How you doing today?
Good afternoon.
Very good. Just briefly, you stated that this trajectory of the bullet wound was consistent with an arm being kind of raised in this type of manner?
Raised and a little bit anterior.
Okay. Something like, if I was to try to give you an example, can you see me? Would this be consistent?
Yeah, it's potentially consistent, yes.
Thank you. So it's, could this type of bullet wound be the result of someone attempting to raise their arm up potentially? You know what I'm saying? Someone potentially raising their arm up? Could this type of interior?
If they're raising their arm up as the gun is fired, it potentially could get. It could already have the arm up, or it could be in the process of raising it up. And when the bullet goes through the arm, that's.
Thank you. No further questions.
You redirect?
Briefly. So if an arm was raised, as counsel just demonstrated, where would the hand be positioned based on the trajectory you were able to do in the autopsy?
Well, can be a number of potential. All I can tell you is the position of the upper arm relative to the chest. The hand would be out in front if you don't have, if somebody has their palm up, you could have your palm up, you could have your palm down, you could have your hands. In this particular case, it's a little bit better if it's twisted so that the thumb is down. Twist the arm to get in the in and out hole in the right line.
So obviously, just sort of anatomically, a person, when they have their arm up, they can only extend out this far, right? They can't go backwards at the elbow?
No, you can only go as far as your elbow will go.
So to be in the position that you were able to determine from the autopsy, if the arm was up, it couldn't be going back this way. It would be just facing this way or in this way, as I'm demonstrating.
Yeah, the arm would be in front because you can't make the hand go back without the arm being in a different position.
Thank you. I don't have any further questions.
All right, may the witness step down?
Yes, Your Honor. Thank you.
All right, thank you. All right, state for your next witness.
Yes, Your Honor. At this time, the state calls Kristen Killinger.
Do solemnly swear affirm testimony shall give, shall be the truth, the whole truth, nothing but the truth, so help you God.
All right, go ahead and state your full name for me and spell your first and last name for me.
My name is Kristen Killinger, Kristen Killinger.
All right, state your main inquiry.
Thank you, Your Honor. Good afternoon.
Hi, good afternoon.
If you could just introduce yourself to the jury.
My name is Kristen Killinger, and I am employed by the Florida Department of Law Enforcement in the Orlando Regional Operations Center.
And what is your position with the Florida Department of Law Enforcement?
I am a crime laboratory analyst in the firearms section.
How long have you held that role?
I have been a crime laboratory analyst for about 5 years.
And have you had any other job titles, or have you had the same job title throughout your time there?
I have been at FDLE for 7 years. I was a forensic technologist in the trace materials section and also in the firearms section, and then I was promoted to crime laboratory analyst.
And in your current role, what are your job duties?
As a crime laboratory analyst, I primarily test firearms to see if they're functional or not. I will also do microscopic comparisons with fired ammunition components, such as bullets and cartridge cases.
If you could just give the jury your educational background to hold the current position you have.
I have a Bachelor's of Science degree in Forensic Science from the University of Central Florida. I also completed a 2-year training program in firearms identification.
Now, as part of your job with FDLE, do you have to have ongoing training to keep up to date?
Yes, I complete continuing education.
And are you up to date with all of the necessary continuing education to this point?
Yes.
Now, I want to take you back to January of 2023. Were you still employed with FDLE at that time?
Yes, I was a crime laboratory analyst then.
Did you become assigned to be the analyst in this case involving Defendant Lawrence Dority, FDLE case number 2022-0506229?
Yes, I was.
So what were you asked to do in this case?
For this case, I received a firearm and a projectile, and I was asked to compare the projectile to the firearm if possible.
Were you also able to test the firearm to determine if it was functional?
Yes, I also did a functionality test on the firearm.
Can you describe to the jury what a functionality test is?
Yes, so when I receive the firearm, I will kind of look it over, document it, take notes on what I have, such as the make, the model, the caliber, the features that the firearm has. I will examine the firearm to make sure that it's safe for me to test fire. And then when I do feel like it's safe, I will take it onto our laboratory range. And in this case, I test fired it into our water tank, which is just a tank full of water. That way I could recover both the cartridge case and the projectile from the firing process.
And in this case, you yourself actually fired the firearm?
Yes, I did.
And was it functional?
Yes, it was found to be functional.
Now, regarding the projectile that you were sent, what were you tasked to do regarding the projectile?
For the projectile, I was asked to compare it to the firearm if possible to see if the projectile was fired from this firearm.
How was that done?
So I use a comparison microscope, which is just a microscope that has 2 stages, so I can view 2 things at the same time in the same field of view. So in this case, when I opened up the projectile, I documented what I had, and when I felt like I could move forward with a comparison, I took the bullet that I test fired into the water tank, and I compared it using my comparison microscope. I looked at the microscopic imperfections that are present from the firing process, and I compared the bullet that I received as evidence to the test-fired bullet that I fired into the water tank.
Now, these microscopic impressions, are they unique to each individual firearm, or like a fingerprint is unique to an individual?
Yes, the firearm during the manufacturing process, the process of cutting the firearm to make it the shape that it is. There's rifling in the barrel that imparts the spin on the bullet for when it's traveling to spiral kind of like a football so it travels straight. The process of putting the rifling into the barrel is like cutting metal. And so there's microscopic burrs, and inside of the barrel there's little metal burrs and flakes that are inside that will leave microscopic imperfections on the bullet during the firing process.
Your Honor, permission to approach with what's already in evidence as State 7 and States 8.
Okay. Okay.
Is that you have in front of you the firearm that you were sent to do the analysis on in this case?
Yes, it is.
And is in the manila package, is that the projectile that you did the analysis on?
Yes, it is.
And were you able to make any associations with that firearm and that projectile?
The projectile was identified to the firearm.
Now, when you say identified to, does that mean that that projectile that was removed from the victim in this case was fired by the firearm that you have in front of you?
Yes, it was.
I don't have any further questions.
Cross?
I have no questions for this witness.
All right, may the witness be excused?
Yes, Your Honor.
All right, thank you, ma'am. You can step down.
Thank you.
All right, state your next witness.
Your Honor, at this time, the state rests.
All right, ladies and gentlemen, the state has rested its case. There are some legal matters that I need to address outside of your presence, so I'm going to ask you to step into the jury room while I address those, and then when we're ready, we'll bring you back in, okay?
All right.
All right, have a seat. Any motions or matters that I need to address from anyone or any party as it relates to the state resting its case?
Yes, Your Honor. If I may have a moment. At this time, defense would like to move for a judgment of acquittal, and this is the basis for that. As relates to the charge, it appears that the state has charged my client, Mr. Lawrence Dority, with second-degree murder with a firearm. Okay. Carries a 25 life minimum mandatory. And as a necessary element, the state is required to prove an element that by an act imminently dangerous to another and evincing a depraved mind regardless of human life, Lawrence Dority did kill Adreian Payne. And during the commission of said offense, Lawrence Dority did carry, display, use, threaten to use, or attempt to use a firearm, and Lawrence Dority actually possessed a firearm or destructive device. Lawrence Dority actually discharged a firearm or destructive device. And the result of the discharge of the firearm or destructive device, death or great bodily harm is inflicted upon Adreian Payne. And viewing the facts in the light most favorable to the state of Florida, Your Honor, I believe the state has failed to establish by competent and substantial evidence in regards to the necessary element of an act being imminently dangerous to another and demonstrating a depraved mind. The reason why I make this position, Your Honor, is that by definition, just going to the jury instruction, an act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and, not or, and, meaning they have to also establish and is done from ill will or hatred or spite or an evil intent, and, not or, and, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, although it's not necessary for the state to prove the defendant had intent to cause death, the issue in this case is whether as it relates, if you're viewing the facts of this case in the light most favorable to the state, obviously we're raising self-defense, we haven't got to that point, but if you're viewing it in the light most favorable to the state, alternatively, the state would have to still establish during their case in chief that Mr. Lawrence Dority acted with depraved mind, right? And absent in this situation, the only alternative that would seem to support the facts as we are listed, or as we stand right now, the issue is whether Lawrence Dority did not have a depraved mind without regard to human life because he acted in the heat of passion based on adequate provocation. That's an issue in this case, Your Honor. So in order to find that he did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. And a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was no reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act that caused death. And that Mr. Lawrence Dority was in fact so provoked and did not cool off before he committed the act that caused the death of Mr. Adreian Payne. And that's what I believe the facts, at best, if we're looking at the facts of this case in the light most favorable to the state of Florida, they have not established a second-degree murder with a firearm. At best, in viewing the light most favorable to the state, what we have, because the facts support that this was a heat of passion, if we're viewing it in the light most favorable to the state, right? This is manslaughter. At best. Mr. Dority didn't have a relationship with Mr. Payne. He only knew of the man's name through his association with his girlfriend over the years. There was no evidence that he had a prior incident with him, any riff, any text, any call, any exchange, any prior situation. All you know, he's coming home and he's surprised by a person he doesn't have any affiliation with, and they have an altercation of words. He's feeling threatened. Well, from our position, we're saying he's feeling threatened. I know you haven't heard from my client yet, but the evidence still supports that there was an argument. And he went into his home. This is at 1:30 in the morning outside his house. And even by testimony of Ms. Tara Walker, she states that Mr. Dority asked, "Why are you here?" So what we have here is a spontaneous situation. But he didn't have time to cool off because whatever the exchange was, it immediately resorted to Mr. Dority having to go back into his home and come back out and ask again, "Why are you here?" While his son is outside, his dad is outside, and they haven't made it safely into the home yet. So at best, Your Honor, this is not second degree, at this phase, this is not even second degree murder with a firearm. I would submit to the court, this is overcharged to begin with. Based on that, I believe that element, based on that lack of sufficient establishment of that necessary element, that you must give us a judgment of acquittal as it relates to second degree murder with a firearm. Thank you.
Okay.
Your Honor, the defendant's actions in this case speak for themselves. He went after someone was not on his property but was parked down the street. He engaged that person in words. He then stormed into his house, armed himself with a firearm. During this time, he didn't, cool off, or he had certainly had time to do that. He then armed himself with a firearm. He came out. You heard the video of Tara Walker screaming for him, "Don't take your gun out, don't do this, Lawrence." And then he still, after all of that, in that circumstance, aims his firearm at the victim in this case and shoots and kills him. This certainly meets the elements of second degree murder. It doesn't require an intent to kill. but a depraved mind. Certainly, anytime you point a firearm and discharge it at a person in this circumstance, that shows ill will, hatred, spite, or evil intent. And again, that portion of the depraved mind is or. So it could be an ill will or a hatred or spite or evil intent. And then obviously shooting a firearm at another person is clearly indifferent to human life. So we've met the elements of second-degree murder and ask that you deny the JOA.
Your Honor, may I add something briefly?
Go ahead.
In light, regardless of what the state just mentioned, still sufficient facts that gives the fact finder a reasonable understanding of what Mr. Dority was placed in at that time, that situation. You heard from an expert that the trajectory of how the bullet went through his bicep to go into his chest cavity is consistent and could be because he was raising his hand, arm up. Now the issue is, why was he raising his hand up? In the direction of where, if his thumb is down, Your Honor, he could have been holding his gun like this, or trying to. That's enough right there to not allow second-degree murder with a firearm to proceed, Your Honor, if you're viewing the facts in the light most favorable to the state of Florida.
Wasn't there testimony that from one witness that his arms were up and he was in between the driver's door and the driver or the hood of the car? And that's a fact that is in the light most favorable to the state, that the arm is already up?
That doesn't negate that his hands is up. He could have had a weapon in his arm, in his hand as well.
Understood.
I understand Your Honor's position. Regardless of the fact there was no rift previous at the time of this situation. This is not something where he intended. I know he doesn't have to intend the outcome of death, but this is literally a heat of passion moment. It can be no other thing. And a heat of the passion killing by law is manslaughter. He didn't have time to cool off. Even the same witness that said Mr. Payne had his hands up also testified that Mr. Dority was in his house less than a minute. Minute at best. Minute and a half at best. That's not time to cool off when someone's outside your house at 1:30 in the morning threatening you while your child and your father's outside. You just got to finish celebrating Mother's Day. You're on your way home, and unknown to you, someone's lying in wait for you. And when you ask why you're here, you get a threatening posturing response. 6'8", 247 pounds. That's adequate provocation. Thank you.
All right, I'm going to take the matter under advisement. There's one thing that I want to check on, and then I'll be able to rule on that issue. Okay?
Thank you.
All right, does the defense wish to present a case?
Yes, Your Honor. The defense would like to call Mr. Lawrence Dority.
All right, and any other witnesses?
With all candor to the court, I don't believe another witness is necessary. No.
Okay. All right, so a couple of things then, Mr. Dority. Your attorney has indicated that he's going to call you to testify. You understand that?
Yes, Your Honor.
All right, and he's indicated that he's making the decision not to call any other witnesses other than you for purposes of your case. You understand that?
Yes, Your Honor.
All right. Have you discussed that strategy with him?
Yes, Your Honor.
And are you in agreement with that strategy?
Yes, Your Honor.
Okay. So you understand that after you testify, there will be no other witnesses or no other evidence presented on your behalf. Is that correct?
Yes, Your Honor.
All right. Then the jury will have to make its decision based upon the state's evidence and testimony from their witnesses and from your testimony. You understand?
Yes, sir.
Okay. Now, have you had a discussion with your attorney about the pros and cons of testifying?
Yes, Your Honor.
Have you had a discussion with your attorney about the pros and cons of not testifying?
Yes, Your Honor.
Okay. You understand that if you take the witness stand and you testify, that you're going to be treated just as anybody else who takes the witness stand. meaning that the jury's going to get to assess your credibility just like they did everybody else's, and the same rules that apply to their testimony will apply to yours. All right. And you understand that you have an absolute right to remain silent if you want to. Okay. And that if you were to exercise your right to remain silent, I would instruct the jury, as I did during the jury selection, that they are not to consider your decision not to testify against you in any way, shape, or form. You understand that? All right. Do you have any questions about your right to testify or your right to exercise your right to remain silent?
No, but is there a way that I could talk to my lawyer for a couple of
Certainly. Go ahead and talk to him, and then I'll follow up. All right, you've had a chance to continue or to consult with your attorney?
Yes, Your Honor.
Do you need any more time to do so with him?
Sir, is there a way I can take a bathroom break before
Oh, we're going to do that. Don't worry. And so, do you have any questions for your attorney or for the court about your right to testify?
No, sir.
Do you have any questions for me or your attorney about your right to remain silent?
No, sir.
All right. And you've indicated to me that you've had the opportunity to discuss the pros and cons of testifying and the pros and cons of exercising your right to remain silent, correct?
Yes, Your Honor.
All right. After having considered those, have you reached a decision in this case as to what you want to do?
Yes, sir.
Okay, can you tell me what decision you've reached?
I want the people to hear my story.
All right, so you want to exercise your right to testify.
Yes, Your Honor.
Has anybody forced you, threatened you, or coerced you in any way to make that decision?
No, sir.
Has anyone promised you anything to make you make that decision?
No, Your Honor.
And are you making that decision because you believe it's in your best interest and you want to?
Yes, sir.
Okay. And is there any other witnesses or any other evidence that you want presented to the jury other than your testimony?
There is one thing that I would like to show.
All right, have you discussed that with your attorney?
It's okay, Your Honor.
All right, so after consulting with your attorney about the issue that you were considering, you're advising me that you no longer wish to have any witnesses or evidence other than yourself testify, is that correct?
Yes, Your Honor.
Okay. All right, then what we will do is take about a 5 or 10 minute recess for everybody to use the restroom and whatnot, then we will come back and start with the defense case, okay? So we'll be in recess. All right, just a friendly reminder, please no spoilers on any case that we're watching, any trial that we're watching. So, Lala, no spoilers, either on this case or on the Ali. So, appreciate it. We want to watch this without any spoilers. So, please, no spoilers. No spoilers. Appreciate that.
Widespread saying no spoilers. No spoilers, please. If you've already seen the trial or knows what happens, please keep it spoiler free so everyone can experience it in real time. Let's keep the suspense alive for everyone. And we appreciate your cooperation in that. All right, so Dr. Marie Hansen, she's the medical examiner. She came out and she talks about, so the bullet, it seems like it went through his arm and then into his chest and went this way. I thought because he's taller, I thought it might have gone like up, but it seems like it went, sorry. Seems like it went like this, right? So it went through here and went down like that. So, and of course they did, defense did the judgment of acquittal, which didn't get us anywhere. So, and don't fret, don't fear not. We're streaming Washington versus Ali on another computer, and we will. Oh, and she did. All right, I'm not gonna look. So don't look, guys. Well, that's a shame, Lala, because it's Terry. It started yesterday, and there's only, it may be done right now. I don't know. So anyway, no spoilers. All right, I'm not gonna look. So thanks for listening to me, Lala. You probably just got yourself banned for doing that. Please, no spoilers, you guys. It's really not that difficult. No spoilers. Okay? Not that difficult. It's a current trial. We're picking up on it. Started yesterday and it's going today. It's a fast trial. So we're asking you, please, no spoilers. We will time you out and we'll either ban you if you can't even just pay attention and follow simple instructions. It's really not that difficult. Okay? All right, so let's fast forward. I just don't understand people. I mean, seriously, what's the point? What's the point of coming in here and telling us what the verdict is? You know, you're just going to get yourself banned. Simple as that. So if you guys want to get banned, go ahead and do it.
All right, we're back on the record. I did go back and look at this issue on the judgment of acquittal argument based upon the evidence and the standard that applies at the end of the state's case. The court does find that there is sufficient evidence to allow the case to continue, and I'm going to deny the motion for judgment of acquittal. All right, anything else we need to address before we bring the jury in and start with the defense case?
Nothing to say.
Okay, let's go ahead and bring in the jurors. All right, go ahead and have a seat. All right, does the defense wish to present a case?
Yes, Your Honor. May it please the court?
All right, you may call your first witness.
I would like to call Mr. Lawrence Dority.
All right, Mr. Dority, if you'll make your way over to the witness box for me, please.
Will someone swear or affirm to tell the truth, all the truth, and nothing but the truth, so help you God?
All right, just have a seat. And state your full name and spell your first and your last name for the court reporter.
My name is Lawrence Dority.
Spell the first name and the last name.
Lawrence, Lawrence, last name Dority, Dority.
Mr. Thompson, you may inquire.
Mr. Dority, how old are you?
I am 32.
You have any children?
Yes, I have 3.
What are their ages?
13, 8, and 2.
What do you do for a living?
I am a barber.
Have you lived in Orange County all your life?
Yes, sir.
Are you married?
I'm engaged.
I'm sorry?
Engaged.
Let's get right into it. Switch gears a little bit. You obviously been here and sat through this trial so far. You've heard a lot of things. And you actually live in this situation. You recall what happened on May 9th, 2022?
Yes, I do.
Did you explain to the court and the jury what happened?
Well, around 1:30 in the morning, me and my son and my dad went to my house. My father was taking me and my son home. And as we arrived, I see the car parked at the corner of my home, and I automatically assumed it was Tara. So I thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. And so I walk over there to greet her, to say, hey, you know, why are you parked here? And Mr. Payne gets out of the car. And when he gets out of the car, he's looking down at me. He has his hand in his waistband, and I can see like something silver sticking out on the side of his hip with his hand on it. And I asked him, what are you doing here? And he said, I'm not playing with you, I'll smoke you. I said, what? I threw my hands in the air and I started freaking out. My dad rolls down the window and asked me, is everything okay? And I told him, I don't know. So I go inside of my home. I retrieve my firearm so I could safely get my son in the house. And so as I return back outside, I see Mr. Payne has moved his car up even more. And he's gotten out of his car again. And so I'm standing in my driveway and I'm asking him, why are you here? What are you doing here? Why are you here? Can you please leave? Can you please leave? And he's just staring at me.
Okay. How tall are you, Mr. Dority?
5'8".
How much do you weigh?
145 pounds.
Did you have a relationship with Mr. Payne? Had he ever been to your home before? Did you invite him? I need you to make an audible.
No, sir.
Did you have a relationship with him at all?
No, sir.
Did you invite him to your home? I'm sorry?
No, sir.
Out of all the years that you knew Miss Tara Walker, had you ever actually met Mr. Payne?
Like twice.
Was there any situation where you guys had a issue?
No. I just seen him one time. He showed up to my girlfriend's mother's Thanksgiving or something like that. He showed up unannounced, and I don't even recall the other time.
So getting back to May 9, 2022, when you came, why did you go back in the house? Why did you go in the house?
Because I thought I was going to die.
Why'd you feel that way, though?
He's outside my house. He's telling me he's going to smoke me. I have my son outside. I have my father outside. He's there by himself. Nobody, I didn't.
How many shots did you fire? A moment.
I'm trying to go home.
Mr. Dority, when you speak into the microphone, let's just slow down a little bit. Let's try to... take your time and make sure you speak into the microphone, okay?
What was the question?
At some point, you felt you went in the home and obtained your firearm. What were you thinking at that time?
I have to get my son safe. I didn't know. I just thought he was gonna kill me and my son and my father, and I didn't know. I didn't know what was gonna happen.
When you came back outside and you had this firearm, first of all, did you have a concealed weapon permit?
Yes, sir.
So had you taken self-defense classes before?
Yes, sir.
When you came out, did you have any additional words or anything was said by you at that time?
Yes.
What was that, if anything?
I said, "Can you please leave? Why are you here? Can you please leave? What are you here for?"
And what was the response that you got?
He didn't say anything. He was just staring at me.
And then at some point, you felt the need to discharge your weapon. How many shots did you take?
One. I saw him. I was saying, "Why are you here? You need to leave. You need to leave. You need to leave. Why are you here?"
How were you saying it? Were you saying it softly, or how did you say it?
Like, "Why are you here? What are you here for?"
Were you talking to him?
I don't know.
Could he hear you?
Yes,
How do you know he could hear you?
because he was staring at me, and it wasn't far. It's like from here to the end of the courtroom. Like, it wasn't far.
When you came out the house, or at the time when you took a shot?
I mean, I was in my driveway the whole time.
Did Mr. Payne appear to reach for something, or
Yes, when I was saying, "Why are you here? You need to leave. You need to leave. Why are you here?" I seen him going like this, pulling his hand up, like he's raising a gun towards me, and I shot one time, and I called the police, and I put my son in the house.
before we get to that point, at some point, you stated when you went in the house and came back out that his vehicle was even closer than it was at first when you first encountered him. Is that true? Is that a yes?
Yes, sir.
So after the fire, after you discharged your weapon, you called 911? I need you to speak into the microphone.
Yes, sir.
Did you remain at the scene?
Yes, sir.
Did you cooperate with law enforcement?
Yes, I did.
Did you provide a statement to law enforcement?
Yes, I did.
Even after they give you Miranda warnings, you gave a statement, right?
I was never read any Miranda rights.
You provided a statement, right?
Yes, I did.
Is there anything else you want the jury to know that you hadn't said?
You know, before I got up here, I thought I knew what to say exactly. You know, but I don't. It's just no.
I don't think I asked you this, but at that time, how old was your father?
60, 62.
And how old was your son at that time?
8, 9.
How old? I'm sorry.
8 or 9, 8.
Were you intoxicated?
No. with the police for 13 hours.
None of the officers assumed or speculated that you were intoxicated?
No.
Now, at the scene of this incident, Tara Walker was present, right?
Yes, sir. Afterwards.
Did you see her go into the vehicle that Mr. Payne was in?
While I was on the phone with the police, I put my son in the house. I'm on the phone with the police. And I saw my father go over to Mr. Payne to see if everything was okay. And I can hear him telling her, find a piece of plastic so I could try to stop the bleeding. And I see her go through the back seat. She goes through both of the back seats. She goes to the front seat. She goes to the glove compartment, and she just runs. She runs to the other side, and we didn't see Tara until the police arrived.
Do you know, or did you see anyone else that may have had any relationship or affiliation with Tara Walker arriving on the scene?
Yeah, her brother and her father came, and I was just so confused because they had my son and my father and me like chambered away, and she's just frolicking around, calling her friends and calling her family.
Sustained.
No, and I was just confused.
Mr. Dority, I'm going to ask you this question. Did you see a firearm in the hand or in the possession of Mr.
Yes.
Did you feel like your life was in danger?
Yes, me, my son, and my father.
No further questions, John.
Cross.
Good afternoon, Mr. Dority.
Mr. Smith.
So, I want to go back to several things that you said in your direct testimony, but first I want to start out with, you said in your direct examination testimony that you gave a statement to law enforcement after this, right? Is that correct?
Yes, sir.
Okay. And you say in your testimony to this jury that you were never read your Miranda rights. Is that right? That's what you just said to your attorney?
From what I can recall.
Well, you didn't say you didn't recall, right? What you said to your attorney was that you were never read your Miranda rights. Is that right?
Yes, I did.
Okay. I'm going to direct you to page 12 of the transcript of your statement that you, with the detective in this case, beginning at line 5.
Really quick, can I say something?
I'm going to approach and I'm going to show you what I'm talking about.
Okay.
I've got to lay this for the record.
Okay.
Okay. I'm going to show your attorney. Permission to approach?
You may.
I'm going to just let you read along. So this is where I read from, but I'm going to read this.
This is the interview?
Yes, this is the interview.
Okay. I was in response. I was talking about when they initially arrived to my home.
Okay. But just
Not
to be
this.
clear, what this says is, okay, well, let me do this. I want to read your rights, okay? And you say, home. And the detective says, and then we can talk about that after, okay? And you say, okay, buddy. And then detective says, so you have the right to remain silent. You say, hum. And then anything you say can be used against you as evidence. Yes, sir. You're entitled to talk to an attorney now and have him present now or any time during question. Do you understand? Yes, sir. If you cannot afford an attorney, you can be provided with one without cost. Do you understand your rights? And then you said, after being read that, in the transcript of your interview with the detective, yes, sir. So you were read your Miranda rights, correct?
Yes, I was not read them initially when I was placed in handcuffs, which I was referencing to.
Okay.
Not my interview.
Your testimony to this jury not 10 minutes ago was that you were never read your Miranda rights. Is that correct? Never. That's what you said. That's not true, is it?
I was read my Miranda rights in the interview room.
Okay. Thank you. Now, another thing that you just said that I found to be interesting is you said that when you came back out of your house, after you'd gone in the house and armed yourself with a firearm, you said that you came back out and you said, "Can you please leave?" And you were speaking sort of calmly to the jury in a sort of meek tone that you're speaking today. Can you please leave? And this is after you came back out, after you armed yourself with a firearm, you're asking him, "Can you please leave?" Is that right?
Correct.
Okay. So I want to direct you, and I'll let you look at it. I'm going to read it again. I'm going to tell your attorney to, this is your interview with Detective Gilberti. This is on page 50, beginning at line 16. This is going to be line 16 through line 23. Permission to approach.
You may.
I'll let you look at this and then I'm going to read it out loud because this is the opposite of what you just said. Starting at line 16, I'll give you a moment to read through line 23. All right, so your testimony on direct examination was that you were just asking him to please leave when you came out with the firearm, right?
Correct.
Okay. But what you said to the detective in your interview was, and I'll begin on line 16, detective, like when you came back out with the gun and he was still in his car.
Best evidence, Your Honor.
Response.
This is impeachment.
Overruled.
Yeah. Like when you came back out with the gun and he was still in his car, did he say anything to you? No. Well, sorry, Mr. Dority, your response was no. The detective says, was there any communication? And Mr. Dority, your response was, I didn't communicate with him, I shot him. That's what you told law enforcement the day that this happened in your interview, right? You didn't say, could you please leave? You just shot him. Is that right?
That's what I had said in the interview.
Right. Okay. So I want to go back a little bit. This afternoon, the afternoon going into the early morning that this shooting happened, you were at your father's house, right?
Correct.
Okay. And you had been drinking at your father's house?
Earlier that day.
And you had been drinking some shots of Casamigos at one point in the afternoon, right?
Earlier that day.
Okay, but earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Overruled.
Earlier that day, you had been drinking shots of Casamigos, correct?
Correct.
Okay. And to be clear, where was your vehicle when you came back to your house?
Parked in my driveway.
Okay. And so your father drove you to your residence from his house, right?
Correct.
But it's a close distance, right?
Yeah, I could have walked.
Okay. All right. So I want to talk about some other things that you said in your direct testimony. You were very clear in your testimony 5-10 minutes ago when your attorney asked you, did you see a firearm, right? You said, yes, I saw a firearm. That was your testimony just, 10 minutes ago, right? Correct?
Correct.
Okay. Now, I want to take you again to your interview with the detective in this case. This time I want to direct you to page 35 of the transcript of the interview. Now, on page 35, do you have the transcript, or do you need to see it?
I have a copy of it, but I don't know exactly.
Sure. I'm on 35 at line 25 and 36 at line 3. All right, so Mr. Dority, I'm going to read from this transcript, starting at line 25 on page 35. Detective Gilberti, this is his question to you. Okay, did you ever see a gun? Mr. Dority, I cannot say I necessarily saw a gun, but if you're giving me this gesture, I've taken concealed weapons classes. I've taken defense classes before. If somebody approaches me like this, and that's your answer. So you cannot definitively say and honestly say to this jury,
Objection, Your Honor. Objection, Your Honor. Argumentative.
Sustained.
You cannot say definitively that you saw a gun, can you?
Objection, Your Honor. Same objection. Argumentative.
Sustained.
Judge, can we approach?
Come on.
Just want to reiterate again, guys, no spoilers. I know that this trial was fast. I know it may have a verdict. Just please, 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 no spoilers. Thank you.
So today in your testimony, you mentioned that you saw a shiny object when you first approached the victim's vehicle, right?
Yes.
Is that correct?
Correct.
Okay. But you never said anything at all in your initial interview with law enforcement about seeing this.
Objection, improper impeachment.
Overruled.
You never said anything at all about the shiny object then, right?
When
you had your interview with law enforcement at the interview room.
I had been waiting and sitting in the back of a police car for 7-8 hours. I was in the interview room for 6-7 hours. I hadn't slept. I was beyond tired, and my recollection of what happened could have been maybe, I don't.
Okay, so you didn't say it then, but you're saying it now, right?
I said it.
Okay. Now, you mentioned in your direct testimony that you were concerned for your son and for your father who were present at the time of the shooting, right? Is that yes?
Yes, sir.
Okay.
I apologize.
But even by your own telling, there was never any threat by the victim made to your son, right?
Objection, argumentative, Your Honor.
Overruled.
There was never any threat made by the victim to your son, right?
Correct.
Is that correct?
I said correct.
Okay. And there was never any threat made by the victim to your father, right?
Correct. It doesn't have to be made to them, though.
Okay. Now, you would also agree that where the victim was parked was not your property, right?
The neighborhood is considered my property. I don't own the neighborhood, but it's my dwelling. That's where I live.
Okay. But to be clear, Mr. Payne never set foot in your house, right?
No.
He never stepped foot on that piece of grass in front of your house.
He may have.
Okay. Do you remember a previous testimony in a hearing? In a courtroom like this?
Yes.
Okay. I am going to
direct and show opposing counsel transcript of a previous hearing.
I don't know what he did when I went in the house.
Okay, I'll direct a question to you in a moment. I'm showing opposing counsel the transcript, page 156. Okay, so my question was, at the time, was that area that he parked, is that your property?
No, sir.
Okay, so you're saying it was not your property. You agree?
It wasn't my, I don't own the land. I don't own it. I was a tenant there.
I understand that. But you leased the property, presumably?
Yes, sir.
Okay. And with that lease, it doesn't entitle you to the entire neighborhood, correct?
It's a private neighborhood.
It's a private, is there a gate to get in?
There was until it was destroyed.
Okay, so at the time of this, you could just drive into the neighborhood, correct?
Yes, you could.
Okay.
It's still a private residence.
And that area that the victim was parked, that's not included in your lease, correct?
Correct.
Now, when you went inside your home to arm yourself with a firearm, in this case, the victim didn't follow you, right?
No.
He stayed by his car.
Correct.
And so you went in, you would have had time at that point to call 911 if you deemed it necessary?
Correct.
But you didn't do that, did you? Did you?
I didn't think it was necessary at that moment.
Okay. What you deemed was necessary was to get your firearm, to go outside, and to kill it, right?
No.
So that's what you did.
It's not subsequently what happened.
So you went in the house, right?
Correct.
You armed yourself with a firearm.
Correct.
You went back outside the house.
Correct.
You aimed. Before you shot, you aimed. Yes?
Correct.
And then you shot Adreian Payne.
After I asked him to leave several times.
And again, we already went through your original transcript, but what you previously said was you didn't communicate with him, you shot him.
You have
right?
audio recording of it.
Okay. I'm asking the questions here. You said, in what we've already established in your previous transcript, you didn't communicate with him, you shot him, correct?
If you say so.
I mean, we can look at it again. Do you need to look at it?
No, I looked at it already. You already showed me.
Okay, so you would agree. You said you did not communicate with him, you shot him, right?
Correct.
All right. I don't have any other questions. Thank you.
Redirect?
Yes, briefly, Your Honor. Mr. Dority.
Hello.
Your interviews with law enforcement was recorded, right?
Correct.
Okay. So your conversation that you had with law enforcement that spanned over several hours could be shown to the jury, couldn't it?
Yes, sir.
Okay. At the time when I asked you, had you been given Miranda warnings, is it your testimony that you thought when you were first encountering law enforcement, they never asked you a question as far as Miranda?
Correct.
But at some point throughout the time that you were in custody, you were at some point in the interview provided with Miranda warnings?
Yes, and I feel like, he tried to trick me with that question, which is how the answer came out like that.
Okay. And again, you've seen a video of outside, right?
Correct.
Could you hear the verbal altercation that you had with Mr. Payne?
Yes.
Okay. So you did, in fact, communicate to Mr. Payne. Okay. In fact, you heard the testimony of Ms. Tara Walker, too, today, right?
Correct.
She also testified that you asked, why are you here, right?
Correct.
So you did communicate.
Correct.
Is it that you was probably confused when law enforcement was questioning you, possibly?
Yes.
Okay.
I was beyond exhausted. I was tired. I could barely keep my eyes open. It was like 10 o'clock the next day. I hadn't slept.
And again, that interview was recorded, right?
Correct.
Video recorded?
Yes, sir.
Okay. No further questions, Your Honor.
All right, sir, you can have a seat back at counsel's table. All right, defense, call your next witness.
Your Honor, defense rests.
State wish to present any rebuttal evidence?
No, Your Honor.
So state rests.
State rests.
All right, let me have counsel approach.
Oh boy, yeah, that didn't go so well for him. In a way, I feel bad for him only because I don't think he meant this. It was like a spur of the moment. He was probably drunk or at least somewhat intoxicated. I don't think he meant it per se. So I feel sorry for him for a little bit. Yeah, that didn't go well. You got 3 kids. He has 3 kids. Oof. All right, let's see if we can fast forward a little bit here. I don't think he planned it per se. I think it's like a heat of passion kind of thing.
All right, ladies and gentlemen, the state and the defense have both rested their cases at this point. There are some other legal matters that I need to take up outside of your presence, and then we will have to be working on the charge conference, which is the jury instructions that will be sent to you and the verdict forms that will be sent to you. And so what I'm going to do is, while we work on that, the remainder of this afternoon, I'm going to send you all home a little early. Okay. When you come back tomorrow, we will have those instructions ready. There will be copies and everything ready for you all. And so that we will be ready to go when you get here. At that point, I will give you all the closing argument instruction. The attorneys will make their closing arguments to you, and prior to lunch, you will then be out to deliberate. What I will ask for you all to do tonight before you leave is I'll have the court deputies give you the lunch menu for tomorrow. Make a choice of what it is that you would like for lunch so they have it, so they can order it so that it'll be available in the jury room for you around 11:45 noon tomorrow by the time you get back there or when you're out there, back there deliberating, okay? Also, make sure you get the number from the sheriff's deputies before you leave so that you can share that with your loved ones or family members who may need to get a hold of you, because you can expect that sometime mid to late morning you will be in the jury room deliberating the verdict in this case, okay? Any questions before we break for the night? All right. Same rules apply. Obviously, please don't do any investigation, any looking up of anything on your own. And I'll ask you all to come back tomorrow morning at 9 o'clock. Okay? I only have one thing else on my docket in the morning. It's a very brief matter, and I will have that done relatively shortly, so we should be able to get started right away. Okay? So I will make sure you get the menus for them. Once you get the menus, go home for the night. We'll see you back tomorrow at 9. Okay?
All right. That's for me.
I go to have a seat. All right, the close of all the evidence, any motions or matters that I need to address from either party?
Oh, yes, Your Honor. I would like to renew my motion for judgment of acquittal as it relates to the issue of, I don't believe the state has rebutted the defense's claim of self-defense. And so I would like to state, as a matter of course, in viewing the facts of the case in the light most favorable to the state, they have failed to, like, once the defendant introduces any evidence of self-defense, the state bears the burden of proving beyond a reasonable doubt that the defendant did not act in self-defense. And that's Bozeman v. State, 714 Southern 2nd, 570, Florida 1st DCA case in 1998. And it's on point here. The state didn't provide any rebuttal evidence in regards to a claim of self-defense, so we would argue that at this point, a judgment of acquittal would be warranted, at least as it relates to elements of second-degree murder with a firearm. I do understand that this is a factual issue that is usually more properly presented before a jury, but pursuant to Martinez v. State, 981 Southern 2nd 449, a Florida Supreme Court case of 2008, if the state fails to carry this burden of rebuttal in regards to not proving beyond a reasonable doubt that the defendant did not act in self-defense, the defendant is entitled to a judgment of acquittal. It even goes so far as to a Florida Supreme Court case of 1974, Lynch v. State 293 Southern 2nd 44, to defeat a judgment of acquittal in a self-defense case, the state must present evidence from which a reasonable jury could conclude that the defendant was not in reasonable fear of imminent harm, or the force used was not necessary or was excessive, or the defendant was aggressive, or the defendant was looking to retreat. The judgment of acquittal must be granted if the defendant presented a plausible case of self-defense and the state fails to rebut it with competent substantial evidence. That's what we have here, Your Honor. Mr. Dority is charged with second-degree murder with a firearm. The defendant has presented credible evidence that the defendant acted in lawful self-defense pursuant to Florida Statute Section 776.012 and or 776.013. Under Florida law, once a defendant introduces any evidence of self-defense, the burden shifts to the state of Florida to prove beyond a reasonable doubt that the defendant did not act in self-defense. So with that being said, when viewing the evidence in the light most favorable to the state, they fail to provide competent or substantial evidence from which a reasonable jury could find that the defendant was not in reasonable fear of imminent bodily harm, that the defendant's use of force was unnecessary or excessive, or the defendant was the initial aggressor, or the defendant had a legal duty to retreat and failed to do so. In this situation, therefore, no reasonable jury could lawfully reject the defendant's theory of self-defense and still find beyond a reasonable doubt him guilty. As such, pursuant to Lynch v. State, the state has failed to meet its burden under the applicable standard of law, case law precedent, and therefore judgment of acquittal is proper. Thank you.
Judge, I think there's a misconception. Obviously, just because the defendant testified doesn't mean that I have to then put on a rebuttal case, which is sort of what it sounded like opposing counsel was saying. Obviously, the defendant's story is rebutted by the evidence that was already placed on by the state, particularly Tara Walker and the video that was presented into evidence where you can hear the encounter just before the shooting and the shooting itself. She stated that the defendant, came out and that he fired, not having been, there was no threats made in his direction, that the victim didn't have a weapon, there was no weapon found in the vehicle. All of this, a jury could find beyond a reasonable doubt that he did not act in self-defense. Further, by the defendant's own admissions in his statement, just because the defendant says it's self-defense doesn't mean it is. So while he characterized what he did on that day as self-defense, it certainly wasn't. If you look at the applicable law and the instructions that you're going to give the jury, that it has to be reasonable, and it's both an objective and a subjective standard. So the defendant himself has to reasonably believe that his actions were justified and necessary in the circumstance, and even if you found that was met, objectively, a reasonably prudent and cautious person in the same or similar circumstances would have to feel the same. And his actions of going back in a house, arming himself, coming back and shooting somebody, that is not justified. That's not self-defense. So even if you just took his own words, he's not rebut the state's case that he was not acting in self-defense in this circumstance. I would point to, obviously, just going to the other point regarding the JOA, that I'd point to Mackey versus State. It's a first district case, 277 Southern 3rd, 762. It states a depraved mind, regardless of human life, second-degree murder may be established by competent, substantial evidence that the defendant acted with ill will, hate, and spite, and that the circumstances surrounding the fatal act can prove the ill will, hate, or spite. In this case, you have the circumstances around it that show it. You don't have to have an express testimony or express statement that there was malice or evil intent, spite. You can look at the circumstances as we have here, and we can clearly see that this defendant was not acting in self-defense. So I ask that you deny the JOA.
Your Honor, and briefly, I'll just add, these facts supports the judgment of acquittal. 1:30 in the morning, size difference, uninvited. You can infer that Mr. Payne wasn't coming over to wish him happy birthday. Okay? Again, had no relationship with Mr. Dority. His girlfriend told him not to come. Despite doing that, he still came. Even after Mr. Dority went into the house, just think about that for a second. If someone is objectively questioning why you're present at a certain hour at someone's home, place of residence, your castle, no, he's not inside the home, but he's lying in wait as he comes home. Very close proximity to where he lays his head, where his child lays his head. His father is in his 60s. His son is 9 years old. He's questioning why you're here. And the threat of posturing yourself as if you have a right to be at someone's home without an explanation, that placed Mr. Dority in fear. And if Mr. Payne didn't want any problems, if he didn't want any smoke, any issues to occur, when Mr. Dority retreated into his home, because he didn't just walk up to him with a firearm. He didn't walk up to him wanting a confrontation. He thought it was Tara Walker in that vehicle. She had been driving that vehicle for several months. Unknown to him, it was someone else who rolled the window down, hopped out the car, and surprise, this is not what you want, little man. Yes, it is an issue of what was said. Nobody in this room was there other than Mr. Dority and Mr. Payne. Tara Walker wants you to believe that she was there when it initiated. She was not. She admitted he was already there. She claims to have been on the phone with him and heard some chatter, but she can't say conclusively what was said. But if you didn't want any problems, reasonable people would acknowledge the fact that when someone goes into their home and you are now on notice that you are not wanted there, he could have left. But instead of him doing that, what did he do? With his 6'8" frame, 247 pounds, he moves up closer to the man's driveway. That places somebody in fear at 1:30 in the morning. Coming home and somebody you don't have a relationship with waiting on you, and you ask them why you're there. By the time you go in that house, he needs to be gone when you come back outside. That didn't happen here. This is common sense. The way the legislature works with these gun laws, this is not like a random shooting that happened in New York, just shooting bystanders. Even Governor DeSantis is pro-guns. He removed the need to have a concealed weapon permit. For situations like this, he's at his home. He asked him to leave. Even Tara would agree. He asked, why are you here? All this chatter about you told law enforcement you didn't communicate. The video itself shows there was communication going on. Tara herself said that it was communication going on. Whether he was giving Miranda or not doesn't matter. He gave a statement. So that don't even matter.
Your Honor. At the very least, before we let this get to the jury, if you find that it needs to get to that point, which I submit to you, you should not. But if you find it that it's necessary to let the jury deliberate, they should not be deliberating over second-degree murder with firearm. That is an overcharge. That is not what we have here, by any stretch of the imagination. Not that. Maybe negligent homicide, maybe. Something definitely lesser than second degree should go to this jury. Not second degree murder. He shouldn't be facing life for that. That's not what the people of Florida support. The public would not be...
Judge, I'm going to object to this improper argument talking about what the people of Florida would support.
Staying, let's confine our argument to the facts and what the standard is for a judgment of acquittal at the close of the case.
I have nothing else, Your Honor.
All right. Based upon the evidence that's been presented to the court and the standard that applies at the close of all the evidence, the court does find that there is sufficient evidence to allow the case to continue to the jury, so the judgment of acquittal will be denied. Counsel for the state provided a copy of, or a draft of verdict forms and a draft of jury instructions to the court. Mr. Thompson, did you get a copy of those?
Yes, Your Honor, I did.
All right. And did you have a chance to review them with your client?
Not thoroughly with my client, I did not.
Do you have a copy of them on your computer that you can pull up?
I do.
Okay.
Oh, yes, Your Honor, I did send this to him.
Okay.
We discussed.
All right, Mr. Dority, did you get a copy of that was sent to you by your lawyer?
Yes, Your Honor.
Was that a yes?
Yes, sir.
Okay. And did you have a chance to read through it?
Yes, Your Honor.
And did you and your attorney have a chance to discuss it?
Yes.
Okay. What I'm going to do is you have a copy of it now up, Mr. Thompson, so you and your client can see it?
Yes, Your Honor.
State, have yours up?
Yes, Your Honor.
Okay. So we'll just kind of go through it. I assume nobody has any objection to the caption?
No objection.
No objection from the state.
All right. And then there's the standard instruction on final instruction or introduction to final instructions. Anybody have any objection to that?
No objection, Your Honor.
No objection.
All right. The next standard instruction has to do with the statement of the charge. Any objection?
No, Your Honor.
No, Your Honor.
Next instruction is the introduction to homicide instruction. Any objections?
No, from the
No
state.
objection.
All right. The next one is justifiable homicide instruction. Any objection?
I don't have that in that order. So my page 5, it goes from excusable homicide and then into second-degree murder on page 6.
Well, the one you sent me had an introduction to homicide instruction, then a justifiable homicide. It's probably part of the introduction to homicide.
Okay.
If you go down
Yes, sir.
in there,
I see. Yes.
I break it out as a separate instruction.
Okay.
I have the same thing.
Okay, so, but it's part of the introduction to homicide, but it's a separate little subsection that says justifiable homicide. Nobody has any objection to that.
No objection, Your Honor.
No from the state.
And then right under that is another subsection for excusable homicide. Any objection to that?
No objection.
No from the state.
All right, and then the next instruction is the second-degree murder instruction. Take a look at that. Tell me if anybody has any objections to the second-degree murder instruction.
No objection other than what's previously been argued.
I understand that you're reserving your right on the judgment of acquittal.
No objection from the state.
All right, and then the next instruction is the standard instruction on aggravation of a felony by carrying a firearm. Any objections?
No objection, Your Honor.
No objection from the state.
Next one is the standard instruction on possession of a firearm, discharge, and causing death.
No objection.
None from the state.
All right, the next one is the standard instruction on when there are lesser included crimes.
No objection.
No objection from the state.
All right, and then the lesser included crime is defined as manslaughter. Any objection to that instruction?
No objection.
No objection from the state.
All right, and then there is a repeat of the aggravation of a felony by carrying a firearm as it relates to the manslaughter. Any objection to that instruction?
No objection.
State.
No objection from the state.
All right, and then there's the justifiable use or threatened use of deadly force instruction. Take a look at that.
I have this highlighted. I don't know. Yeah, there's different language, and the defendant has to affirmatively state what if they're seeking the part B, which I put in as aggravated assault, just based on prior arguments that they had made at the stand your ground hearing. That would sort of be my anticipation of what they would be asking for regarding the forcible felony. But if that's not what they're asking for, obviously we'll need to go in and change that.
That's why I'm asking the defense to take a look at it and see if they have an objection or if they're asking for any changes.
No objection, Your Honor.
Okay. I assume the state has no objection.
No objection.
All right, then we get to the standard instruction on plea of not guilty, reasonable doubt, and burden of proof. Any objection to that?
None from the state.
No, it looks standard. No objection.
Then we get to the standard weighing the evidence instruction. Paragraphs 1 through 5 were included, and then I added the sixth, or there is a sixth paragraph added that included making inconsistent statements in court. Does anybody believe that the other 4 paragraphs apply? I don't think that they do, but
I believe the 6 that we have are appropriate.
Defense?
I agree, Your Honor. I don't see what the other ones were. That's all I received. I didn't receive the other ones.
Well, the other ones usually have to do with reputation and for dishonesty, criminal convictions. None of that kind of stuff came out.
I have no objection.
All right. And then the next standard instruction is the defendant's statement instruction.
It's missing the caption, I think, maybe, at the top.
Where it says defendant's statement?
Yes, Your Honor.
I have it on my copy.
I don't have it on mine. Well, I have it. The next page has it.
All right, there you got it. Any objection to that instruction from either party?
Not from the state.
No objection, Your Honor.
Okay, that gets us to the rules for deliberation, standard instruction. Any objections?
None from the state.
None from defense.
All right, and then the standard instruction for cautionary instruction, any objection?
None from the state.
None from defense.
Standard instruction on verdict, any objections?
None from the state.
No objection.
And then the standard instruction on submitting the case to the jury. Any objections?
None from the state.
No objection from defense.
All right. And Mr. Dority, you've had a chance to go over this as we've gone through it here in court. You had a chance to go over it previously with your attorney. Is that correct?
Yes.
All right. And you agree with the choice of lesser included offense for being manslaughter?
Yes.
Okay. And are you in agreement with the instructions as your attorney has indicated?
Yes.
And then for purposes of closing, I assume, counsel, you're going to again concede elements of the offense or the lesser included offense, but as part of your self-defense claim?
Yes, Your Honor.
All right. And so, Mr. Dority, as you indicated to me previously, you understand that that's the strategy that you and your attorney have agreed upon for purposes of this case? All right. So you understand that during the closing argument, as he did during the opening argument, he may be making concessions that the shooting happened, but his claim is that it was self-defense. You understand that? And you're in agreement with that strategy?
Yes, sir.
All right. right, so the verdict forms then are finalized. I will have my assistant make multiple copies. I'll make 2 for you all, so you all each will have a hard copy. I'll make a copy for the state. Rebecca, do you need one? All right. I'll make 1 for the clerk, so that's 4. And then we need 8 for the jurors, so I'll make a total of 13 so that I have 1 to read from. I'll make those copies. I will make sure that I have them all here. We'll disseminate them for the jurors in the morning, and I'll have copies for you all ready when we come into court, okay?
Thank you, Your Honor.
All right. So, and then as far as the jury verdicts go, you got a copy of those, Mr. Thompson?
Yes, Your Honor, I do.
All right, and you forwarded that to Mr. Dority as well?
Yes, Your Honor, I do.
All right, Mr. Dority, did you get a chance to look at the verdict forms? Okay. All right, the verdict form as to count 1 gives the jury 3 options: second-degree murder, the lesser included offense of manslaughter, and not guilty. Any objections to that verdict form?
No from the state.
No objection from the defense.
And then there are 4 special findings based on the way that the case was charged. The first special finding has to do with possession of a firearm or no possession of a firearm. Any objection to that special finding?
None from the state.
No objection, Your Honor.
The second special finding has to do with discharge of a firearm or no discharge of a firearm. Any objection?
None from the state.
None from defense.
The third one has to do with discharge causing death or not causing death. Any objections?
None from the state.
None from defense.
And then the fourth special finding has to do with personally carrying, displaying, using, threatening to use, or attempting to use a firearm or not. Any objections?
None from the state.
No objection.
All right, so the verdict forms and special findings are in order, and I will have my assistant make 1 copy of those for the jurors. All right, anything else that I need to address from the state or defense before we adjourn for the evening?
Nothing else from the state. I know some judges have different, when you're saying what you're going to send back with them, the jury room, some judges will send everything back, some judges don't want to send the firearm back. I don't know what you were planning to do regarding the firearm and the defense out of position.
All right. I know that sometimes in the past they've done that where they've rendered them safe and sent them back, but if you all aren't comfortable doing that, then we'll send everything back with the exception of the firearm. I'll let the jury know if they want to see the firearm, that they can ask me with a note to see it.
Understood.
Okay?
Yes, Your Honor.
All right. Anything else from the state?
Nothing further from the state.
Anything further from the defense? Thank you. All right, then we will be in recess on this case till 9 o'clock tomorrow morning.
Thank you, Your Honor.
All right.
apparently there's a jury question in the Ali case if you guys want to go over there. Okay, hold on.
Thompson on behalf of Mr. Dority.
Mr. Dority is also present. All of our jurors are back. I have handed out copies of the jury instructions to all parties. There's copies for the jurors, and I do have the verdict forms up here that we all discussed yesterday. Any other matters or issues that I need to discuss or take care of from the state?
No, Judge, just for as far as jury instructions, do you read the majority of the instructions before closing or after? I think judges split them differently.
I don't have a preference.
I typically prefer the majority of them to be read before, but again, that's obviously, I don't know what the preference is or you typically do.
I don't have a typical practice. If you want me to do it, I'll do it. If you don't want me to do it, I won't do it. If you want me to do it, tell me where you want me to stop at.
Mr. Johnson, do you have
I have no preference either way. I have no preference either way.
I would suggest potentially going up until rules for deliberation, stopping there, and then closing arguments, and then going to the rest of the way from rules for deliberation. It's on page 12 of your instructions. Or 13.
Okay, so you read up through the rules for deliberation, stop there, have you do your closings, and then read those remaining 3 or 4 instructions and send them out.
That would be the state's preference, if everybody else is in agreement.
Any objections?
No objection, Your Honor.
Okay, then I'll do that. Anything else from the state that I need to address?
Nothing further from the state.
Anything from the defense?
Nothing.
All right, we discussed yesterday, each side's agreed to do their closings in 45 minutes or less per side.
Yes, Your Honor.
Yes, Your Honor.
Okay. All right, we do have all the jurors back, so let's go ahead and bring them in. All right, have a seat. All right, ladies and gentlemen, welcome back. I trust that you all complied with the instructions. You didn't do any investigation or any research on your own or have anybody have any contact with you reference this case over the evening, correct? All right. When we spoke yesterday, both the state and the defense had rested their cases. The court released you all early so that we could finish the jury instructions and the verdict forms. We have completed that. You do have a copy of them. You're free to take those back into the jury room with you. What we're going to do is I'm going to split up the way that I read the jury instructions a little bit. I'm going to read the majority of the jury instructions through about the top of page 13 to you now. I am required to read the jury instructions to you. I give you a copy so that you can take them into the jury room with you, but I have to read them out loud to you. The reason I'm reading the first about 12 pages to you is so that you hear from me what the law is that applies to the case before the lawyers argue to you what the law is and what the facts are that may apply to that law. So you'll have heard it from me first so you know what the law is as they make their arguments. Then they will do their closing arguments, and then I will pick up on page 13 with the last few instructions before I send you out and go over the verdict form with you to let you deliberate, okay? All right, so with that said, we'll go ahead and start with the reading a portion of the jury instructions before they do their closings. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Lawrence Alexander Dority, the defendant in this case, has been accused of the crime of second-degree murder with a firearm. In this case, Lawrence Alexander Dority is accused of second-degree murder with a firearm. Murder in the second degree includes the lesser crime of manslaughter, which is also unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Adreian Payne was killed by Lawrence Alexander Dority, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and adequate provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Lawrence Alexander Dority may be found guilty of second-degree murder or any lesser included crime. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Adreian Payne is dead. 2, the death was caused by the criminal act of Lawrence Alexander Dority. 3, there was an unlawful killing of Adreian Payne by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another person and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Lawrence Alexander Dority did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Lawrence Alexander Dority was in fact so provoked and did not cool off before he committed the act that caused the death of Adreian Payne. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of second-degree murder with a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused the death of Adreian Payne, you should find the defendant guilty of second-degree murder with discharge of a firearm causing death. A firearm is legally defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. To prove the crime of manslaughter, a lesser included offense of count 1, the state must prove the following two elements beyond a reasonable doubt. 1, Adreian Payne is dead. 2, Lawrence Alexander Dority intentionally committed an act or acts that caused the death of Adreian Payne. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Lawrence Alexander Dority committed manslaughter, and you also find beyond a reasonable doubt during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm, again, is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. It is a defense to the crimes of second-degree murder and manslaughter if the actions of Lawrence Alexander Dority constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Lawrence Alexander Dority does not have the burden of proving that he was justified in using or threatening to use deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force is as follows. Lawrence Alexander Dority was justified in using or threatening to use deadly force if he reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to himself, or the imminent commission of a forcible felony, aggravated assault, against himself. The definition of aggravated assault is as follows. An aggravated assault is an assault with a deadly weapon without intent to kill. An assault is an intentional, unlawful threat by word or act to do violence to the person of another, coupled with an apparent ability to do so, and doing some act which creates a well-founded fear in such other person that such violence is imminent. Lawrence Alexander Dority had no duty to retreat before using or threatening to use deadly force. In deciding whether Lawrence Alexander Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. However, the use or threatened use of deadly force is not justified if you find that Lawrence Alexander Dority used force or threat of force to initially provoke the use or threat of use of force against himself, unless, 1, the force or threat of force asserted towards the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using or threatening to use deadly force on the victim, or 2, in good faith, Lawrence Alexander Dority withdrew from physical contact with Adreian D'Angelo Payne and clearly indicated to Adreian D'Angelo Payne that he wanted to withdraw and stop the use or threatened use of deadly force, but Adreian D'Angelo Payne continued or resumed the use or threatened use of force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Lawrence Alexander Dority and Adreian D'Angelo Payne. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? And 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you applied to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, 1, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, I'm going to stop reading the jury instructions. At that point, I will pick up with the remainder of the jury instructions after the attorney's closings. As I indicated, both the state and the defense have now rested. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence, nor your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Does the state wish to give their closing at this time?
Yes, Your Honor.
You may.
Thank you, Your Honor. May I please report? Carol Walker pled with the defendant not to take his gun out. She pled with him, don't take your gun out. Over again, don't take your gun out, Lawrence. We were asked to come here. She pleaded with him not to shoot Adreian Payne that night. But he didn't listen. Instead, he proceeded to take his gun out, take deadly aim, and shoot and kill Adreian Payne. It wasn't justified. It wasn't in response to a reasonable threat. It was just because he was intoxicated and he was mad. Not in the heat of passion that would be justified by law, but just because that's how he felt like, what he felt like doing that night. Not justified. Now, this was a relatively short trial. You heard from 6 state witnesses, as well as the defendant, including Tara Walker. And obviously you heard from the witnesses yesterday, so you probably have fresh memories of what was said, but I want to go through and touch on what I think are important points for you to remember when you go back for your deliberations. First, you heard from Corporal Garrett Morris. He was one of the first responding officers on scene. Now, he came to the scene and he found the victim suffering from a gunshot, and he was still in his vehicle. Now, you heard from the testimony, he was a large individual. He was 6'8", and they had difficulty getting him out of the vehicle. They were able to ultimately get him out. He tried to render aid on the ground at CPR with another officer. Unfortunately, he was unsuccessful. Now, you heard as part of protocol for when responding to a scene like this, a shooting, that he checked for weapons on the victim's person. And you can actually see on his body camera video that you saw that he did check both a pouch that the victim had on and as well as his pockets. No weapons. You also heard from CSI Hannah Miner, who testified yesterday morning as well. She was the lead CSI in the case, and she was in charge of documenting the entire scene, including the inside of the victim's vehicle. And you saw her documentation of that scene produced no firearm. There was no firearm in the vehicle. There was a kitchen knife in the passenger floorboard that you heard from Tara Walker was put there by her after a dinner that they had picked up. You also got to see from CSI Miner's photographs sort of a layout of the scene. you got to see that the victim's vehicle wasn't parked right in front of the defendant's house, but down the street a ways, at least a couple of residents down. You saw that the vehicle wasn't on his property. It wasn't on anything adjoining his property. You got to see the distances between the defendant's door and where the victim had parked. You got to see her photographs detailing her search of the defendant's residence where the firearm was found. And you saw the firearm itself, which is in evidence. You heard briefly from Marco Quintanar, who was a neighbor in this incident. He didn't see anything, but he heard gunshots, which caused him to look at his surveillance camera, and he was able to find video that captured audio of this shooting. And of course, you heard from Tara Walker, the victim in this case's girlfriend, the mother of his child. She told you that she responded to the area of the defendant's house after receiving a call from her best friend, Tatiana Mesa. That she then spoke with her boyfriend, Adreian, who said he was also en route there as backup to her. Now, you heard that she got there just after Adreian had arrived and saw the defendant sort of walking away after apparently having words with Adreian going back into the house. You heard she had a brief conversation with him. He was going to move his car so she could fit to park on the street there. And then you heard that's when things took a turn. The defendant came back outside the house. He didn't stay in the house. He didn't lock the door. He didn't call 911. None of that. Instead, he arms himself with a firearm, taking the time to do that. He comes back out, and when Tara Walker sees him, she notices that he seems to have a gun. And she says, and you can hear on the audio, "Don't take your gun out. Lawrence, don't take your gun out. We were called here." But then she told you he didn't listen. He does take the gun out. You can hear the escalation in her voice. While you can't see the incident, you can hear it play by play from her voice on the video and the shots themselves. And you hear just after that, after he's been warned, after he's been told while they're there, you hear the shot ring out. And then you hear screams. Because the defendant had killed Adreian Payne for no justifiable reason. And you hear that in that surveillance. You then saw on the video, and you heard from her, that she ran down to a neighbor's house. She tried to get help. And then she continued running, trying to get help from other neighbors. And then ultimately, when law enforcement came back, she was back to the car to try to render aid to her boyfriend, who unfortunately succumbed to the injuries. Now, you also heard from the medical examiner in this case, Dr. Marie Hansen. She told you about her extensive experience as a medical examiner since 1990. She told you about the autopsy she performed in this case. And she told you about the positioning of the victim's body when he was shot, that his arm would have had to have been up like this and to go through his torso for the shot. She said that was consistent with, and obviously she wasn't there, so she can't say specifically, but it was consistent with someone having their arm either perched on a door frame or on a steering wheel, just as Tara Walker said. She also said that based on the position, it's likely that the thumb was down. That's not a position that someone would be pointing a firearm, which we know that the victim in this case never had. But instead, a position of somebody that's by his car or in his car, nowhere near this defendant's residence, not on his property when he was shot. You heard from the medical examiner that the cause of death was that gunshot as it went through and pierced the aorta. And you heard that the manner of death was homicide. You also heard from firearms expert with FDLE, Kristen Killinger, just that confirmed that the gun that was found in this defendant's home was in fact the gun he used to kill the victim in this case. And that the bullet that was removed from the victim in his autopsy was in fact fired from that defendant's gun. Now, you also heard from the defendant in this case, and part of your job, as is your job with all the witnesses that testified, is to weigh their credibility. Now, the judge just instructed you with an instruction on weighing the evidence And it goes through the factors that you look at when weighing the credibility of a witness that testifies. And that's your job as a juror, to go through that with each witness and determine what you find credible and what you find to be not credible. Now, I want to talk about some of those that are of particular importance, I believe, to this defendant's testimony. Did the witness seem to have an accurate memory? Well, you heard his testimony as he said certain things with his counsel, but then when I questioned him about it, I said, well, it had been a long day, I'm not sure, I might not have said it. Did you find that to be credible? Was the witness honest and straightforward in answering questions? Well, he was barely audible when answering questions from his attorney, but he was at least cooperative. But then when I asked him questions, you saw his response, talking around the question, not giving me direct answers, having to be impeached multiple times with his previous statements. Did the witness have some interest in how the case would be decided? Well, no one that you heard from yesterday has more of an interest in how this case is decided than the defendant, obviously. Did you find his demeanor on the stand to be credible? Or did you see the tears, if there were any, to be crocodile tears that he was trying to force to gain sympathy from you? What do you believe? Did his testimony agree with the other evidence in the case? Well, no, it was in conflict with the testimony of Tara Walker, and that testimony of Tara Walker is corroborated by the video and the audio from the surveillance video. And did the witness at some point make statements inconsistent? Well, several times. I mean, just out of the door in his direct testimony, he said he had never been Mirandized, but then obviously he was impeached on the transcript of him being read Miranda. He said that he, didn't initially, so they didn't try to talk to the victim when he came back out. He didn't communicate with him. He shot him. That's what he said just after this murder. But then after watching all the evidence, he gets on the stand and says he came out there and was trying to, talk, please leave, please leave. First of all, I question that is the demeanor that he came out and was asking Mr. Payne to leave. But also, Adreian Payne was not on his property. He was on a street that was not even touching his property, and he didn't have any less of a right to be there than the defendant. He also said definitively, as you heard in his direct testimony, he definitely saw a gun, but he never said that in his initial statement. What he said is he thought he saw the outline of a gun. He's not sure, to be honest, he's not sure. That's what he originally said, but after hearing the evidence and realizing what needs to be said in order to convince you that he was somehow justified in his actions, that's what he said on the stand. But it's not consistent with what he said before, and it's not consistent with the facts and evidence in this case. Now, from the evidence in this case, it is clear that this defendant is guilty of second-degree murder with a firearm. The judge just went over with you the elements of that offense as well as the lesser-included offense of manslaughter. But I want to take a minute and go through those with you as well and go through the facts as the state believes they apply. So the judge will instruct you and you have in your packet that you are to convict of the highest crime proven beyond a reasonable doubt. And that's second-degree murder. Now, here there's a lesser-included offense of manslaughter, but I want to be clear, and I'm going to talk about manslaughter, but I want to be clear. In jury selection and in these instructions, you're going to be told to not let sympathy or concerns about sentencing impact your deliberations in this case. So if you believe that we've proven this case beyond a reasonable doubt regarding second-degree murder, it is not appropriate to say, well, maybe he was scared even if it wasn't justified, or maybe whatever the situation is, he's, not that old, I don't want him to, go to prison for a long time, or whatever the case may be. That is not appropriate. That is not the consideration for the jury. You are to convict of the highest offense proven beyond a reasonable doubt, and that's second-degree murder. But I'm going to talk about manslaughter because we have proven the elements of manslaughter as well, as it is a lesser-included offense. So to prove the crime of manslaughter, the state must prove it's just two elements. And there's a couple of big differences between manslaughter and second-degree murder. First, there's just two elements. There's three elements to second-degree murder. Manslaughter does not require any type of mental state. So second-degree murder requires that he acted with what the law calls a depraved mind. I'm going to talk to you a little bit more about that in a minute. But manslaughter does not require that. It just requires that A, Adreian Payne is dead, which is stipulated to. Obviously, we've established that he is deceased, and that the second element is Lawrence Dority intentionally committed an act or acts that caused the death of Adreian Payne. Now, obviously, in this case, that act is taking his gun and intentionally shooting him. That's it for manslaughter. Now, you're going to see that for second-degree murder, there is an instruction regarding heat of passion. That doesn't apply to manslaughter. So the two things that you can consider for manslaughter for elements are that Adreian Payne is dead and that the defendant committed an intentional act that caused the death of Adreian Payne. We've proven manslaughter. We've met those elements. But you should not convict him of manslaughter because that's not the highest crime proven. So I want to talk about second-degree murder. I'm going to put it up here. I know you have it in your packets, but I want to talk about it in a little bit more detail. And if you can't read it exactly on the screen, again, I say you have it in your packets. It is on page 3 of your packets. But so there's the same. The first element is the same, that Adreian Payne is dead, and that the death was caused by the criminal act of Lawrence Dority. That criminal act is taking his firearm and shooting him while he's sitting in or by his car. The third element is the difference, that there was an unlawful killing of Adreian Payne by an act eminently dangerous to another, demonstrating a depraved mind without regard for human life. So, ladies and gentlemen, I pose to you that obviously taking a firearm and shooting another human being demonstrates a depraved mind, and eminently dangerous to another and depraved mind is defined for you. It says a person of ordinary judgment would reasonably certain to kill or do serious bodily injury. A normal person knows if you take a gun, you point it out, and you pull the trigger, it's going to cause bodily injury, or it's going to kill him. It's done from ill will, hatred, spite, or evil intent. And I want to point out that these are ors. So you can find that it was done from ill will. He was upset that he was outside his house. Hatred, maybe he was that mad that he was outside his house. Spite or evil intent. You can find any of those. You don't have to find all of them, but if any of those satisfy the depraved mind requirement. And he certainly had that, and his actions demonstrate that he had that. And then finally, is of such a nature that the act itself indicates an indifference to human life. And again, some of these things overlap with each other. Obviously, again, taking a firearm, pointing it, and shooting at another human being shows that you're indifferent to that person's life. Now, with second-degree murder, we do not have to prove an intent to cause death. So that's not something you consider. Maybe he just wanted to injure him or whatever the case may be, if that's what you believe. I think the facts show that he took deadly aim and intended exactly what happened, but you don't have to find that. You don't have to find an intent to cause death, just that he had an intent to shoot him. So then there's the portion that talks about the heat of passion. And there are some subsections here, A through E. But each of them talks about an ordinary, reasonable person. So it's not just, well, I was scared, so I did it. That's not sufficient for heat of passion under the law. It's not sufficient to say, I was upset, and so I did this thing, and I'm excused from it being second-degree murder. No. There must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. Again, that language, ordinary, reasonable person. And again, I want to point out, too, all of these are ands. So you have to find all of them for these actions to be reasonable. A reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. So the question is not just, was this defendant in a blind, unreasoning fury? He was certainly not acting reasonably, but would a reasonable person have acted that way? No. There was not a reasonable amount of time for a reasonable person to cool off. This defendant took time. He went in his house. There was no threat at that point. He wasn't pursued. He armed himself. He came back out. There was no further threat. He's being begged and pleaded with to not do what he did, but he still did it. So he certainly could have cooled off when he went in the house. And then another and also has to be met. A reasonable person would not have cooled off. So say he was so upset by whatever interaction that they had out by the victim's vehicle before he went in the house. A reasonable person, when they go in their house, can shut the door, can lock the door, can do whatever, can cool off, before coming out and doing what he did. And then finally, he was so provoked that he did not cool off before he committed the act that caused the death. So it's not just a matter of, I was scared, this was a scary situation, and therefore I did this and I should be excused of second-degree murder. No, you have to look at it based on a reasonable person. And the defendant in this case and his actions were anything but. So the defendant in this case took the stand and claimed that he was acting in self-defense. He was justified in his use of deadly force. But that is not the case when you look at the facts. The defendant's actions were not reasonable. The judge has given you a lengthy definition of justifiable deadly force. That's on page 8 of your packet. And for something to be justified, it must be both an objective justification and subjective. And I want to go through a specific paragraph that is in your instructions that explains that and how that works and what you're to consider. The second from the bottom on this page, I don't know on your packet, but it starts with in deciding. So the judge has instructed you, and you're going to have this in your packet, in deciding whether Lawrence Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force threat was used. So that's important because he didn't use the force, when they first had words and he decided to go in the house. This is after he had gone back in the house, had time to cool off, arm himself, and come back out. And other people, were present at this point, including Tara Walker. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. So first of all, this wasn't threatened use of deadly force. I guess maybe it was in the moments just before he pulled the trigger, but this was deadly force. He did pull the trigger in this circumstance. And he himself must have actually believed in that moment that it was necessary to do what he did. Not that he wanted to, but that it was necessary. And beyond that, even if beyond just necessary in his mind, moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed that the use or threatened use of deadly force was necessary. A reasonably cautious and prudent person. This defendant's actions were not the actions of a reasonably cautious and prudent person. That's for you to decide when you look at the facts of the case and you look at the evidence. But the evidence has shown that what he did was not the actions of a reasonably cautious and prudent person. The defendant in this case was not standing his ground. He was the aggressor. He was the person that initially approached a car parked on the street. This person wasn't knocking, on his door, wasn't standing on his lawn. He was sitting in his car with the window rolled up. He was the one that made even an initial contact. This was not an act of defense, and it certainly wasn't an act of reasonable self-defense. He took a life not to protect his own or to protect his family. He took it because he wanted to, because he was upset. His actions show a depraved mind, and he's guilty of second-degree murder. We ask that you convict.
All right, defense.
Your Honor, maybe approach more briefly.
Come on.
Good morning, ladies and gentlemen. Good morning.
I'm going to stay at the podium this morning because that I really want you guys to hear what I have to say. Let's forget all the antics, okay? You remember during jury selection, I said we was going to have a real conversation, right? Real conversation. And the state and I felt like you guys were the most suitable jurors after Dyer, okay? There's three sides to every story. I know you probably heard that before. One person's version of what happened, another person's version or perspective of what may have transpired, and then there's the truth, right? The truth, ladies and gentlemen, is you at this point. You determine what the truth, what the facts are in this case. You have the ability to give us justice here today. Okay? In my opening statement, I explained to you all what you would hear in this case. And I submit to you that the defense kept its promise. Okay? We kept our promise in this case. This is a case about self-defense. This is a case about reasonable doubt. Now, the state has rested, the defense has rested, and we both are asking you to use your God-given common sense. Consider all the reasonable inferences that comes from the facts that you heard and saw today and throughout the scope of this trial. Consider what you heard, what you didn't hear, what you saw, what you didn't see. Use your common sense, okay? This case is not for the weak at heart. We selected you guys hoping that you wouldn't just have sympathy one way or the other, just unbiased, impartial citizens. This is your highest civic duty to sit on a jury. This is literally the highest mode of citizenship you can have. Sitting right now, being in judgment, to decide whether someone should be found guilty for a crime that they've been accused of, and falsely accused of at that. Okay? I thought about this last night when I was summing up the evidence in this case, and a huge question just jumped out in my mind. And I already had been thinking about it throughout the scope of representing Mr. Dority, but after the trial when the state actually presented and showed their hand. You know what that question was? Where's the proof? Where's the proof? The state has a burden, a high burden, that they have to overcome. And I submit to you, the state has not met their burden. They did not. It's not your job to stack inference upon inference upon inference to come to a conclusion that Mr. Dority did not act in self-defense. If you have a question in your mind right now, an unanswered question, if you have an unanswered question in your mind about the facts of this case, if something's not sitting right with you, if something's troubling you, if it's something that you would have wanted to see or needed to see to come to a conclusion and you can't make sense of why you didn't get that, why you didn't hear that, that's reasonable doubt.
Objection, misstatement of the law.
Sustained. I've given you what the instruction is on reasonable doubt. You have it in writing. You should consider that, not what the lawyers argue. Understood?
I'll go directly to the jury. The court has already given to you. And again, you guys use your common sense, okay? And I'll say this a little differently. Mr. Dority is not required to present any evidence or prove anything at all, number one, right? That's not his job. He could have sat at that table, played tic-tac-toe. He could have been texting if the court would allow. Of course, the courtroom doesn't allow that, but you get what I'm saying. He didn't have to do anything, okay? Proof beyond a reasonable doubt does not mean proof beyond all doubt. Of course not, all right? Reasonable doubt is not merely a possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. If you have an abiding conviction of guilt. On the other hand, this is what I want you to really pay attention to. If after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if you having a conviction is one that's not stable, one that wavers, vacillates, then the charge is not proved beyond a reasonable doubt. And guess what? You must find him not guilty. Not may, you must do it. So, nobody in this courtroom other than Mr. Dority, I don't know if Ms. Walker's in here, at some point, no one, neither of you, the court, myself, the state, was at 2529 Egret Shores Drive on May 9th, 2022. Right? Everything we say is like our best efforts to try to advise you of what happened that morning around 1:30 a.m. It's a very serious case, ladies and gentlemen. And it's a sad fact fact that, unfortunately, it's a large sum of people who are murdered every year. And we ask you not to just base this case off that type of sympathy that someone lost his life. We acknowledge this is a very sensitive, sad situation. Both families have been impacted. So out of respect for both families, this is a tragedy. But Mr. Dority didn't go looking for trouble. When tragedy happens, right, it becomes a duty of law enforcement to be competent, careful, timely, diligent in the performance of those duties, especially when investigating homicides and violent felonies, and doing it without a bias, without a rush to judgment. So let's talk a bit about what the evidence did show, right? The evidence revealed that neither Mr. Lawrence Dority or Lawrence Dority's fiancée, Tatiana Mesa, invited Mr. Payne over. You didn't hear from Tatiana. You didn't hear that from her mouth, that she invited Tara over. Where's the text message? You remember that? Tara Walker wants you to believe she was texted by Miss Tatiana Mesa to come over. Did you see a text message? Where's the proof? The evidence showed that even Miss Tara Walker advised her boyfriend, Mr. Payne, not to go over to Mr. Dority's house. She admitted to that fact. But why? Why was he there? Why was she there? The crime scene was contaminated. And I'm going to expound upon that a little bit later. That's very important. It's so very important to this case. Fatal to the state's case. It's fatal to the state's case. There was evidence that was not properly secured and processed. Tara Walker's testimony is not credible. There's inconsistency in the state's case. There's lack of evidence in the state's case. And when you go through the jury instructions, that is a factor that tends to go towards reasonable doubt. When there's inconsistency in the evidence, lack of evidence, inability of witnesses to recall what happened, you know. Mr. Dority's actions were justified under the circumstances of this case, ladies and gentlemen. Mr. Dority was standing his ground. Let's talk a little bit more about what you heard over the course of the trial, though. Now, in the opening, the state conceded that Mr. Dority and Mr. Payne had brief words, right? So all this badgering Mr. Dority on the stand about him allegedly telling a detective that he made no comment, that he just walked out the house and shot this man. Ladies and gentlemen, you heard it on the video that it was verbal. Not only that, Tara Walker, even though she didn't want to really say what happened, she said she pulls into the neighborhood, pulls up to the house, and sees her boyfriend standing outside the car, sees Lawrence Dority talking to him, and based on her words, communication was happening. Such a soft word, right? They was just communicating at 1:30 in the morning. Just communicating. That's not what happened. The state tried to create some sense of a factual inconsistency, knowing the fact of the matter is that the evidence revealed there was in fact a verbal altercation outside of Mr. Lawrence Dority's home at 1:30 in the morning, and Mr. Payne's vehicle was outside of Mr. Dority's house. Feel free to ask for a read back of the opening statement if you don't recall that.
Objection. The opening statement is not evidence.
Sustained.
The state made no mention of Mr. Payne's girlfriend being present during the initial altercation either, because she wasn't. Mr. Payne arrived before her. They didn't meet together. You remember? She was saying that at some point she decided to text him and say, hey, I'm headed over to Tatiana's house. I don't know, something's going on, something. And he took it upon himself, oh, I'm going to go over there too. I'll meet you there. No, don't go. No, I'm already on my way. I'm on the 408. I'm on my way. Don't even know where he stayed at. Driving around the neighborhood, cabins in the neighborhood, looking for my client's car. 1:30 in the morning. So at some point during the verbal altercation, Tara Walker arrives. Mr. Payne actually walks up to her car. And at some point she tells him to get back in the car and move his car up some more, closer to the house. But do you remember what Tara said? That when she first arrived, that the first person she talked to was Larry Dority, Mr. Lawrence Dority's father. And what did Mr. Larry Dority say to her? Tara, get back. I'm about to go get my gun. Now, if it wasn't a threat that appeared imminent or of some sense of seriousness, that's consistent. Use your reasonable inferences. You're allowed to use reasonable inferences. So that's one fact that's admitted by the state's own witness. The state has proven the defense's case. When Tara Walker pulled up, Larry Dority told her to get back. I'm about to get my gun. She said, no, don't do that. That's my son's father. That's my boyfriend. Oh, I've never seen him before. That's a big fella. How big is he? Wait a minute, let me see. Medical expert Dr. Hansen said he was 80 inches. Mr. Dority, could you stand up for a second? With your permission, may I ask my client to stand up, please?
That's fine.
See what Mr. Payne was doing, he was coming to try to pick a fight. He was trying to be intimidating. He wasn't coming to sing a Christmas carol outside his house at 1:30 in the morning. He wasn't delivering for Uber. He wasn't delivering for Amazon. He had no right to come to his house. Now, if you believe he has a right to be in the street, just parked outside, just waiting, lying in wait for someone with your car running, headlights on, just sitting in the car, and then when someone walks up thinking that you're someone you know, you hop out with a threatening gesture. Mr. Dority goes in the house. A reasonable person, you know what a reasonable person would do after having an argument outside of someone's home that you don't have a right to be at 1:30 in the morning? And when that person gets ready to go in the house, after you threaten the person and he goes in the house, by the time he comes back out, you should be gone. But guess what? He moved up a little bit closer. And guess what? Mr. Dority's son was still outside, who was 9 years old at the time, 8 or 9, give or take. His dad was 62 years old. There's inconsistency in the evidence, ladies and gentlemen. There's lack of evidence in this case. So, let's talk about Deputy Garrett Morris. He was very forthcoming very forthcoming and candid, professional. He arrived at the scene. You could see his body camera. He rushed over, and basically he was administering life-saving measures to try to revive or try to just get some sense of keeping Mr. Payne viable till paramedics can arrive. You know, he arrived, he located Mr. Payne in the driver's seat at that time, one left foot out of the vehicle, right foot in the vehicle, you know, but he wasn't all in the car the whole time now. Only after this shot hit him and set him down, he went and got in the car. Because you remember, I was talking about Dr. Hansen. I don't want to jump around too much, but I'm going in the order of where the state called their witnesses. So just walk with me through this journey of justice real quick. Just walk with me for a second. Detective Garrett arrived, pulled Mr. Payne out of the car, and started trying to administer CPR. Okay. He did a brief search of Mr. Payne's fanny pack. He did not see any weapons in there, but he did not search the vehicle at all. Okay? That's pretty much all he did. After this, fire and rescue arrived, and then Deputy Garrett says he maintained the crime scene. Just himself, just Deputy Garrett maintained the crime scene. He testified that he put up crime scene tape. He held the area around the car until homicide and forensics units arrived. Now, he was equipped with body camera footage, remember? Did you see if he maintained the area on that body camera footage that you saw? Where's the proof? Body camera's on. You on duty. You're working. See, the state is trying to cherry pick with you. They're picking to try to show you some things, to try to spoon feed you. You ever had Thanksgiving dinner that was so nasty that you had to sprinkle a little sugar on it to make it taste good? That's what this tastes like. That's what this is. No. Don't let them force feed you. If it's nasty, it's nasty. All right. Let's proceed. The state published the body-worn camera footage, and the footage did not reveal that he maintained this area around the car. In fact, there is no evidence that the area around the car was even secured or maintained free of contamination or free of manipulation. Also, Deputy Garrett candidly admitted that when he arrived on the scene, the passenger side door of that black Chevy sedan, that Malibu, was already open. Now, he initially testified that he believed Tara Walker was on the passenger side, but then he couldn't really say that because the door is already open. And I ask you again, where's the proof, right? Somebody gained access to the passenger compartment of the vehicle. That door was completely open. Tara did say at some point in her testimony that she went on the driver's side. I'll get to her testimony in a second. I'm just going to keep going down chronologically. But you know what else jumped out? And I hope you guys asked to watch that video again. If you listen closely to Deputy Garrett's body camera footage, Tara Walker is heard in the background saying, "Why am I here? Why am I here?" You said you was here because you was invited. Seemed more like a setup or something. What's going on? You know, Tara has a motive to not be honest in this situation, because you know what this is? When Mr. Dority arrived home and he approaches the vehicle that he was familiar with at one point, believing it to be Tara Walker, but unknown to him, a 6'8", 247-pound man steps out and in a threatening manner steps over to him and say, "I'll smoke you. What you want to do?" That's an aggravated assault with a weapon. That's a felony, a forcible felony. And if Tara Walker invited him over to do that, that means she conspired with Adreian Payne to commit a forcible felony of aggravated assault. Use reasonable inferences, ladies and gentlemen. So let's talk about Hannah Minor, the crime scene investigator. She, at the time of this incident, May 9th, 2022, she had only been employed, as a crime scene investigator for 4 months. She had just started January 2022. So she's 4 months in on the job, relatively inexperienced. And it technically shows, because the role of a crime scene investigator is to respond to the crime scenes, document the crime scenes with photos, notes, sometimes measurements, document evidence, collect evidence, process that evidence, package that evidence, forward that evidence to its final location, whether it's in a laboratory or evidence unit, and write reports of their involvement in those cases. And of course, they work in conjunction with law enforcement and detectives. This is her exact testimony, right? It's from my notes, right? But she failed to document and process, collect that knife. She didn't dust for prints. She testified that it can be done, and case by case it can be done. She didn't try to get any touch DNA. She testified that she can do that. It's case by case. So in a case like this, a homicide, an allegation, if someone died, that's not something where you think that's important to dust. She agreed that it can be a weapon. It is a weapon. But Tara is saying she's just been driving around with a kitchen knife for 4 months. A mother is not driving around with a kitchen knife on the front passenger side floorboard in plain view for 4 months. That's not believable. Well, one would hope or think. So May 9th, she was on call, crime scene investigator. Their office is short-staffed. They're only staffed to midnight, so any calls that come in after midnight goes to the on-call crime scene investigator, where they take the call from home. Miss Minor, investigator Minor, she didn't get notified till 4 a.m. This incident, Mr. Dority arrived at 1:30 in the morning, right? Do you remember the testimony of Tara Walker when she said her brother arrived at 2 a.m.? Follow this for a second. 1:30 in the morning, he gets home. 2 in the morning, Tara Walker's brother arrives. 3 in the morning, Tara Walker's father arrives. 4 in the morning, crime scene investigator is notified, and 5 in the morning, she arrives. 7 in the morning, Tara leaves with her car still at the scene. Crime scene investigator never took a picture of her car, never searched her car, didn't even know her car existed, although Tara was alleged to have been at the scene at the time of this incident. Nobody even took identification from her brother. What is her brother's name? Nobody knows. What kind of car he drive? Tara said a BMW. Crime scene contamination. You heard testimony from Mr. Dority that he's seen her go in the car and run, and she didn't come back out until she was talking to law enforcement, till law enforcement arrived. But what time did law enforcement arrive? The only person you heard from was Deputy Garrett. Where was the other officers, if any? And what time did they get there? How could you secure a crime scene? Where's the proof? It's akin to someone throwing rocks at a glass window, and when you come outside to confront them, they're hiding their hands. Where's the proof? This is serious. This is someone's life. The state wants you to believe that my client just comes out the house, guns blazing, just shooting at someone for no reason, in cold blood, without adequate provocation, without it being in fear, just willy-nilly. Use your common sense. That's not what happened. And it's not the defense's job to show you things that it's not even, it didn't happen. The video that the state showed you doesn't even show the actual, it doesn't show any body, any person in any frame. All you hear, it's a video of audio. It's a video of audio. They didn't, how about this, if this don't convince you? When when Mr. Dority testified and the defense rests, the state didn't even put on a rebuttal witness, no rebuttal evidence. They haven't rebutted self-defense. Their own case established self-defense, arguably. And after hearing from Mr. Dority, who refuted that? Tara wasn't there when he first encountered Mr. Payne. Now, I imagine what may be troubling you guys is that there was actually no gun found in the car. But it's a reasonable explanation for that. You know why there was no gun found? Because the gun that he had was removed. Either by Tara, her brother, or somebody.
Objection, facts not in evidence.
That's a reasonable inference. Overruled. You are allowed to make reasonable inferences based on the facts. That's her job, to collect and document the knife. It was still in the car, not taken in evidence at all. You didn't even have a chance to see it today. I couldn't present it to you. It was not taken into evidence. That's not fair. The state can strike hard blows, but they can commit fouls now. Mr. Payne's girlfriend, her car was on the scene. It was never searched, no picture taken or anything. Investigator Minor agreed that she did not document the vehicle. She wouldn't know what was inside the vehicle because she didn't document the vehicle. And she agreed that part of her duties were to collect evidence, and she failed to document or collect evidence. This means this was an incomplete investigation, insufficient investigation. Marco Quintana, the neighbor, had that Google Nest camera. He didn't see what happened. The actual altercation didn't occur in video, but you just had the audio. He basically just provided them with audio. Not much value to the case at all, other than just at least allowing you to see that an actual argument did happen. You can hear that something happened outside, and then you hear the gunshot. Mind you, Mr. Dority only fired one shot. It's not like he unloaded a clip. He shot to repel the threat. He didn't shoot to kill. He didn't ask for what happened. Even in the state's opening, he says that Tara Walker speaks with her boyfriend, and he decides to come over to the residence as backup. Backup? Backup for what? I hope that you guys, you have to base this case on the facts that you heard in court, not anything external. This is the case. The facts are the facts. And they didn't meet their burden. They didn't. Tara Walker says that Tatiana Mesa texted her and said, "Meet me at the house in 15 minutes. Did she meet you? Where was it? There was no meeting. It's not right, ladies and gentlemen. You are empowered with the ability to give us justice here today. Justice demands not guilty. His actions were justified. When you go through this jury instruction and look at the justifiable use of deadly force instruction, all those elements are met. It's like, think about this. The elements, you think about elements of any type of crime or any type of rule of law. Think about a peanut butter and jelly sandwich, right? You got peanut butter, jelly, and bread. If you're only presented with bread and peanut butter with no jelly, then guess what? It's not a peanut butter and jelly sandwich. It's missing a necessary element. This is a very simple case. Very simple. getting back to some of the comments, Mr. Payne, instead of leaving, pulls his car up closer to the home and gets back out of the car. Mr. Dority again questions, why are you here? You need to leave. You can't really hear much of the conversation. Like, it's muffled. It did happen relatively quickly. It happened relatively quickly, you know. And you can see in that video that my client's son was very, very close in the vicinity to this situation. And it was not until Mr. Payne reached in a threatening manner as if he can pull. It just goes back to Dr. Hansen, right? Let's talk about her for a second. She has 35 years of experience. 35 years since 1990. She did maybe 250 to 300 autopsies a year for 35 years. And she testified that the trajectory of the bullet wound that Mr. Payne was inflicted with pierced the tissue of his bicep. Mr. Femur twisted, it just pierced it, and then it went into his chest cavity. But it's consistent with this movement. Thumb down, arms raised. How is this not consistent with someone trying to aim a firearm at you if you're left-handed? The testimony is he was left-handed. You can absolutely aim a gun. And I apologize if I'm aiming at you like this, but I really need you to see this. A gun can be aimed like this. This is consistent. And just because the gun wasn't located, but you have a reasonable explanation for that. I can see if you didn't have that. I can see if the crime scene was not contaminated. I can see when law enforcement arrived, the passenger side door wasn't open, wide open. I can understand it if Miss Tara Walker's brother did not arrive at 2 a.m. before law enforcement did. Or at around the time of, had to be before, because he wasn't documented. Was he invited over? Who invited him? Sounds like an ambush. Seems like an ambush. That's a reasonable inference that can be made. Nonetheless, Mr. Dority reasonably believed that Mr. Payne had a firearm on his person. And there is a strong inference that there was. Either Tara's brother left with the gun, or Tara left with the gun, or the gun was left in her car, or her father took the gun. The crime scene was contaminated before law enforcement arrived there. Tara's testimony should be taken with a grain of salt at best. She didn't even want to acknowledge the fact that Mr. Payne arrived on scene before she did. Vacillating between that. Evasive. You remember when I asked her on cross-examination? Before Mr. Lawrence Dority walked away and went into his home, he actually asked Mr. Payne, why are you here? Right? Tara Walker says, I can't recall if he said that. Can't recall. How convenient for you not to be able to recall that fact, but you can remember everything else, like the selective amnesia, when a fact is not a fact in your favor. Come on. Reasonable doubt. Come on. How's this justice? How's this fair? Where's the integrity of this prosecution? Remember, the state had the burden to overcome. Remember that. There is so much wrong with this. The integrity of this prosecution cannot be established beyond a reasonable doubt. The state tried to impeach Mr. Dority about what he said to police, but they failed to show you the interrogation video.
Objection. Halliburton equally available for defense.
Sustained.
The burden is not on us. Did you hear that? The state wants us to provide you with evidence when it's their job to do that. You got to hold that against them. Throwing rocks at a glass window, hide your hands.
Judge, can we approach?
Yep.
Oh, doesn't like that. He doesn't like. He didn't like that analogy. He didn't like that. I wish I knew these lawyers' names. Unfortunately, I don't. But defense is saying it's up. The state is wanting. The state is saying that he's saying the state wants the defense to provide evidence. Yeah, I don't know why they didn't. He's bringing up a few good points. Trust me, I'm not buying it, but I'm just saying he is bringing up a few good points about why would she be driving around with a knife for 4 months in the front seat? I thought that was kind of interesting. Why didn't we hear from Tara, the woman who called, texted them to come over? Why didn't we hear from them? Why didn't we see the interrogation video? I think they're valid points. Again, is that going to sway the jury? I don't know. Would it sway you guys? But I do think those are some valid points. I hear they come back.
Remember, it's their burden, ladies and gentlemen. Literally, this is a homicide investigation. What kind of investigation was this? This case is literally about who do you believe at this point. It's literally Lawrence Dority versus Tara Walker. No other witness brought any value to this case, ladies and gentlemen. Crime scene investigator didn't collect evidence. She admitted that to you. Maybe due to relatively inexperienced tenure of being a crime scene investigator, but it's not to talk bad about her. She's very educated, obviously. But the state has utterly failed to prove that Mr. Dority did not act in self-defense. This appears to be some sort of rush to judgment here. Some sense, that's what this was. Ladies and gentlemen, Mr. Dority has exercised his constitutional right to a jury trial. And we truly believe you will make the right decision here today. Justice requires a finding of not guilty. He acted in self-defense of himself, his son, his father, given the darkness of the night, 1:30 in the morning, the size difference. He cooperated with law enforcement. Why was Mr. Payne there? Why was Tara Walker even there? This was a setup. Why didn't they leave? Mr. Dority was not intoxicated. There's no evidence of this. Mr. Dority's father drove him home because Mr. Dority's vehicle was in his own driveway. How else would he get home? Walk with his minor son at 1:30 in the morning? We're not challenging whether the firearm was functional or not. So FDLE testimony from Ms. Kristen Killinger, not an issue. Mr. Dority testified at 1:30 in the morning. He, his father, and his son was on the way home. As they arrived home, Lawrence sees a car parked in the corner of his home, and he automatically assumed it was Tara. So he thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. So Lawrence walks over and to greet her, to say, hey, or inquire, why are you parked here? Mr. Payne gets out the car. And when he gets out, he's looking down at Lawrence. He has his hand in his waistband. Lawrence could see something silver sticking out on the side of his hip with his hand on it. And Lawrence asks him, what are you doing here? Mr. Payne replies, this is the words from my notes. He actually said, I'm not playing with you, I'll smoke you. That's what he said. I'm not playing with you, I'll smoke you. Lawrence replied by saying, what? He threw his hands up in the air, started freaking out. Lawrence's dad rolls down the window and asks, is everything okay? Lawrence replied, I don't know. He goes into the home, retrieves his firearm so he could safely get his son in the house. So he returns outside and sees Mr. Payne has moved his car up even closer, and he's gotten back out of the car again. At this point, what What do? It's dark. You have no duty to retreat, first of all. If it's troubling you that he didn't remain in the house and go hide in the closet and get on the cell phone and call the police, he's not required to do that. He's protecting his castle. He's protecting his son. He's worried about his father. Why are you here? Can you please leave? Mr. Dority is 5'8", 145 pounds, had no relationship or affiliation with Payne. Lawrence did not invite Payne over. Out of all the 15 years he known Tara, he had only met that man maybe twice. One time at some girlfriend's mother Thanksgiving or something like that, he showed up unannounced. And he couldn't even recall the other time he met him. Lawrence went back in his house because he felt like his life was threatened. The jury instructions, the law in the state of Florida supports self-defense in this case. This is one for the books. You have the ability to send a message.
Objection, improper asking of a jury to send a message.
Sustained.
Ladies and gentlemen, we trust you will render justice and make the best decision, one that is fair, one that justice requires. Lawrence was just trying to go home. Lawrence didn't know what Mr. Payne's mental state or his motives. He knew what was going on.
Counsel, your 45 minutes that you imposed on yourself is up. You need to wrap it up. You started at 9:55. It's 10:40.
Thank you, Your Honor. Ladies and gentlemen, we trusted you would do your job today and find Mr. Dority not guilty, because that's what justice requires. There was no rebuttable evidence. Not guilty. Thank you.
State wish to give its rebuttal?
Yes, Your Honor. Just a moment to set up. I don't need the lights off just yet. I gotta get the lights set up. Thanks. So one of the first things that opposing counsel said in their closing argument was that you should use your common sense. And the state wholeheartedly agrees with that. Use your common sense. We don't ask anybody to check their common sense at the door. The facts in this case, if you look at it using your common sense, you'll see that this defendant wasn't acting like a reasonably prudent person. Now, opposing counsel stated correctly, the state has a high burden in this case. We have a burden of proving this case beyond a reasonable doubt. And that's our burden in every criminal case. Same as a murder case versus a driver's license case, it's the same burden. When we were in jury selection, we obviously hadn't met that burden. The question was asked, I believe somebody, if you had to give a verdict right now, what would it be? Obviously, you heard no evidence, be not guilty. Opening statements aren't evidence. So anything you heard after opening statement, if you had to give a verdict at that point and deliberate, it should be not guilty. But as evidence comes out in this case, that cloak of innocence is stripped away and has been stripped away from this defendant in this case. And with the evidence that's here and the evidence that you heard on that stand, he now sits before you a proven guilty man. So, we do have to meet the elements in this case. And opposing counsel talked about a peanut butter and jelly sandwich, right? So, have a peanut butter and jelly sandwich, you got to have the bread, you got to have the peanut butter, and you got to have the jelly. Those are the three elements. So, a pretty good analogy to the elements in this case. For manslaughter, there's just, the two elements that we talked about, then the three elements for second-degree murder. And that's what we've got to prove. We've got to prove each of those elements beyond a reasonable doubt. But opposing counsel also said in his argument that if you have any questions or any questions about any of the facts in the case, then that's a reason to find the defendant not guilty. That's not true. That's not correct. We have to prove the elements beyond a reasonable doubt. But if you're going back there and you're wondering, well, I have a question whether the victim's car was gray or black. I don't think the state established that. Well, that's not an element. We don't have to prove that. So if you have a question of whether the car was gray or black or something like that that's not an element, that shouldn't influence your verdict. We have to prove the elements beyond a reasonable doubt, and we've done that here. We've made the peanut butter and jelly sandwich, as opposing counsel talked about, because we've hit those three elements for second-degree murder. Opposing counsel talked about a text message that you didn't see the actual text message that Tara Walker, talked about. Okay, I mean, you can believe what you want. Obviously, weigh the credibility of the evidence, but she showed up there. You can use your inference, as opposing counsel said. Why was she there? Right? She said it was because she got a text message. All right, you can decide if that makes sense. Opposing counsel talked a lot about the crime scene being contaminated, but how? You didn't hear anything in the testimony, the evidence of how it was actually contaminated. They infer that somehow maybe, with no evidence, that the gun was present and was taken. But there was nothing that you heard. Nobody testified to that. None of the evidence you heard showed that. They talked about, Corporal Morris, the first person that arrived on scene. Yeah, he didn't search the vehicle because the first response was to try to save a life because of the actions of this defendant. And his priority at that moment wasn't to secure the vehicle that he was, right next to. And you can see, that he was there the entire time, that the defendant's father was there, that Tara Walker was there. And she was, by the way, hysterical this entire time. From the moment that this defendant shot the victim in this case, and she runs to the neighbor's house to when law enforcement responds, and you can see on Corporal Morris's body cam, she is hysterical. Is this a person that's in that moment just beside herself? She's gonna take a gun or something and try to hide it somewhere? Ladies and gentlemen, in your instruction, it talks about beyond a reasonable doubt, but it also talks about what's not beyond a reasonable doubt. It's not a possible doubt, imaginary of what could have happened to this gun that was never there, speculative, forced doubt. That's what that is. It's imaginary. It's speculative. Now, opposing counsel talked about the height difference between the defendant and the victim. And yes, the victim was tall. He was, 6'8". But this, and you can consider the relative height, but this wasn't a fist fight. This wasn't even something at the time that the shooting happened where they were in arm's reach of each other. It doesn't matter how tall you are when the other person has a gun. And yeah, if the victim and him were engaged in a fist fight, maybe he feels the need to bring a gun out to defend himself at that point. That's not what happened. That's not the facts of this case. So the fact that he's 6'8" doesn't have any bearing on whether his actions were reasonable. They weren't reasonable. Also, opposing counsel talked about, Adreian Payne should have left. Maybe he should have. None of us were there, but there's one person on trial today, and that is this defendant, not Adreian Payne. He's not here today because the defendant acted in the action that he did, and he killed him. That's why. Now, opposing counsel talked about the defendant's son and father being present, but the defendant even acknowledged in his own testimony, begrudgingly, that there were no threats made to his son, there were no threats made to his father. He wasn't protecting them from some sort of threat from the victim in this case. This is a point that I really wanted to address from opposing counsel's argument. He talks about, if you go back and you listen to the body cam from Corporal Morris, you'll hear Tara Walker say, "Why am I here?" It's not like, "Why am I here?" like this, and like that's some big conspiracy. I encourage you to listen to that body camera. She is hysterical, and she's standing there, and she's asking, "Why am I here as I watch the father of my child be murdered? Why am I here for that? Why am I living through that?" And there's one reason that she was, the defendant. Now, there's a lot talked about by opposing counsel about the knife, the kitchen knife that was found in the passenger seat of the vehicle. And why that wasn't collected. Well, this wasn't alleged to be a stabbing case. There was no allegation that anyone was stabbed or that the knife was used. Also, the defendant, in his testimony yesterday, got on the stand and said he saw this silver object. But when I asked him, "Did you say that in your interview with law enforcement?" "Well, I don't know. It'd been a while." This is right after it happened. He didn't say it then, but he said it yesterday. Why? Because he got to hear all the evidence in the case, and he got to craft his testimony in a way to try to make it seem justifiable what he did. But even by his own words, he couldn't quite wrap it around the requirements of the law. Because even by his own words, what he did was not justified. Now, opposing counsel is right that when he first had his words, or whatever the case was with the victim in this case, and he went in his house, he was not required to call 911. That's true. He's not required to do that. He's not required to cower or anything like that. But that doesn't mean that because he's not required to do that, that somehow that makes his actions justified. He has to meet the requirements of the law that we talked about previously, that his actions were something that a reasonably prudent person would do. Just because he didn't have to call 911 doesn't mean his actions of arming himself with a gun, coming out and shooting a person that's not in arm's reach of him, not on his property, not armed, is reasonable. So yeah, he didn't have to call the police, but he was not justified in doing what he did. So, opposing counsel talks about defending the castle, defending his home. Again, I want to emphasize to you that the victim in this case never set foot at his house, never knocked on his door, never stepped in his driveway, didn't park in his driveway, didn't park in front of his house, didn't step on his grass. He wasn't defending his castle. He saw a vehicle that he recognized. He went over there at 1:30 a.m., had the person roll the window down, and that's what started the engagement between the two. He did that. He's not defending his castle. And then he went back in, armed himself, and came back and shot the person in his car on the street. So he's guilty. Now I'm going to play for you the clip that shows the audio and then Tara Walker running afterwards. And you can hear for yourself. You can't see it, but the audio paints a picture. Don't pull your gun out. You were asked to come here. Pleading with it. Do not pull your gun out. Do not pull your gun out. You were asked to come here. Lawrence. Notice what you don't hear there. You don't hear anybody yelling, Adreian, put your gun away. Adreian, don't pull your gun out. Adreian, no. You know why you didn't hear that? Because he was the aggressor. He's the one that pulled his gun out. He was the only person making a threat, and he's the person that's guilty of second-degree murder. The state asks that you find him guilty as charged, and you find all of the firearms enhancements that are on the verdict form that you're going to get. Thank you.
All right, ladies and gentlemen, we'll resume with the remainder of the jury's instructions beginning on page 13, starting with rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think that I prefer one verdict over another. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. and I will go over with them with you at this time. The first one is the actual verdict, and then there are 4 special findings that you'll have to make with respect to the firearm. Okay? Each of them has a caption. That's the top portion, and it just indicates that it's the case of the state of Florida versus Lawrence Alexander Dority. It has the charge, the division number, which is assigned to this courtroom, and the case number that's assigned to it, and then it indicates that it is in the Ninth Circuit here in Orange County. The verdict form gives you 3 options. The first option is we, the jury, find the defendant guilty of second-degree murder as charged in the information. The second option is we, the jury, find the defendant guilty of the lesser included offense of manslaughter. And the third option is we, the jury, find the defendant not guilty. The bottom portion of all the forms is the same. It says, "So say we all," dated at Orlando, Orange County, Florida, on this blank day of July 2025, and there is a place for the foreperson to sign. When you all have reached your verdict, whoever your foreperson is that you've elected needs to do 3 things on the verdict form for me. You need to check one of the 3 options: guilty of second-degree murder, guilty of manslaughter, or not guilty, one of those 3. You need to make sure that you fill in the date, and you need to make sure that you sign the verdict form, okay? You'll need to make sure that you do all 3 of those things, otherwise the verdict form is not complete. If you don't do those things and you come back and I see that the verdict form is not complete, I'm required to send you back in the jury room, and I can't tell you why I'm sending you back in the jury room. So I'm telling you why now, okay? So just make sure we get those 3 things done. In the event that there is a verdict on either second-degree murder or manslaughter, then you have to do the special findings. If you find him not guilty, then you don't need to make any special findings, okay? The special findings, there are 4 of them. The first special finding says that if you find the defendant guilty of second-degree murder, you then must answer this question. We, the jury, find the defendant did, during the commission of the crime, actually possess a firearm. The second option is we, the jury, find that the defendant did not, during the commission of the crime, actually possess a firearm. So special finding number 1 is only required if there's a manslaughter, if there's a second-degree murder verdict from you all, okay? And so then on this special finding, you would do the same thing. You would select either he did possess a firearm or he did not possess a firearm. Make sure the foreperson dates it and signs it, okay? The second special finding also applies only to a verdict for second-degree murder, and it says that if you find the defendant guilty of second-degree murder, you must then answer the following question. And there's 2 options. We, the jury, find the defendant did, during the commission of the crime, discharge a firearm. Second option is we, the jury, find the defendant did not, during the commission of the crime, discharge a firearm. As you did with the other verdict forms, the foreperson will select one of those 2 options, date it, and sign it. And then the third special finding also applies only to the second-degree murder verdict, if there is one. And it says that if you find the defendant guilty of second-degree murder, then you must answer the following question. And again, you have 2 options. We, the jury, find the defendant did, during the commission of the crime, due to the discharge of a firearm, cause death to Adreian Payne. And the second option is we, the jury, find the defendant did not, during the commission of the crime, due to the discharge of a firearm, cause death to Adreian Payne. As you did with the other ones, you would select one of those 2 options, date it, and sign it. And then the last 4th special finding applies to a verdict of second-degree murder or manslaughter. So if you have any verdict on those 2 charges or those 2 counts, that count or the lesser included, then you would have to do this finding. And it says if you find the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The 2 options are we, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. Second option is we, the jury, do not find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. As with all the other forms, the foreperson will select one of those 2 options, date it, and then sign it. Once you have properly dated and signed and filled out the options for all of the verdict forms that are required, knock on the door, let us know that you've reached a verdict, and we'll bring you in to take it at that time, okay? Now, in just a few minutes, you will be taken to the jury room by the court deputy. The first thing that you all should do is choose a foreperson who will preside over your deliberations. The forepersons should see to it that your deliberations are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring the verdict forms back to the courtroom when you retire or when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You're not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have had cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. The deputies, and it cut off, the deputies will collect them before you go in. They'll give them back to you when you get out. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I'm going to talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The majority of these exhibits will be sent to you with you into the jury room when you begin to deliberate. The exceptions to that are, obviously, we're not sending a firearm back into the jury room. If you would like to see the firearm, write me a note saying that you'd like to do that. We'll bring you back in and we can show you the firearm. Okay. The other exceptions, do you have a device that is approved?
I do.
To go back into the jury room? Have you confirmed it?
I have not
Assuming the parties are in agreement, then we can send back a computer that doesn't have access to the internet or anything to allow you to do research. It'll simply allow you to play the videos that have been placed into evidence. If that's the case, then I can send those back into the jury room with you. So I just need to know from you all.
Judge, the laptop does need to be plugged in to work. It's an older laptop.
Okay. So it doesn't have a battery either, so you got to old school plug it in the wall. Okay. All right. Any objections?
No objections.
All right. So all the other evidence will go back with you so that you can take your time, use the computer that's provided to review the exhibits that require the use of the computer. The only exception is I'm going to leave the firearm in here. If you want to see it, let me know by sending me a note. Okay. All right, in closing, let me remind you that it is important that you are to follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Any objections to the jury instructions as read by the state?
None from the state, Your Honor.
Defense?
No, Your Honor. Thank you.
All right. We had 2 of you that were selected as alternates. So if those 2 of you would remain seated, the remaining 6 of you can go back and deliberate your verdict at this point.
Not sure why the audio cut out.
You were our alternates. We select alternates in the event somebody gets sick. Everybody else is healthy, so this will conclude your all's jury service. If you 2 will just remain seated there, I'll give you some further instructions. The remaining 6 of you at this time may take your notes in the jury instructions and head back to the jury room to deliberate. And they've already gotten their orders. Okay, thank you. All right.
All right.
Go ahead and hand them these. All right, go ahead and have a seat. All right, gentlemen, you all were selected, as I indicated, as the alternates in the case. Whenever we have a case that's going to go more than a day or 2, we will select alternates because life happens, things happen. Had somebody had an illness, a family emergency or something, and they had to be replaced, one of the 2 of you would have been asked to step in. Fortunately, it looks like the remaining 6 jurors are all healthy, and so they will be doing the deliberations in the case. I know that jury service is an inconvenience. I know that it is an imposition on your time, but it is a very important part of our system of justice and a very important part of American citizenship. And for giving of your time the last 2 or 3 days, I do wish to sincerely thank you. You will not be called for jury service for at least another year, if that's any solace for you. But with that said, this will conclude your jury service. Do either of the 2 of you need an excuse for the last 3 days? Okay. If you could generate one, I'll have the clerk generate that. You already got it? Yep. All right. So she's already generated it for you. With that said, with my sincere thanks, you are excused from jury service at this time. Okay. Have both the state and defense agreed to all the evidence the deputy's taken back?
State's in agreement.
Okay. All right, go ahead and have a seat. All right, Mr. Dority, you have been present for the entire trial, correct?
Yes, sir.
All right. And you've had an opportunity to provide your input to your attorney at all the important stages and the various stages of this trial? All right. And I know we've talked about them, but we've talked about the witnesses that were called. We talked about the jurors that were picked. We talked about some of the strategy that you and your attorney have made during the course of this proceeding. Have you been satisfied with your attorney's representation of you? All right. Has he done everything that you wanted him to do? Was there anything that he didn't do that you wanted him to do? All right. So is it fair to say at this point that you're completely satisfied with his services? Okay. Anything further from the state at this point?
Nothing further from the state.
Defense? All right. We will be in recess at this point pending a question or a verdict. If you're going to leave, just ask that you give your cell phone number to the trial clerk so that we have ability to get a hold of you and that you remain within 10 or 15 minutes of the courthouse so that we can get you here, okay? All right, we'll be in recess.
All right, so we are in verdict watch. We are officially in verdict watch. But what's this? Something happens here. So let's see, how long were they? Is it a question or is it the verdict? Let's see here. 2:30. 3:30 is an hour. The 4 hour and a half. Looks about an hour. Looks like about an hour and a half. Do not spoil this for anybody. No spoilers, no spoilers, no spoilers. No spoilers, please. No spoilers. All right, I'm going to fast forward because something happened. Oop. What's this? Something happened here.
All right, go back on the record. This is on State of Florida versus Lawrence Dority. Jury is out. The jury has provided a question. The question indicates, can we be provided with the time the officer, and then in parentheses, Morris, arrived to the scene, and it is signed and dated by the foreperson. I'll leave for the record, both the state defense and Mr. Dority are present. My notes indicate that there was some indication that that time was at 1:30. I've asked the court reporter to find that section of the testimony in the transcript for a readback. She has that prepared. My intent would be to have them call in or have them brought in, have that question and answer read to them, and send them back out.
No objection from the state.
No objection. Okay. Then let's go ahead and bring the jurors back in.
So we have a jury question. Can we be provided with the time law enforcement arrived at the scene?
All right, ladies and gentlemen, I did receive a question from you all that indicates that you want to be provided with the time the officer, I believe that was Corporal Morris, who testified first, arrived at the scene, and it is signed and dated by the foreperson. You have to rely upon the evidence that was provided during the trial. I did have the court reporter locate that information in the transcript, and so she's going to read to you as part of a readback the question and the answer as it relates to that question. Okay?
Question, and did you have occasion on that day around 1:30 a.m. to respond to 1529 District Forest Drive in Orlando? Answer, yes, I did.
All right, that's the only evidence that we have that was provided as it relates from Corporal Morris that's responsive to the question, okay? All right, so you're free to go back and continue your deliberations at this time. All right, go ahead, have a seat. All right, we will be in recess again until such time as we have a question or a verdict. Again, remain within 10 to 15 minutes walk or return to the courtroom. All right, thank you all.
Thank you.
It's not a boutonniere. I think it's like a little handkerchief, if you will. Yeah, it's not a boutonniere he's got in his pocket there. It's a little handkerchief. All right, Broken BB, how long has this trial been? Yesterday and today, so we're doing, we did day one earlier, and now we're doing day two. All right, so let's see what this next break is over here. Here we are again.
Dority's present. I've been advised. All right, we're back on the record. I'll note that both parties are present. Mr. Doherty's present. I've been advised that the jury has reached a verdict. So let's go ahead and bring the jurors back in. All right, go ahead and have a seat. State recognize the presence of the jury?
Yes, Your Honor.
Defense recognize the presence of the jury?
Yes, Your Honor.
All right, has the jury reached a unanimous verdict? Yes. All right, if you'll go ahead and hand the verdict forms to the court deputy for me. All right, the verdict forms are in order. Madam Clerk, if you'll go ahead and please read the verdict.
In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, the state of Florida versus Lawrence Dority, case number 2022, CF 5250. Verdict as to count 1. We, the jury, find the defendant guilty of second-degree murder as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 30th day of July. Full person. Special finding as to count 1. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, actually possess a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the full person. Special finding as to count 1. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, discharge a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the full person. Special finding, if you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, due to the discharge of a firearm, cause the death to Adreian Payne. Special finding, if you found a defendant guilty of second-degree murder or manslaughter, lesser included the crime, you must then answer the following question. We, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the full person.
Either party wish to have the jury polled?
The state does not.
Defense does, Your Honor.
Madam Clerk, if you'll poll the jurors for me, please.
Juror number 902, is this your true and accurate verdict? Is this your true and accurate verdict? Juror number 558, is this your true and accurate verdict? Juror number 206, is this your true and accurate verdict? Juror number 4217, is this your true and accurate verdict? Juror number 484, is this your true and accurate verdict?
Yes.
Juror number 693, is this your true and accurate verdict? Thank you.
All right, ladies and gentlemen, I have one final instruction for you, and that is your instruction upon discharge. I do wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that you enjoy as jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their own private affairs as long as they wish it. Therefore, the law gives each of you a unique privilege not to speak about your jury's work. Although you are at liberty to speak with anyone, you are also at liberty to refuse to speak to anyone. A request may come from those who are simply curious or from those who may seek to find fault with you, and it'll be up to each one of you individually to decide whether you wish to discuss your jury work with anyone or not, okay? I know that it's been a couple of days and it's been an inconvenience to you to come over here and give of your time, but it is very important to our system of justice and very important part of being an American citizen that we have jurors like you come in and decide these cases for us. For your time here the last 3 days, I do thank you for the efforts that you have put in and the work that you have done. If any of you all need an excuse for work, we will generate that for you that indicates that you have been here for the last 3 days. With that said, that will conclude your jury service in this case. With our sincere thanks, you should not get another summons for at least 1 year from today's date, okay? All right, thank you. All right, Spencer. All right, have a seat.
Say the Florida word.
All right, is there any legal reason why we can't proceed to sentencing at this point?
Your Honor, I don't know if the defense is asking for a PSI or asking for a sentencing date.
Is he entitled to a pre-sentence investigation?
He's not a convicted felon.
He has a prior dealing in stolen property that he's on probation for?
I'm not sure if he's adjudicated guilty.
I looked at it. He's a withhold adjudication.
I understand it was a plea of no contest and it was a withhold of adjudication. Have you all reviewed Florida Statutes 921.231?
Not recently, Your Honor. Let's do that now.
Nine 21.31 subsection 1 with respect to pre-sentence investigation reports says that any circuit court of the state when the defendant in a criminal case has been found guilty or has entered a plea of nolo contendere or guilty, so a nolo plea previously would count as a conviction, may refer the case to a Department of Corrections for a pre-sentence investigation. So a nolo plea previously doesn't entitle him to a pre-sentence investigation. The state objection to their request?
I don't have an objection, Your Honor. It's in your discretion.
And the defense is requesting one?
Yes, Your Honor.
What I'll do is I'll go ahead and request the PSI so I can get some additional information. How much time do they normally take for those? 30 days?
30 days.
All right, I'll go ahead and order a PSI at this point. We'll set sentencing for August 29th, which is a Friday, at 11 a.m. In the meantime, Mr. Doherty will be remanded to the custody of the Orange County Sheriff's Office pending sentencing. Further from the state?
Nothing further from the state.
Defense?
No, Your Honor. Thank you, Judge.
All right, we'll be in recess.
All right, so sentencing is August 29th, which is a Friday. That's that. Quick trial. All right, here, check it out. So I wanted, Shore Life, this is for you. So you heard them, that woman cry out. We'll stay here for a minute. So she's not happy, obviously. I wonder if she's the one that cried out. Okay, that's Adreian Payne's girlfriend, mother of his child. They had one child. So they got justice for Adreian. It's a shame because she knew Lawrence for like 15 years. You know, she knew this guy. You know, it's not like he did this. They didn't know him. You know, they knew him. Adreian didn't know them, but she knew Lawrence for, I think she said 15 years. That's a long time to know somebody. Then he goes and shoots your boyfriend. So, all right, so they started deliberating. Let's say they started deliberating around 2:30, right? So 2:30, and they came back with a verdict. 3:30, that's 1 hour. They came back with a verdict at 4. So it's like 90 minutes. Like Ed was saying, basically, yep, 90 minutes. So, all right, you guys, that's going to conclude it here. Joanne, sentencing is going to be August 29th. Sentencing is August 29th. So August 29th is sentencing. So if they stream it, we'll show it. But yep, that seems to be it. That looks like that's it. So August 29th sentencing. All right, one thing, we're going to bounce over to Ali, but I want to look up, let's look up, I would love to see, and I don't want to get in trouble. I'm going to try and find something. I want to see if I can find him playing basketball. We got to be careful because we can't play anything too much because we'll get hammered if we play. All right, maybe here. Maybe this we can. Okay, here we go. All right, I want to play this. I want to see him in action. So here's this guy in action. This is what I wanted to show you guys. This is a news report, so we will not get in trouble for this. Let's check this out.
Well,
all right, so this is a news report. This is Adreian Payne in no problem, Alexa. All right, so this is Adreian Payne in action.
hug your loved ones just a little bit tighter tonight, because we never know what we're going to be saying our last goodbye. The Michigan State basketball community knows that all too well tonight as the Spartans are mourning the loss of former MSU forward Adreian Payne, who was killed this morning in a shooting in Orlando. He was only 31 years old. During his playing days at MSU from 2010 to 2014, Payne was a dominant force to be reckoned with in East Lansing, and in his senior year, he averaged 16 points and 7 rebounds a game. He was an all Big Ten second-team selection and then scored 41 points, which is the most NCAA tournament points by a Spartan in program history. Tom Izzo attended the introductory press conference of MSU hockey's new head coach, Adam Nightingale. Izzo did not take the podium or meet with the media, but he did release this statement shortly after, saying, quote, "I am in shock at the tragic news of Adreian Payne's death. Our prayers are with his family, teammates, and loved ones," end quote. Izzo went on to say that today is a difficult and sad day for the Spartan basketball family, and he's heard from several former players who praised Payne's ability to work with Spartan players even after graduating from MSU. Some of those former players like Miles Bridges and teammates of Payne's like Gary Harris and Denzel Valentine shared on Twitter their condolences after hearing the news. Magic Johnson even shared that he and his wife Cookie are heartbroken. Then Draymond Green, who played with Payne for 2 years at MSU, shared a tweet with broken hearts. Draymond's head coach Steve Kerr started his afternoon press conference with some words on the passing of Adreian Payne.
I want to offer condolences to Adreian Payne and his family, Michigan State family, Tom Izzo. We heard the news this morning, and Draymond is just crushed. And Adreian and Draymond were teammates, and best of friends, and just devastating news today. So our condolences to the family, and we're thinking about them today, just feeling a lot of grief with everybody involved. And Draymond especially is feeling that way. And so wanted to share that before we start.
So I know a lot of you may not know sports. And so Draymond Green plays for Golden State Warriors. He's won like four championships for the Warriors out there, 4 or 5, whatever it is. Clearly, and Steve Kerr was the coach. So, yeah, Adreian Payne scored the most points ever in Michigan State University history. That's pretty amazing. In the NCAA tournament, that's pretty amazing. It's pretty amazing. So there you have it. Adreian Payne, no longer with us. Sad. Yeah, he played it. I wish I could play you some of this other stuff, but it's like Big Ten Network. Oh, maybe here, this is it. Oh, here we go. This will be a good one. This is going to make you guys cry. I'm sorry. I don't mean to make you guys cry, but this is going to probably make you guys cry.
He was a star for the Spartans.
Spoiler alert, this is probably going to make you guys cry. So I can tell I'm going to cry already.
He was a star for the Spartans from 2010 to 2014. He also gained national attention for his bond with Lacey Holsworth, a young girl battling cancer. Adreian Payne was shot and killed early this morning in Orlando. Pamela Osborne live tonight following the very latest information from police down in Florida. Pamela.
Karen, police are saying they have that shooter in custody. Still, so many questions remain at this hour about what led up to the shooting death of Adreian Payne.
Payne slashing in and dunking it down.
Adreian Payne, a first-round NBA draft pick and Star Center standout at Michigan State University, was shot and killed in Orlando this morning. Investigators say the first call came in just after 1:30. When they arrived on scene, they found Payne injured. He was taken to the hospital where he was pronounced dead. Payne, who played for the Spartans from 2010 to 2014, warmed hearts all across the country. His senior year, his special relationship with Lacey Holsworth, an 8-year-old cancer patient who he met 2 years earlier during a hospital visit, was on display that winning season. The Orange County Sheriff's Department hasn't released much information except to say the shooter, a man by the name of Lawrence Dority, remained on the scene, was taken into custody and placed under arrest for first-degree murder. Adreian Payne was 31 years old. And within the last hour, Tom Izzo released a statement expressing his shock and sadness. It reads in part, Adreian was loved by his teammates and coaches who respected his development as a player and a person. He goes on to say that today is an incredibly difficult day for Spartans and that Adreian would actually go back to East Lansing to develop relationships with the players that came after him. Reporting live tonight, I'm Pamela Osborne, Local 4.
Tough one. All right, Pamela.
A remarkable relationship we want.
All right, I don't know if my mic was on. I said I don't want to, make you guys upset or whatever, but I just want to honor this guy because he seems like a really cool dude,
To share with you a college basketball star and a little girl. He is leading his team into March Madness tonight into the Sweet 16. She is battling a rare and advanced form of cancer, and through it all, they are best friends.
On the court, he is as talented and as fierce a player as any in the madness of March in the heart of the Michigan State Spartans. While off the court, Adreian Payne is almost 7 feet of gentle giant. sprung from a storybook.
He's just a really nice brother, and I like it when he picks me up. It just makes me feel happy and safe.
8-year-old Lacey Holsworth has another name for him, though.
Superman. Because he flies high, he dunks, and he busts down walls. And he's my Superman.
And to Payne, she is Princess Lacey.
I love her, and I wouldn't want anything to happen to her. She's always going to be a part of my life.
Their unlikely friendship began 2 years ago when Lacey was diagnosed with neuroblastoma, a form of childhood cancer that attacks the nervous system. Payne and his team visited her in the hospital.
Adreian playing with her and stuff was the first time she really, truly smiled and I think felt a little bit of joy.
She is certainly his biggest little fan.
She always texts me and, wish me luck and tell me to get some dunks and shoot some three-pointers for her.
And he's become a fixture in the Holsworth home.
We like to play games together, and we like to color and stuff, and I make him brownies.
It's just her brother, just as if he just walked into our family that day and stayed.
Payne's coach Tom Izzo described the bond of player and princess in an interview with The Journey on the Big Ten Network.
This past year, she was back in the hospital, and I knew he was a little down about it, and things were looking kind of not very good. And so I said, "Hey, P, I'll go down there with you." And we were on our way down there, and he wanted to get her something. He bought her this stuffed animal.
When I came in, I was just, terrified, what's going on.
As I sat there, watched AP, I was sitting on the bed with her, and the mother kept saying AP, and she turned, and her eyes opened for the first time in a couple days, I guess. And it was just like her world was better.
At Payne's senior night ceremony, Lacey was his special guest.
I'd like to thank Lacey's family, and everybody for coming out and supporting me, and just praying for Lacey because she's going through some hard times.
And on March 16th, Payne would lead the Spartans to the Big Ten tournament title and give Lacey the honor of helping to cut down the net.
That was fun.
You ever been that high?
I don't think so.
I'm going to be sad that he's leaving, proud of him as a player, and maybe even prouder of him as a person.
Good luck, I love you.
Me too.
Lacey's family has raised more than $30,000 of its $50,000 goal. 71 days to go. And if you want to find out more about the effort to help her, you can go to our website.
All right. That's that. That hit me a little bit harder than I thought. All right, guys. With that, we'll say goodbye. Thank you for watching. Can't get it together. I'll just say thank you to our mods. Thank you to Aaron. Thank you for watching. And we have a redirect to go over to the Alley trial. So I'll see you guys over there.